overflowing on us. You drop it, then pick it up. I think I'm falling in love, but shawty, this isn't what you probably thinking it was. It's a vibe out, pulling in for the weekend and such. You gon' find out once you come on and bring me that up. Keep coming with it. Keep coming with it. Keep coming with it. Place your bets on us. Get your money and flip it, yeah. Keep coming with it. Keep coming with it. Keep coming with it. Place your bets on us. Get your money and flip it.
All right, welcome to the Sarah Boone stream. This is clearly not Sarah Boone content yet. I had some tech issues. It's not going to stop me. It may have stopped you from showing up early, but you guys will find me. I figure in about the same time it takes me to find myself. Maybe I should send a message in the old group. Launched a new stream. There's 27 of them in the other room. I think it's just a matter of time. Okay, there's people here. Oh, you know what? I should post the link to my new stream. Yeah, that would be smart. Troubleshooting. Okay, copy it. Big fuck yous to everyone. Welcome to the stream. I think I passed the 30-second mark. Slight tech difficulties, but we'll be fine. Got a treat for you when it comes time to watch the charging conference. We're going to focus in a little bit more on some yoga in the background, and we'll still listen, but... Alright, looks like a few of us have found it. This is going to be our main view, especially when there's a transcript to read, but... That said, there will be no transcripts for the first 3 hours because the jury's gone. They're just going to talk, so it's going to be a little easier on me. Get rid of that flashing. Okay. Okay, you guys ready for a morning? I'm ready. At the end of this song, we'll get her started. Grab your medical snacks. Find your way here. It's going to be like an 8.5 hour stream. And that's if I don't go crazy with commentary. But we're not going to leave without the end of the rebuttal argument. We'll do jury instructions. We'll do verdict. We'll do verdict watch. We'll do sentencing. We'll do all that next week. Today is going to be charging conference, state rebuttal. We'll stop dancing with the dogs. We'll turn off the music. And get to our regularly scheduled courtroom broadcast. Thank you for joining the stream. I'll say hi to you in the chat. Looks like enough of you have found where we are, so let's get started without any further ado. Oh, there'll be a tiny bit more ado. Just one sec. We'll have our main character, Sarah Boone, led into the courtroom in chains, shackled and chained for the final time of this trial. Wearing her white blouse with grayish black blazer. It's got a bit of a chiffon ruffled collar. I'm noticing that her hair, like, you know, obviously it's, you know, low-hanging fruit to make fun of her hair. The back of it looks like it's been layered on with that silly string.
Madam Clerk, I'm ready.
Courtroom audio picks up.
Catatouri on behalf of the state. William J. for the state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Ms. Boone, raise your right hand to be sworn, please. Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ma'am, good morning. Can you please state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
Ms. Boone is seated at counsel's table wearing a light gray suit and a white blouse. She is in custody, however, will not be wearing any restraints. As such, we will continue to stand when our jury enters and exits. We're here for a charging conference. The court has reviewed, I believe, both parties' red lines as to the jury instructions, including, I believe, that was submitted last night, the defense's red line as to the jury instructions that were provided by the court. Let's try to get as much done as we can until our jury arrives. I believe what we had discussed yesterday was starting at the beginning and moving through as quickly as possible.
Just for context, this is 8 a.m. on the 24th of October, is it? Let me just quickly. 25th of October, 8 a.m. They've come in early to try and take care of some charging conference. We skipped this when we were watching the rebuttal arguments because it would have been kind of a non sequitur in between that, but we're going to keep all the charging conference together, so we will skip by the rebuttal arguments when we get to that after the first hour. But yeah, they've just come in early to get a head start on this, and then there's about 2 more hours of it after Mr. J finishes his rebuttal argument.
We get to the real meat of some of the issues in the 3.6F and the 3.6G instructions. Mr. J?
May I remain seated during the charge conference?
Yes, sir, you may. Thank you. All right.
Good thing to ask. The other thing is, while there is no sidebars during the charging conference, there's a number of times of audio dropouts and whatnot. I'm going to do my best to allow it to play in real time and then maybe just read afterwards, like to follow up when people are quiet. So kind of echoing it like Garrett Morris on the news for the Hard of Hearing on Saturday Night Live back in the Chevy Chase days.
I have in my hand a 34-page document that was emailed to the court last night by counsel for the defense at 12:06 a.m. from Lauren Henderson. That's what the court's going to be relying on. Does everyone have that in front of them?
Yes, sir.
Defense.
Right off the bat, it's already not going fast. Defense, you were the ones who prepared this. What do you mean you don't have it?
Basis, yes, Judge, I do.
Okay, all right, let's start on page 1 of 34, 3.1, Introduction to Final Instructions. Any objection to the form of this instruction? State.
Now I'm confused. I don't know that I have a 34-page document from them last night. There was an attachment. There was an email at 12:06.
Hang on, let me make sure.
So much for trying to get a head start there, Mr. Granick.
G separate red lines, 8.9 culpable negligence red lines separates.
Give me a moment. Then it was what was sent at 11:31 yesterday.
That 34-page document I have.
Okay.
Oh, 31. I don't know if it's 34. It says 31 to me.
I have it as 34.
You can see why I've tried to set up a secondary source of interest on the page during the charging conference. A lot of page flipping and low stakes discussion. In red is Assistant State Attorney Dave Catatouri.
Excuse me, Judge.
Yes, sir.
Can I have Ms. Henderson explain how she sent the document?
Fine by me.
So now Lauren's going to have to explain it because Mr. J doesn't know where it is.
Good morning, 11:30, I sent the red line instructions from the defense based off the document you had sent to us yesterday morning. And then last night, we approached and I had asked if that format was okay for you. And I believe Mr. J had said, could the defense send separate 3.6, 3.F, so it'd be easy to incorporate in your final instruction.
And that's what was sent at 12:05 last
Yes,
night?
sir.
All right,
Just for more convenience for you.
understood, okay.
Thank you.
But the balance of the instructions, because that just addresses those.
I'm sorry, what was that?
What you just advised only speaks to the 3.6, 3.6G instructions.
And F and culpable negligence.
Correct.
Yes, sir.
Okay, all right. So I'm talking about the balance of the instructions that may or may not be at issue.
Yes, sir. That was the balance of instructions that are not at issue. Those are what was sent at 11:30.
Okay, all right.
My confusion is, the court is indicating they have a 34-page document.
Yes, sir.
I have a 31-page document that was emailed to us by Ms. Henderson at 11:32 in the morning.
Are you looking at October 24 at 11:31 a.m.? Subject, defense proposed jury instructions in red line format?
I'm sorry, Mr.
No worries. I'm looking at the email correspondence of October 24, 2024, 11:31 a.m. Subject, defense proposed jury instructions in red line format. Is it possible that you don't have your track changes are off, and maybe that's why? That's the difference?
Where the track changes, please?
In Word, under review, or I can just have Madam Clerk print out 2 more copies. And we could just work our way through that.
But track changes for everyone is still only 31 pages.
Okay. I just forwarded to Madam Clerk. I'm gonna have her print out 2 copies. That way we've got hard copies, so we seem to be all on the same page.
Yes, Ketty, Mr. Catatouri teaches yoga in his spare time. And now we're all going to be the benefactors of his spare time because it's going to be a lot of spare time during this charging conference. So just kick back, do what you'd ordinarily do during a trial stream, but realize it's fairly low stakes. The most important thing that we're getting right now is some of the jury instruction stuff comes up on appeal. So when that happens, I'll try and pay attention and say, hey, gather round. Interesting part. But in the meantime, Mr. Catatouri and his butt-eating shorts, team of 4 students, just a nice, easy, relaxing way to start your day. Morning, Mandy. Welcome to the stream. Good morning, Barbecue Queen. I can zoom on the Sarah cam as well. Indoor camper makes a good suggestion. Let's see what I can do with that. So slow. I think it was Phil who pointed out in an earlier day of watching that you can count how many lights are on the courthouse roof by looking at Mr. Henderson's head. Good morning, Suze. What? You know what? I'm going to do a few stretches too. It's been, I just finished an hour of the morning radio Nada show, so follow Mr. Catatouri's lead here. Still doing it. on pause, for Christ's sake. Can't do it that long. I'm not sure this is his house. This feels like it's one of those kind of rental houses, and maybe he rents it out for his, yoga class. But I first was exposed to this content on a Suma stream, and they did a lot of micro analysis of the background and stuff. There's like I think 2 barbecues. So it looks like it's like maybe a B&B rental house kind of thing. And hey, Beth the Salesman, welcome. Punchable Baby Heads here. That's a good question. Punchable Baby Face says, I wonder what Owens does in his spare time and what his stream would be. So if we were watching something, I feel like Owens would be out riding one of those swamp boats with a big fan on the back of it, hunting gators or something. Just him and a guy playing banjo. See, this is the difficulty with doing. I knew that if we did this during the stream last week, it would be like, what the hell? Like, we're doing this now in the middle of the rebuttal? In the morning, you guys a little bit more understanding, court starts slow, so. But I want this to be a comprehensive feed, so somebody who wants to say, I've watched every second of the trial, you don't want me skipping through it just because I've seen it or I'm bored. It's there for you. You can skip it if you're bored. You can watch it on replay. Watch what you like. Yeah, I could picture there's Indoor Camper says it would be a good old boy stream. Words of wisdom. Yeah, I could see him and somebody sitting out on a porch drinking liquor out of a jar with one of those little tiny handles for big, huge jar. Look how he holds a pose. Like, that's no body movement, no sway. That's great form, Mr. Catatouri. Reach to the sky. Oh, that would be fun. Let me see if I can find a passage from Hamlet. Beth of a Salesman would like to hear James Owens reading Hamlet. All right, Hamlet is a 144-page PDF. LZB sent out another gift membership and celebrated her own membership anniversary. This membership has gone to
Both
Sudi.
parties have what was provided to the court yesterday, a 34-page document, which includes the defense's red line with regard to the proposed jury instructions. We'll start on page 1 of 34. Instruction 3.1, Introduction to Final Instructions. Any objection to the form of this instruction state?
No, Your Honor.
Defense?
No, Your Honor.
Moving to page 2 of 34, Instruction 3.2, Statement of the Charge. State?
No objection.
To
Defense.
be,
Moving to page
Your
3
Honor.
of 34,
Can I have a
7.1,
second?
Introduction to Homicide. Those
B.
3 paragraphs, any objection?
No objection from the state.
No objection.
Moving to the next portion, Justifiable Homicide in the singular paragraph. Any objection, state?
No objection.
Defense?
No objection.
Moving to excusable homicide and the 4 paragraphs, including paragraphs numbered 1, 2, and 3.
Now that they're getting stuff done, I'll just give a little context. So these are just agreements to what jury instructions will be read. It's mostly cut and dry. If you're charging with X, then you read Y. If you're charging with A, then you read B. There's going to be some discussion over, well, this is a self-defense case, or, the mitigating factors in whatever case. Do we read, instructions A, B, and C, or just A and C? So that's what most of the discussions are. Right now, there's a lot of stuff that they've mutually agreed on because there's nothing to argue about. So that's what they're getting through right now, if it sounds like a lot of stuff's happening.
No objection. I have no objection to anything I submitted to the court.
Okay, thank you. Defense?
No objection.
Moving to page 434, 7.4, second-degree murder instruction.
Morning, Kathy.
Defense, any objection to the form of the instruction?
No objection.
And also the removal of the lesser-included chart on page 5 of 34, correct?
Correct.
Kathy
Moving
Callie
to
also
page 6 of
celebrating
34,
membership.
instruction 3.4, when there are lesser-included crimes or attempts. My only question is, if I understand from the defense, they're looking to see culpable negligence is a lesser-included.
Yes, Your Honor.
Would that not need to be included here?
Yes.
If you guys are bringing up, I see something about a golf pencil and talking about the stupid little pen Sarah has to use. I think it's today in the trial, she starts using pens she's not allowed to use. I think she knows that, what's going to happen. But I'm sure I see her with a clickable purple ballpoint pen, as well as possibly a Sharpie later. So she's using contraband pens by day 6. If you notice it, call it out.
Okay, so is the only addition to this, the balance of the 3.4 instruction would be correct with the exception of the last sentence, which would read, the lesser crimes, plural, indicated in the definition of second-degree murder is manslaughter and followed by culpable negligence.
Yes, so it should go to R. Yes.
State?
State objects. There's no evidence to support a misdemeanor culpable negligence lesser included offense for a category 2 lesser to be included in the jury instructions. They both must be supported by the charging instrument as well as the evidence in the case. There's no evidence in this case that he only suffered culpable negligence. The crime for culpable negligence with death is manslaughter. Culpable negligence isn't even a category 1 lesser of manslaughter, it's a category 2 lesser, which includes, by inference, there must be some evidence that her culpable negligence did not result in death.
Charles Greaves asks if Sarah's hair is a
What's your
lesser
response
included
to that?
crime.
Judge, the instruction that we're asking for is 8.9. It reads to prove the crime of culpable negligence. The state must prove the following 2 elements beyond a reasonable doubt. 1, Sarah Boone exposed George Torres Jr. to personal injury. And 2, she did so through culpable negligence.
Yes, she did.
As to the fact that there is evidence of culpable negligence as to the case, and the fact that Ms. Boone, while Mr. Torres is still in the suitcase, goes upstairs. As to it being charged, it's a category 2 lesser included that's available to the defense. Defense can get category 2 lesser included offenses as long as there's evidence to support the category 2. And there is evidence in this case to support the category 2 lesser included. That's
And
why we're asking.
any other further argument, Mr. J?
No, Your Honor, thank you.
Okay, all right. At this point in time, the court is inclined to include the culpable negligence as a lesser included. We'll get to the instruction momentarily. Any other revisions to the 3.4 instruction, defense?
No, Your Honor.
Moving now to 7.7 manslaughter, there are some objections. The defense is now objecting to paragraph 2C, the death of George Torres was caused by the culpable negligence of Sarah Boone. So So how could you ask for a culpable negligence instruction and then object to 2C in the manslaughter instruction? Logically having trouble understanding that.
Yeah, I'm going to go full screen on this because this is a brilliant little moment. We'll just let Dave, you can pick up with Mr. Catatouri where he left off, but you'll see the screen grab right here. And we'll go back about 10 seconds, but look at Mr. J just looking over, because however Judge Kranick put it, and I don't know enough about the law, it sounded a little snarky, and looking at Mr. J's like, yeah, do tell Mr. Henderson, how can you object to one and want the other? Go back about 10 seconds from that. Maybe 15. There we go. But pay attention, Mr. J.
C, the death of George Torres was caused by the culpable negligence of Sarah Boone. So how could you ask for a culpable negligence instruction and then object to 2C in the manslaughter instruction? Logically having trouble understanding that.
Because this is my argument, because I'm not arguing that there isn't evidence of it, because I just said there's evidence of culpable negligence. The difference is, and I think the burden is different from the state, because it's not alleged in their information.
Does not the instruction say give 2A, 2B, and or 2C depending upon allegations and proof?
Yes.
There is a Mr. J emoji. I added some new emojis last
Any
night.
response, Mr. J?
Judge, it's a category 1 lesser. All the theories are included in that. The language does not need to be included in the charging instrument. And quite frankly, it's not inconsistent with the language in the charging instrument. She's accused of having a depraved mind when killing him, and what the evidence has also shown is that she was heavily intoxicated when she made this decision. That supports a conclusion for a trier of fact to reach that this was out of culpable negligence, and if they reject our argument that it was done knowingly and out of hatred, ill will, spite, etc.
Any other argument, sir?
No other argument.
At this point in time, the court is going to overrule the defense's objection as to the objection to 2C in the manslaughter instruction, including the final 2 paragraphs of what the definition of culpable negligence is on the bottom of page 7 of 34. It seems like it's stipulated between the parties that 2B, Sarah Boone intentionally procured an act that caused the death of George Boone, should be George Torres, is not applicable. Is that correct, State? Is that correct, defense? Okay, thank you. And also, since 2B is not applicable, the to procure definition will not be provided. Any other questions regarding the 7.7 instruction?
No, sir.
No, Your Honor.
No objection to what they suggest is the definition of culpable negligence as the court's indicated.
With regard to the
Second lesser?
second lesser? Yeah, thank you.
No objection to that proposed instruction.
All right, very good. Thank you very much. What is the instruction number for the culpable negligence instruction? I think it's 8.9, isn't it?
8.9.
Okay, thank you very much. Moving now to page 10 of 34, 3.6D, voluntary intoxication. Does this now need to address culpable negligence? Or is that only?
No, yeah, we would request to add it, the culpable negligence, since it's going to be given. So it should read second-degree murder, comma, manslaughter, comma, or culpable negligence.
You're talking in the last sentence, correct? Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence,
Yes,
correct?
Your Honor.
Thank you. Any objection,
No,
defense?
I agree.
Thank you.
Oh, what a rogue and peasant slave am I.
Do we want to take an attempt to address the 3.6F?
I would suggest we do that later and see if we can just get
Is it not
3.6.
monstrous?
At this time, just going to make a note
Work on that.
that we're going to bypass the 3.6F instruction and 3.6G instruction. That'll take us all the way to page 23 of 34. Instruction 3.7, plea of not guilty, reasonable doubt, and burden of proof. Any objection to the form of this instruction, defense?
No objection.
Moving now to page 24 of 34. Weighing the evidence, 3.9 instruction.
Should we go to 3.7, be not guilty?
Did I skip it?
Yes, sir, page 23 of 34.
I'm sorry, I thought that's what we just covered, Mr. J. I apologize.
Oh, I was just making sure that there was no edits that either the court made or the defense made, so I was scrolling, but no objection to 3.7.
Okay, thank you. Moving now to page 24 of 34, 3.9, weighing the evidence. Looks like give as applicable paragraphs 6, 7, 9, and 10 have been struck. Is that acceptable? State.
Yes, Your Honor, I agree that 8, the inconsistent statement instruction, should get bumped up to 6.
Agreed.
And the remainder should not be read.
With those revisions, is that instruction 3.9 acceptable to the defense?
Yes, Your Honor.
Moving now to page 25 of 34, the latter portion of the 3.9 instruction. Any objection to the language contained on this page? State.
No, sir.
Defense?
No, Your Honor.
Moving now, the 3.9A instruction was struck by virtue of Ms. Boone testifying in this matter, so that need not be addressed. The 3.9B defendant's statement instruction also included the requested language by the state. Is there any objection to the form of this instruction at this time? Defense?
No, Your Honor.
Okay, Ms. Boone, earlier this week, and I can't recall if it was yesterday or the day before, the state had filed a motion seeking to add additional language to this instruction. And I had read that language to you at that time. Do you want me to read it again to you this morning?
Yes, please.
Okay, so I'm going to read you the entire 3.9B instruction.
This is good.
3.9B defendant statements
Not really.
reads, a
But
statement
she just wants him
claimed
to
to have
read
been
it. Yes,
made
please.
by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1, whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get him to make it. That should be revised to the feminine. Any objection?
No, Your Honor.
Defense?
No, Your Honor.
That is the form instruction created by the Florida Supreme Court, ma'am. What has been added is the next paragraph, which reads, law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. Similar to other conversations we've had this past week, ma'am, I don't want to know about specifics of any conversations that you had with you and your attorneys, just simply whether or not those conversations have been had. Did you and your lawyers discuss the proposed language that I just read to you?
Yes.
Do you have any questions with regard to that proposed language?
No.
Are you in agreement with this additional language being added to this defense?
Yes.
All right, thank you, or to this instruction, rather. Thank you. The last sentence read, if you conclude the defendant's out-of-court statement, was not freely and voluntarily made, you should disregard it. Any other clarifications to that instruction state?
No, Your Honor, thank you.
Defense?
Judge, in looking at it, it says in the final part, consider whether the defendant's statements, can we replace and put whether Sarah Boone's statements?
Where are we specifically, sir?
In the state special that I have no objection to, it says, this is however one of the factors you may consider whether the defendant's statements, if we could have Sarah Boone.
Hey, Peter, glad to see you here.
voluntarily made.
Peter's been enjoying the shorts and just starting to get into the long form dandy content.
I tend to agree with the state on that.
Okay.
Indoor camper says, what does conclude
Rule
mean, please?
3.10.
If you don't
I'm sorry,
mind,
Instruction
please.
3.10, rules for deliberation, page 28 of 34. Looks like the parties agree that paragraph 7 is not applicable.
Yes, sir.
I agree.
All right, that would change paragraph 8 to 7. Any other revisions to 3.10? Defense?
None from the defense.
Moving to 3.11, cautionary instruction. Defense?
No objection.
The court then interlineated on page 30,
Hey,
the
Seba.
2.7 closing argument form instruction. Any objection to that instruction, state?
No, Your Honor.
Defense?
No, Your Honor.
Moving now to 3.12 verdict instruction, page 31 of 34, state?
No objection.
Defense?
Defense.
No objection.
Moving now to 32 of 34, instruction 3.13, submitting case to jury. The only other question I have for the parties is with regard to, I believe it was Exhibit A, the suitcase. Are we going to send that back, or is that going to be viewable upon writing similar to the baseball bat?
No reason that it can't be sent back.
Okay, agreed?
Agree.
Okay, all right. Is this instruction acceptable to the state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Very
Thank you
good.
for the glowing endorsement, Peter.
And then moving to, that concludes the, except for the 3.6F and 3.6G instruction, that includes the verdict, or the instructions. I'll have Anita clean that up and send it to the parties so that we have a cleaner red line to work with. The only other question that I think we can address this morning is the verdict form. I received the defense's verdict form, and it looks like manslaughter is no longer being sought in the verdict form. Manslaughter was struck out, and it was just culpable negligence.
That's a great point, Phil.
Yes.
Right.
I hope the court
So
goes
how do we want to address the verdict form then? Because if we're giving instructions on manslaughter, certainly needs to be included in the verdict form.
Going to take a quick break to comment on Phil's comment in chat. Imagine how mad Sarah is when she saw Courtney Clenny's sentence. I think Courtney Clenny is a pretty despicable person herself. So not a fan, not an only fan, that's for sure. But not a fan. Regardless, I do like the idea of her going there and rubbing that plea deal in Sarah's face every day. Like, oh my God, you're like one of those old women that's going to be here forever. Forever. No, I don't want to talk to you. I'm talking to the people who are getting out. Thanks. I took the plea.
I understand, Judge, but the defense isn't requesting manslaughter, but if it's instructed, it has to be in the verdict.
So the verdict form would read, we, the jury, find the defendant guilty of murder in the second degree as charged in the information. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant guilty of the lesser included offense of culpable negligence. We, the jury, find the defendant not guilty. Is that acceptable to the state?
I like Mitch Hedberg
Is that
too.
acceptable to the defense?
Yes, Your
All
Honor.
right. Similarly, I'll have Ms. Barrios make those revisions and submit them to the parties as soon as possible. Anything else, state, we need to address before? Bruce, do we have everybody as of this time? Everybody's here? Thank you, sir. Other than the 3.6 instructions and the state's request for other instructions, which
So
I
they're
think
getting the jury back, just so you know, we're not going to watch that part, even though it's probably more interesting than this, because we did watch the rest of the rebuttal last week. So once the jury comes back in, we're going to skip to the rest of this charging conference, and then we'll get to the meat and potatoes, or the steak and McPotatoes of the stream, with the closing arguments before we shut her down.
to table for now.
Yes, sir.
Are we prepared to go ahead and bring in our jury at this time?
Only thing I want to bring to the board and the defendant's attention was
Mitch Hedberg says, I used to like Mitch Hedberg. I still do, but I used to too.
at lunch, there was some sort of domestic violence event out in the quad. A coworker indicated that without believing it was any particular jurors.
Hey,
in this
K to
case,
Zed's here.
that he did see people with juror badges in and about the area, so I don't know if that warrants inquiry.
Sorry, one more interruption, but K to Zed recently did a live stream reaction to Chelsea and Haley, who you may remember from one of my streams as the Drunk Sisters. And one is worse than the other. There's a shoulder dislocation, a couple of handcuff slips, lot of begging and pleading. Just say you're sorry and you wish him well. You'll save $3,000. Just say I'm sorry and I wish you well. Anyway, K to Z did a reaction to that, and I'm thinking about reacting to K to Z's reaction to that as part of a Friday Night Ramble, reacting to random and not so random live streams. So I'm thinking about starting with K to Z's, then maybe watching the one with me and Cowboy where everything went to shit, because it's more fun to watch it retroactively than when I was in the shit. So then we'll do that, and then we'll just skip around. Whoever's got live streams going, we'll just pop in for 5 minutes of their live stream, see what it's about. And that might be how the ramble goes tonight. But last interruption for now.
Defense?
I think it should be mentioned.
I agree.
Okay.
I agree.
Just to see,
Sure.
we spent all this time, we've got a bunch of alternates. Let's utilize them, but I do have an issue.
Yes. What do we got?
Let's utilize them.
I think the state attorney, the last piece of evidence is they've extracted from Sarah Boone's phone a bunch of pages of text messages. And I believe their intent is to introduce all those text messages, which are quite a few, but I think they want to read specifically out a few to the jury. My only concern is I don't know which ones they're going to read out, and under the rule of completeness, if there's a thread where it needs to be put in context, we would ask that all of that be read. So
Good morning, Vel.
Mr. J, any response?
It's going back with them, just like I told them during some of the body-worn cameras. Only some of it's published, it's all going to be there for them to use. I do not intend on reading all 108 pages. I don't intend on trying to delineate what contextually is one conversation from the other. I think it's just fair to say this is all going back with you. You're going to have a scrub laptop. You're going to be able to view it all.
Okay. Mr. Owens, you can make any objections you deem necessary at the time, and we'll address it. Because it's just hard for me to say what should or should not be. I understand the state's position, but if it's something that's you believe in the rule of completeness should be provided at that time, regardless of it going back, we'll address it.
It's going to be about 40 minutes worth of reading text messages. Are we going to have some people come in to read the messages?
Again, I'm not sure how long it's going to take. I did not practice reading what I'm going to be reading in the mirror. Number two, no, I don't understand why a witness would be called. It's in evidence. The lawyers can now publish them.
Anything further, Mr. Owens? Okay, all right.
Not on that issue. I would like to take like 5 minutes to use the bathroom.
Sure, we can do that. Okay, so I don't want to highlight that it was a domestic violence event. So are the parties, is it acceptable to the parties to inquire of if anyone heard or participated, got any information, or observed anything of the event that transpired yesterday afternoon in the courtyard? Is that acceptable?
Yeah, you definitely shouldn't suggest what it was.
Agreed. Okay, got a thumbs up from Mr. Owens. All right, we'll take a 10-minute recess. We'll just plan on bringing back here at 9:30. We'll bring the jury in at that time. Thank you all very much.
All right, so we will skip past that break and move right into the rest of the charging conference, and then I promise we'll get to something more interesting. But that's charging conference, jury state rebuttal, outside jury presence. We might need a touch of outside jury presence here. I always like to see Sarah get brought in. Oh no, she's just sitting at the table.
Of everything from the revisions that we made. This morning. Let's go ahead and bring back in our jury. And I agree with Mr. Owens. I'd rather.
Can we go back? Disney Mom is asking what happened in the courtyard. So we'll go to that quick little thing. Basically, as the jury was leaving the trial, I think yesterday in their time, so October 24th, there was a domestic violence rally in the courtyard. And one juror was aware of it, and another one, that juror thought was aware of it, but didn't I don't know. Here it is. Here's the part where they basically questioned, did you pick up any pamphlets, anything like that?
County Courthouse. Just again, if you could raise those hands, confirm you complied with the court's instructions. All right, all hands have been raised. Thank you very much. Members of the jury, before the state, yesterday they were with their evidence presentation. Today, I just have a couple of questions to go over with you.
Hey, A to B.
Yesterday there was an event in the courtyard of the Orange County Courthouse. Did anyone happen to observe that event? If you did, please raise your hands at this time.
What do you mean by observed?
We'll get to it.
Okay.
Okay. Did anyone happen to hear anything during that event? All right, and record reflects no hands have been raised. Did anyone see anything during that event? All right, juror number 2, first row. Thank you, ma'am. Did anyone participate in that event? Record reflect no hands have been raised. Did anyone receive any writings or review any material from that event? Record reflect no one has raised their hands. Can the parties approach for a moment?
Oh, Jesus, I wasn't ready for this. Okay. Well, I'll find the transcript, but I know that this part is not a big deal. They're just basically talking about, like, you know, what do you want me to ask them? Are you okay if I ask the one individually, or should we send them all outside? And yeah, send them all outside. I think it was, we'll get to that.
All right. Members of the jury, I'm going to send everyone out except for juror number 2 in the first row. We've got a couple follow-up questions for you individually, ma'am. Same instruction I've given you all previously. Please don't conduct any independent investigation or research as to the person, places, things, or charge involved, and don't have any discussions amongst yourselves or anyone else, and we'll bring you back in as promptly as possible. Thank you.
Hey, Mrs. Woodbridge, welcome to the stream.
You all may be seated. Thank you. Juror in seat 2 on the first row from right to left.
Pickle
You
Spoon,
had
good to see you.
advised, based on the court's question, that you had observed something, and you said, what does observed means? And instead of getting that out in front of every other juror, we just want to have that individual conversation with you now. So tell me what it is that you saw or heard or anything yesterday in the courtyard yesterday.
When we were walking back from lunch, and we saw that they were gathered, and I asked the deputy if he knew what was going on, and he said it was somebody Bain talking about domestic violence.
Okay. And you said we were walking. Who's we?
Another juror. I don't want to say her name.
Okay. All right.
Detec-
Is that a juror that was on our panel here?
Detective
Okay,
Crane, it
all right.
figures
Do
it
you
out.
recall where they may have been seated?
No, in the back over there.
Okay. All right. Do you recall what color her hair was?
Yes.
What,
Would you like me to tell you?
Please.
Dark brown or black?
Is it the shorter juror? Okay, thank you very much. State, any further questions?
Not only is Judge Kranick an excellent judge, he would have been fantastic at Guess Who. He took like 4 questions to figure it out. Glasses, beard.
And after you were told what was going on, then what happened?
I walked back in.
All right. Did you hear any of the speakers?
I
or-
couldn't hear anything. No.
And so what's happening here is the both sides get to question, like, hey, were you influenced? And the fact that they have 8 alternates on their 14-person panel, there's every reason for them just to do, you know, the exploratory conversations of, you know, okay, well, if you talk to, you know, the head of the thing while you're serving on a jury, maybe you've been corrupted and no longer able to serve, but it ends up being nothing. But still, it's good to watch the process.
Anything further from the defense?
Ma'am, did that affect your ability to be fair and impartial?
What is going on? See, look at her hair. It looks like it was sprayed on with silly string. Beth of a Salesman pointed out it looks like somebody in the front row may have coughed and not covered their mouth, and that's the result on the back of Sarah's head. I think it looks like it's been sprayed on like a helmet that, you know, it started with like just almost like, what was that Ron Popeil spray on hair? Where if you had a little bald spot on the back, you just spray it on and no one could tell the difference on TV with non-high definition televisions at the time. You tried it at home and it would just like melting in the sun. Not that I tried it. I'm still, lots going on up there.
Parties approach for a moment.
parties approach. Oh, what are they talking about? I think this is where they're basically okay with it. Any further inquiry? Mr. J says, no, sir. Any problems with this juror? Mr. J says, no. Court says, do we need anything else with regard to the panel? The other shorter juror might have better hearing, so maybe ask her. Mr. Owens says, I don't think it's Mr. Owens, I don't think it's necessary. She didn't raise her hand, so she must not have considered anything.
Thank you so much. We're going to go ahead and bring in the balance of the panel. You can just hang out where you're at, okay?
Okay, so he didn't complain even. So that's the panel coming in, but we're not going to watch the rebuttal. So we'll go back to... Yeah, Ron Popeil hairspray. You guys remember the ads. And if you order now, you'll get the Steta Ginsu steak knives. You can cut through a tomato or a soda can. How often do you have to cut through a soda can after a tomato? Always coming up in my household. Does anyone have to go to the bathroom?
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? All right, thank you. Y'all can be seated.
How about now?
Members of the jury number 2 in the back, he's ready. He gets it. All right, can you raise those hands one more time for me? All right, record reflect, hands have been raised as compliance with regard to the court's instructions. Members of the jury, all the evidence and testimony sought to be provided by the state and the defense have been provided to us over the last week. At this point in time, the state and the defense and I need to discuss the law to be given to you in instructions. That's going to take a little bit of time. So we're going to go ahead and excuse you at this point in time for a longer lunch break than what you've had previously. And we're going to ask you to come back here at 1:30. At that point in time, the court will begin to instruct you on the law that you are to apply in this case. Then the parties will begin with their closing arguments. The state will go first, then the defense. Then the state will have the opportunity to rebut any of the defense's arguments. After hearing the closing arguments, the court will provide you final instructions before releasing you to deliberate in this matter. We may work past 9 o'clock tonight. We may go late into the evening. So if there are any plans...
And yeah, just for context, they showed up early today to get work done on the charging conference, but this is also the deliberations day. So if you remember from watching the trial, they do come back the same day. They eat dinner first, but they don't take too much time after dinner to come back with a verdict. We're not going to be watching the verdict today. We're not going to be watching the jury instructions leading up to the verdict. That's all going to be next week's show. But we will be watching the closing arguments from both sides in completion.
Or things that you need to reach out to, as we discussed last week during jury selection, that we could work till late as 9, and we may work later than that this evening. If there's anyone that has any concerns as to working that late, please raise your hands at this time. Court sees no hands. I would also ask of you, if you could, please reach out to any family members or friends to, one, advise them that you're on the jury and will be deliberating this evening. And if there's any accommodations or issues with minor children or family that need to be taken care of, I would ask you that you take care of that during our lunch break.
And the emergency phone number, since they won't have phones.
Yes, we will provide you. The court deputy will provide you the emergency phone number when we get back from lunch so that you can provide that during a break that we'll have this afternoon to any friends or family or loved ones if they need to get in contact with you. I will give you a similar instruction that I've given you over the last couple of days. I know you're probably tired of it, but I got to give it to you one more time. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not...
There's a question in the chat over how the trial would have went if Sarah was pro se, and I know if she was pro se, she would have She would have fought a lot harder for her snacks motion, I'll tell you that.
Anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face to face, you must not talk about this case by using an electronic device. You must not you must not use phones, computers, or electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I thank you for your attentiveness, service, and sacrifice, and we'll see you at 1:30. Juror number 2 in the back. Yes, sir.
Question. So
Answer.
with the parking, we're going to be here for some time. Can we leave and come back and get restamped with a new thing? Or must 3 hour long?
We will have you that answer when we come back.
Okay.
Madam Clerk's going to figure that out for you.
Okay.
All right, thank you very much.
I got to guess that was Juror 3. He sounded bold and, yeah, just guessing, but that sounded like the voice of a Juror 3 to me.
Can we exit each?
Yeah.
Yeah, now we've got about 2 more hours of charging conference before the lunch break. Yeah, almost exactly 2 hours.
Okay.
We'll switch back to the double
Could you do that
yoga
also?
view.
Oh,
I've also-
I've been advised by, you know what, rather than double speak, could you just tell me what it was, say it for the record what it
If
was?
judges approve that they are to go on campus or out of the courthouse garage, they can come back and get new stamps, cards, and everything.
So they can leave this point during lunchtime.
Then I'll
It's
approve
just
that.
about the parking passes.
State, anything else we got to discuss, other than the jury instructions? Defense?
No, you.
Okay, court's going to run upstairs, put the finishing touches on what we agreed to this morning. I'll bring back paper copies for everyone, and then we can continue the charging conference. At that time, court's going to be in a short recess. We'll be back as promptly as possible. Thank you.
Thank you, Judge.
All right, so I'm going to try a reading of Hamlet. This is going to be James Owens reading Hamlet from from Act 2, Scene 2, probably the final monologue leading into Act 3. Oh, what a rogue and peasant slave am I? Is it not monstrous of this player here, but in a fiction, in a dream of passion, could force his soul to be his own counsel? That her working at all this visage wand, tears in his eyes, distraction in his aspect, broken voice, and his whole function suiting with forms to his counsel, and all for nothing, for Hecuba. What's Hecuba to him, or he to Hecuba, that he should weep for her? What would he do? Had he the motive and the cue for the passion that I have? He would drown the stage with tears and cleave the general car with horrid speech. Make mad guilty and appeal the free. Confound the ignorant and amaze indeed the very faculties of eyes and ears. Yet I, a dull, muddy, meddled rascal, a peak like a John of Dreams, unpregnant of my cause, I can say nothing, so not for a king, upon whose property and most dear life a damn defeat was made. Am I a coward? Who calls me a villain, breaks my paid across, plucks off my beard and blows at my face, tweaks me by the nose? Who gives me the lie? The throat is as deep as the lungs. Who does me this? Ha! Swounds. I should take it, for it cannot be. But I am some pigeon livered and like galled and make oppression bitter. Ere this, I fatted all the region kites with this slave's awful, bloody, bawdy villain, remorseless, treacherous, lecherous, kindless villain. Oh, vengeance! Why, what an ass am I? This is most brave that I, son of a dear father, murdered, prompted by revenge, by heaven and hell. Must, like a whore, unpack my heart with words and fall a cursing like a very drab, a stallion, a fee-upon foe about my brains. I've heard that guilty creatures sitting at a play have, by the very cunning of a scene, been stuck to the wall, that presently they have proclaimed their malefactions. For murder, though it have no tongue, will speak with miraculous organ. I have these players play something like the murder of my father before mine uncle. I observe his looks. I'll tempt him to the quick. If he do blench, I know my course. The spirit that I have seen may be a devil, and the devil hath power. I assume it was a pleasing shape, yes, and perhaps, out of my weakness and melancholy, as he's very potent with such spirits, abuses me and damn me. I've the grounds, relative than this, to play's the thing, wherein I'll catch the conscience of the king. That was James Owens reading Hamlet, end of Act 2. Skip ahead to the charging conference.
Of each page, I have paper. Defense. Let me get appearances for the state.
Dave Catatouri on behalf of the state. William J. for the state.
Defense.
Tony Henderson for Sarah Boone.
Kevin Mack on behalf of Sarah Boone, Your Honor.
Okay. Where might Mr. Owens be?
Judge, Mr. Owens is doing some preparation. I am handling
Okay.
For the record, the previous Owens reading was not part of the official transcript. That was a reading from Hamlet, the play. If it sounded as completely what? There's a word I'm looking for. Side saddle? Cattywampus to the facts of the case. It's because it had nothing to do with the facts of the case, which made it probably sound exactly like Owen advocating on Sarah's behalf. He very well could have just got up and read Hamlet for 15 minutes and got the exact same reactions out of everyone. And what's the legal basis for your objection? Your Honor, Hamlet.
If the state and the defense can approach, I have paper copies of the revised jury instruction. You'll see on the bottom of each page is a file and path name. That's just for my own edification of where I've stored them, so then we make additional changes. The revisions that we discussed earlier today have already been made. There's still a couple cleanups that I need to do just to get rid of the formatting items, but all the revisions that we spoke about this morning have been included. With that, I think that takes us to page 9 of 28 in the 3.6F instruction. I also have the defendant's revised portions as to 3.6. Just for the court's clarification is
I'm going to leave you guys with the charging conference for a
page
few
9 of
moments. I'll be
28
back.
of what was
Gonna make a
provided to the
snack.
parties. Is that the same as the separate defense 3.6F instruction?
Yes, Your Honor, it was only provided for more convenience for you to copy and paste them in.
Got it. Okay, so should we be relying on the 3.6F instruction you, Ms. Henderson, sent last night?
Yes, sir.
Okay, all right. State, do you have that?
I have a digital copy of mine.
Okay, all right. Tell me when you have it pulled up in front of you, sir, and then we'll...
It's pulled up, and I had sent everybody the state's digital copy as well.
Okay, very good. All right. Let me pull up the digital copy that I have. Give me a moment.
Yes, sir.
All right, the court has the 3.6F instruction as provided by the defense. As to the first paragraph, it is a defense to the crime, bracket S bracket, of second-degree murder and culpable negligence if the actions of Sarah Boone constituted the justifiable use of or threatened use of deadly force. What say the state as to this instruction? And should not manslaughter be included?
It should be second-degree murder, comma, manslaughter, and culpable negligence, even though culpable negligence doesn't involve an intentional act. But I'm not going to fight over that.
Okay. Any objection to that addition?
No, Your Honor.
Okay.
Judge?
Yes, sir.
Can I interrupt for just a minute? Because there's a special instruction that the state is requesting on causation,
Yes.
and that goes, it's going to come before the self-defense.
When it was used in the previous case that I cited, that I used it in, I don't know, 10, 12 years ago, it's part of the instructions in second-degree murder.
Yes.
Is where I would be requesting it.
And this is just so that we're all on the same page, forgive me. This is the state's request for special jury instruction on causation.
Yes, sir. I suggest we table that for now and just get into self-defense.
Okay, all right, so we'll revisit the state's request at that point in time. So is the the first full paragraph is read, is that acceptable to the defense?
Yes, Your Honor.
Okay, moving now to the deadly force definition. That seems to track the language of the proposed jury instruction completely. Any revisions to that state?
No, sir.
Defense? It's your instruction, so I'm assuming you've got no quarrel with it.
No, Your Honor.
Moving to the next paragraph, I also believe that that's from the Form 3.6 instruction. State, any issue with the third full paragraph?
So in my request, I struck through or threatening to use each time because the evidence doesn't support that. What the evidence supports is she did actually use force. It wasn't a threat of force. So I think it's unnecessary and confusing and not supported by the evidence to have that clause in each of the paragraphs where it's mentioned.
Response, defense.
Judge, I have no problem with that. I was just, when I put it in, I just was going on some statements that the state had made in different arguments. So, especially when I'm talking about aggravated assault.
Okay, so just so that I'm clear, you've got no objection to the removal of that language. So the third paragraph would now read, Sarah Boone does not have the burden of proving that she was justified in justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. Is that correct, state?
Yes, sir.
Is that correct, defense?
Yes.
All right, very good. Yes, sir.
To make it quicker.
And Mr. Henderson, you don't need to stand up every time, sir. I appreciate it.
I'm sorry, but it's old.
I get it.
But it's how to have it. Judge, every time that comes up,
You lose it?
yes.
Understood. So then just, let's go back to the title then. Can we revise the title to 3.6F, justifiable use of deadly force, and remove that bracketed or threat?
Funny because every time Mr. Henderson gets up, it's always yawn. There's a bit of a labored pace to the way he moves, so I can see Judge Cranick go, you don't have to get up every time. I'm sorry, yawn. I'm just used to. It's almost like Stanley from The Office. Yawn.
Use language.
It should just be used.
Okay, very good. All right. The next sentence, the law on the justifiable use of deadly force is as follows. Is that acceptable? State.
Just the strike through
Uh,
or threatening.
As I read it, yes.
Yep.
Is that acceptable defense?
Yes, Your Honor.
Moving now, Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent A, imminent death or great bodily harm to herself. Is that acceptable to the state?
It's acceptable. Just confirm that they don't want me.
Yes, confirmed, only what would be read would be A.
That's correct.
Okay, all right. Is that acceptable, state, with that understanding?
Yes, sir.
Okay, moving now to the next portion. Sarah Boone had no duty to retreat before using deadly force. I mean, my review of the case law, and I don't recall which one it is that if you're on your own home, you don't have to retreat.
My understanding of the facts was that she used force first by zipping him up in the suitcase and doing so that, one, she could make him feel like he had made her feel in the past for choking and cheating on her, and two, to give her a platform to be able to speak to him as a captive audience, and he would have to listen. Because she took the actions of an initial aggressor, it is our position that there is a duty to retreat caused by the initial aggression, as that is addressed lower in the jury instructions.
Response, defense.
Judge, I have a different view of the evidence. I think what
I have a different view of the evidence.
The initial in the suitcase is that Mr. Torres was getting into the suitcase and positioning himself into the suitcase when Ms. Boone came down. There was laughter between the two of them. The suitcase was zipped.
That is a different view of the facts, that's for sure.
It was a consensual deal. It was a consensual thing for Torres. She didn't use any threat or use of force at that time to zip him in the suitcase. Furthermore, during the demonstration and when they were demonstrating the suitcase and the zipping ability, I know time has passed, but I hadn't seen anything different. To keep someone in there who didn't want to be in there, if someone didn't want to be in there, it would be almost literally impossible to zip that suitcase because how much force it took to zip that suitcase. So the evidence doesn't support it.
Doesn't support a duty to retreat?
Correct.
It doesn't support what? So somehow, if what Mr. Henderson's saying is correct, that the demonstration showed that it's very hard to zip up the suitcase unless the person's compliant, why would it be any less incumbent on that same person to unzip the suitcase because it's difficult to get done up?
That's what they're saying. Going back, even before we had Stand Your Ground, just going back to the Castle Doctrine, there was never a duty to
The castle doctrine. Now the townhome is a castle.
retreat from your home.
So then if I understand your argument, you are...
And Kevin Beck trying to touch him, and he's just ignoring him totally like a child.
It's never a duty to retreat from your home.
So then if I understand your argument, you are not seeking to have this included then?
I am seeking...
Because if
I
you're
want-
saying she had no duty to retreat,
That's correct.
this talks about... Hang on, let me just reread it. Okay, so I think I follow your
That's a
argument.
great point.
Okay.
What I'm saying is that it should
Just Me points out both of them were on the lease for the castle. It was his castle too.
be no duty to
Hey,
retreat.
JLK.
That Sarah Boone had no duty to retreat. That's what we're requesting. I believe the state's objecting to that and saying that it is a dispute, so they want the next paragraph as to the court. But there is nothing that showed at that time, because the state's arguing that she forcefully put him in the suitcase.
Response.
That's a straw man argument. That is not the state's argument. We know what the evidence in this case is. The evidence that she provided was he got into that suitcase by himself and they were playing hide and seek, and he was inside but not completely hidden. The lid was flapping over him. She came over and zipped it shut to whether it's 100% or near 100% shut, and it was all in fun and jest at first, but he did indicate, and we saw it on the video, image IMG_1062, Sarah, I can't breathe, Sarah, I can't breathe. He was being held against his will in that suitcase. That there is no requirement that she initially forced him into it or not. It's no different than two people wrestling and play fighting, and one person has another person in a headlock, and then there comes a point in time where I'm tapping out. Jorge Torres was tapping out, and that's on video, and it's in her testimony. It's uncontroverted.
A lot of castles
There
have
is
mildew
sufficient
problems.
evidence for there to be a dispute as to whether or not she was the initial aggressor, and whether that generates a duty to retreat. And quite frankly, it's undisputed evidence because it's uniquely only her testimony coupled with the video. She restrained him in that suitcase on purpose and intentionally. And if you look at the elements of aggravated assault in our proposed jury instruction, that is exactly what was going on. She intended for him to feel fearful of an inability to breathe, to make it feel like he had made her feel when he had choked her. An aggravated assault is defined as follows: Sarah Boone intentionally and unlawfully threatened, either by word or act, to do violence to George Torres. She would not let him out. She would not release the headlock when he indicated he could not breathe. At the time, Sarah Boone appeared to have the ability to carry out the threat. Well, the video evidence is res ipsa loquitur. He could not get out on his own. He could not get out on his own at 11:12 in the first movie. He could not get out on his own at 11:23 in the second movie. And quite frankly, he couldn't get out at 11:03 during the still photo as well. Element 3, the act of Sarah Boone created in the mind of George Torres a well-founded fear that violence was about to take place. Absolutely. Sarah, I can't breathe. Babe, I can't fucking breathe. Sarah, shh, go fuck yourself. The assault was made with a deadly weapon, element 4. An object not designed to inflict bodily harm may nevertheless be a deadly weapon if it is used or threatened to be used in a manner likely to cause death or great bodily harm. Well, ladies and gentlemen, it did cause death, so that's not in dispute. So it's our position that she was the initial aggressor based on her testimony that we received in court, and that is going to put into play a duty to retreat, and that the parties can then argue about that.
Anything further, Mr. Henderson?
Yes, Judge. I want to clarify this because what the initial thing in getting into the suitcase, the act is zipping the suitcase up. That act of zipping the suitcase up was not done forcefully. The testimony was he agreed, he was in the suitcase, he was the one who got into the suitcase to begin with. He agreed, the suitcase was zipped up, and there was no argument at that time. All right, and just by the demonstration that they gave, you could see somebody to get in that suitcase or not get out of it at that time wanted to be in that suitcase. And it's nothing to dispute what she says, that he agreed, she zipped the suitcase, and they both laughed and thought it was funny.
Good morning, Meow Garita. Thank you for joining the stream. We've got a great crowd here.
Next thing that the state goes to is an omission. It is not an act. It is an omission at that point in time.
Regarding the makeup, there's a lot of discussion about the Glam Squad and what they did with Sarah and, whether it was intentional or malicious and all of that. Any Simpsons fans out there? Do you remember when Homer was an inventor and he came up with a makeup shotgun? Kind of looks like he got the makeup shotgun. Probably like not set to whore, but, still, it got things in the general spot where the makeup belonged, but yeah, that was Marge's complaint. Oh, homie, you've got it set to whore.
She's saying, when they say, oh, he can't breathe, well, she doesn't go
sorry,
let him
Marge.
out. So they're saying, so they're trying to make that an act when it is not, when she just did not let him out. It's different. And what we're talking about is just the duty to retreat at this time. We're not even talking about the other parts as the thing, but as to the duty to retreat, she's in her home. And at that point in time, when that act took place, she had no duty to retreat.
Here's what the form instruction says. If it is undisputed by the parties that the defendant had no duty to retreat, give the following sentence. Defendant had no duty to retreat before using or threatening to use deadly force. Instruction goes on to read, if the parties dispute whether the defendant had a duty to retreat, give the following paragraph. It sounds like both of y'all, are disputing whether or not there's a duty to retreat.
Yeah.
So I think I have to, based on what the Florida Supreme Court's instruction to me is to give that second paragraph. State, anything
Henderson.
further?
No.
Tony
Defense,
Henderson.
anything further?
Just note the objection, but I understand the court's ruling.
Okay, all right. So the language in
Hey, Tammy. Another one to say.
the
When
red
did you
line
sneak
from
in here?
the
You've been here a
defense
while,
as
haven't you?
to Sarah Boone had no duty
I've
to
seen it.
retreat before using deadly force will be removed. And I will add in the state's proposed language, which tracks the form instruction. Is there any objection? Do you want me to read that to you, Mr. Henderson?
No, I'll read it real quick, Judge.
Okay. And I just want to make sure we're all on the same page. That's the state's proposed revisions to the 3.6F on the top of page 2 of 7.
Yes. I'd ask that the court would read it.
Sure, okay. If Sarah Boone was not committing any crime other than the alleged second-degree murder or manslaughter for,
Culpable negligence.
okay, I
Or
will add that,
culpable
thank you.
negligence.
For which, so it'll read, if Sarah Boone was not committing any crime other than the alleged second-degree murder or manslaughter or culpable negligence for which the defendant is claiming self-defense or defense of others, and if she was in a place where she had a right to be, then the defendant had no duty to retreat before using deadly force.
Pine Weaver,
On the
you're
other
kind of a good
hand,
time.
1, if at the time Sarah Boone
This is just for anyone who's joined in late, including Pine Weaver and Meowgarita, who's just joined us, and a few others that come in a little late. It's all charging conference stuff, which is relatively dry and dull. In the live time of the trial, it was a little frustrating because it sounded like every concession was that much closer to a Casey Anthony type verdict. Now that we know what's going to happen, we can kind of just sit back, enjoy each other's company, and listen to everything happen. The only things of any real interest out of what's going to happen in these next 2 hours are going to be discussions of the jury instructions that lead to the appellate argument that the jury instructions weren't properly applied. So there may be some discussion of that comes up in the next hour and a half. It's not the most interesting content of the trial, and that's why I've set up a little Dave Catatouri yoga for your secondary viewing pleasure.
Used deadly force, she was committing an aggravated assault, or if at the time Sarah Boone used deadly force, she was not in a place where she had a right to be, then the defendant had a duty to retreat. The duty to retreat means the defendant had the legal obligation to use every reasonable means to avoid any danger before using deadly force. The law does not require the defendant to retreat if she was placed in imminent danger of death or great bodily harm or imminent danger of the commission of, parentheses, applicable forcible felony, end parentheses, against herself, and it would have increased her own danger to retreat, or if retreat would have been futile. But if the defendant had a duty to retreat, and if she could have safely retreated but did not do so, then her use of deadly force was not justifiable. I do have a question as to the applicable forcible felony
I
portion
believe
of
they were
that.
waiving B. That's for her, for the A and B that we already previously discussed, not for the
That is correct. So then that sentence would be revised to, the law does not require the defendant to retreat if she was placed in imminent danger of death or great bodily harm, and it would have increased her own danger to retreat.
Yes.
What say you, Mr. Henderson?
Judge, I enter objection as to the instruction, as the state has included to get this instruction, an aggravated assault.
Here we
which is
go.
not charged in the information.
State response.
Judge,
So the aggravated assault is due to the beating with the bat, and part of that was because Sarah, it was a good time, it was a good day, everything was good, and then just before this trial changed her story that, well, I beat him with the bat because I felt like he was going to attack me coming out of the suitcase. That became, well, that would have been evidence of an aggravated assault, but it passed the statute of limitations for charging that. So Mr. J hasn't charged it, and now there's some question over whether it should even be mentioned, or if other charges that are contingent on an aggravated assault can still be applied. And that's what.
I'm happy to hop into that one as well.
Okay.
I understand what Martinez versus State says, and I'm sure we've all read the opinion. It's in my motions, and I understand what it holds. What it says all throughout the opinion is there needs to be an independent forcible felony. And then at the very, very end of the opinion, then it says there needs to be an independent felony charged. Why I'm asking for a special jury instruction, and I've made that request in writing, is because under the standard jury instruction that we are going through right now, it says, according to Martinez versus State, that the independent forcible felony needs to be charged. The whole purpose of this is you can't engage into a circular logic argument that defeats Ms. Boone's right to self-defense. So it would be preposterous to include in this jury instruction, Ms. Boone did not have a right to use justifiable use of deadly force by committing second-degree murder against the victim when that's the charged offense. Because she, of course, would have the right to use deadly force to defend herself against the victim, and that would be correct. Well, what we have in this case, and what the state has alerted the court and the defendant to well before trial, was the evidence shows that she committed a separate aggravated assault. She, at the time that she had already zipped him shut in there, and again, just because she releases that quote-unquote chokehold by sitting on the couch, she is exerting that force through distance because she's the one that zipped him shut. So she, in using that force, is the one who did that on purpose to make him feel like he was choking and make him feel like he had made her feel like when she was getting cheated on, and to intentionally confine him in a place so that she could speak to him about her thoughts. As I already outlined, it's the state's position, and the evidence does support that this is an aggravated assault. She intentionally put him in fear of death, and she relished it. She relished it for that 2-minute video. That is prior to when she says, well, now he's sticking his fingers out and I get scared by that action. And by that action, it's George Torres just trying to exert the will to live, to survive and be on this earth. That now that action, if his attempt to escape out of the suitcase that she has left him zipped up in, is this independent threat of great bodily harm and death to her. She testifies if he gets out, it's her belief that he will beat her up, kill her, disfigure her, so on and so forth. And her testimony at trial, I believe she said was, he said that I will end you. So what we have here is they, by their own admissions, through the testimony that she provided, that there is a separate and distinct independent forcible felony from what ends up being the second-degree murder. What ends up
Hairball urine, it's 100% Dave Catatouri leading the yoga.
At this point in time when she says, well, he's trying to get out.
He's got a channel on YouTube.
I'm going to get disfigured.
I'll post the link in the chat.
And so that is why Ms. Boone makes the decision, and I'm not even going down the aggravated battery path, but she batters him with a bat on the hands and batters him, pokes him while he's in the suitcase, and basically beats him into submission so that he stops trying to escape. That's what the testimony was. And then she makes the decision to now leave him and go upstairs and go to sleep without having relieved him from the force that she exerted earlier committing aggravated assault. So like the example I gave you earlier, this is absolutely no different than me pointing a gun at you, Judge, and putting you in fear of your life that I'm going to shoot you and a projectile is going to enter your body and kill you or give you great bodily harm. And you, in turn, after having been placed in fear by me pointing a gun at you, you begin to defend yourself and exert your right to live on this earth by pulling your own firearm. And now, do I, as the initial aggressor, the initial person who committed the forcible felony of aggravated assault on you, under the law, I don't have the right now to defend myself against you. I need to retreat. I need to make it clear, sorry man, my bad, drop my gun and walk away. That is what is the law. 776041 is a very short and very, very simple statute. And it has not changed since 2014. This has been the law. This was the law at the time of this offense in 2020. 776041 provides, the justification described in the preceding sections of this chapter is not available to a person who, 1, is attempting to commit, committing, or escaping the commission of a forcible felony. So taking away the firearm example, it's a chokehold. His cause of death, according to the medical examiner, was asphyxiation by position and environmental suffocation, caused by her not releasing a chokehold on him when he indicated, babe, I can't breathe, Sarah, help. That is an independent forcible felony, separate and distinct now from what she says is the victim, like you, pulling a gun to defend yourself from me pulling a gun on you. Now, the threatened use of force that the victim is exerting is sticking his hands out and saying, I'm going to end you. That is the distinct break between the aggravated assault and now her continuing to use this unlawful force, which she's not entitled to do because she started it. She was the initial aggressor in committing this aggravated assault. And she ends up just leaving him to die and never releasing the chokehold.
And the unlawful threat is what's on the video in your realm?
Yes.
Okay.
And any facts that support that should cause this jury instruction to be given. The absolute only hang-up about whether or not this jury instruction should be given is because Martinez slightly overstates what is necessary to prevent this circular logic, which is not going to occur in this case. There is not going to be any arguments by the state that she does not have the right to defend herself if she is in imminent fear or death of great bodily harm by the victim. She testified that him sticking his hands out of the suitcase and saying, I'm going to end you, put her in fear of imminent death and great bodily harm. And in turn, what she did was she decided to not let him out. And he ended up dying. And that is second-degree murder. That is separate than what preceded that. What preceded that was her not letting him out when you can see him pushing up on the suitcase in the video, begging to get let out, and she doesn't because she is doing this out of anger, hatred, ill will, and spite to teach him a lesson and put him in fear of death or great bodily harm. That's an aggravated assault. I would absolutely charge her with aggravated assault and aggravated battery, separate independent forcible felonies, if I could. But I did not learn this information until after the statute of limitations had passed.
There we go.
That is through no fault of the states. So we absolutely would, if we could, and we are not going to make the argument and defeat her defense of second-degree murder by saying, well, you can't defend yourself with second. I understand what they're getting at in Martinez. That's not this case, though. It's broken down into those parts.
Can I have the citation for Martinez? Because unless I missed it in your motions, I didn't see Martinez cited in the motions.
I'm sorry.
And forgive me if I
No, it's
missed it.
been in previous motions.
Because you cited a Cologne with regard to the Miranda issue.
No, I am referring to, there's a pleading entitled State's Request for Forcible Felony Instruction and Request for Initial Aggressor Instruction, which we've kind of hopped into now since aggravated assault is being mentioned in this paragraph.
I love how the contrast and how quickly Mr. J, even if something's like, oh, I don't have that, hold on one sec, boom, he's got the answer, as opposed to, Mr. Owens, what's the legal basis for your objection? Margot's going to call me with a legal basis for my objection. I'm just doing the best I can. Judge.
In paragraph,
Oh, there it is. I apologize.
yeah, paragraphs
Thank you.
12 through,
Judge Cranick never apologizes to Mr. Owens. He does it to Mr. J a couple of times. Oh, yeah. Turned out you had all your ducks in a row once again. Well done, Mr. J.
31 are the legal analysis, and Martinez is cited in there at paragraph 19 at 981 Southern 2nd 449 Florida 2008. And more importantly, what Martinez doesn't say is that there's like some requirement that the verdicts would be interlocking. Like there's no requirement that second-degree murder be count 1 and aggravated assault be count 2, and then if they return a not guilty verdict on aggravated assault, then there has to be a not guilty verdict on the second-degree murder. That's not the case, because there's so many different prongs to the self-defense instructions. So it's not required to be charged for some reason of an interlocking verdict. And the whole spirit of that opinion is that it is to make sure that we do not defeat her self-defense argument that she's entitled to make about why she committed second-degree murder. All we're saying is you're not entitled to defend yourself in that manner if you committed an aggravated assault to start this. And that's what the facts show. It's a little complicated, and there's another special jury instruction related to this force by distance. It's like tying somebody to some train tracks and walking away.
That's
are
one
you
of his
still
best
choking the
analogies,
person?
I think.
No, but are they restrained in a manner that if a train comes, they will die? Yes. So the special circumstances of this case and the facts are going to warrant, in the state's estimation, the forcible felony paragraph, and then that language being placed into this initial paragraph that we're talking about.
Just reading Martinez. Give me a moment.
Yes, sir.
Just reading Martinez. So I'll read some chat while he's doing that. Peter Shane says she's already tried to get their addresses through third parties, the jewelers. I mean, there's really something else.
Which I cited in a couple of my other pleadings.
That's speaking about Sarah's interest in finding the jury's names.
A, the special instruction is supported by the evidence, which is the case. It's in fact undisputed since there was only one person there. B, the standard instruction did not adequately cover the legal theory it is meant to. That is also true. And C, the special instruction was a correct statement of the law and not misleading or confusing. That is also the case. Stevens, Stephen's versus State, 787 Southern 2nd, 747, and I mistakenly put 657, I imagine.
I think it's 755 is the pinpoint.
Yeah, 2001.
Yeah, I reviewed that already. Thank you. Response.
Response is clear, Judge. They're trying to make exceptions for the law. That doesn't work here. Simply this, what the requirement is under Martinez to get the aggressor is this. It's only applicable and only in cases where the defendant was charged with either an independent forcible felony, that's Martinez, or B, felony murder. That's a different case. In Martinez, they have not charged an independent forcible felony. So it doesn't apply. It tells us right there, that's the standard jury instruction. For him to come back here and say, well, really, Judge, they overstated Martinez, Martinez is still good law. It has not been changed. That's the rule, that's the requirement.
Martinez is good
But
law.
this is relying, Martinez's opinion states, indeed, consistent with this case law in 2006, we approved an amendment to the self-defense jury instruction to specifically provide that the forcible felony instruction should be given, quote, only if the defendant is charged with more than one forcible felony. That doesn't seem to be what the new instruction says, unless I'm missing something.
You're not missing anything.
I'm sorry, can you repeat that?
Sure. The sentence says, indeed, consistent with this case law, in 2006, we approved an amendment to the self-defense jury instruction to specifically provide that the forcible felony instruction should be given, quote, only if the defendant is charged with more than one forcible felony. And unless I'm missing something, a 3.6F instruction doesn't say that now. The form instruction.
Judge, when it comes to the aggressor in the standard jury instructions, when it comes to aggressor, and they're talking about under 776.041, sub 1,
Just going to interrupt. There's a lot of comments in the chat over how much we enjoy the rewatches for picking up little things, and I'm getting lots of compliments as well for my ability to notice moments of scorn, and I just wanted to extend my appreciation to you guys for being here with me, because if I'm just rewatching it on my own, like I was for the full year of since the trial, but before I had a channel, I'm just rewatching the same parts that I liked, but not, you know, watching it with, like, when I'm watching it with you, I'm focused, I'm here, this is what I'm doing, and I'm picking up stuff that I never seen before. So it's a very synergistic, mutually beneficial relationship we have here, and I just want to give my thanks to you for being part of it.
it's to only be given
Hey, Mary
if-
Mac.
and only in cases where the defendant is charged with either an independent forcible felony. You cannot give this instruction unless there's an independent forcible felony that.
So this is where he's upset about the aggravated assault. They're not charging it, and it's like, yeah, but you know, we're charging the murder. We would charge it. It happened.
That Miss Boone has been charged with, and there just isn't one.
But where does it say that in the form?
The facepalm was great. That was so. Any response, Mr. Owens? I think Mr. J was publishing some evidence, and Mr. Owens just jumped up. Permission to publish? No, Mr. Owens. They're introducing evidence. Do you have an objection? No, Your Honor.
Judge,
Yes.
it's page 14 of 28. Aggressor, 776.041, 1, Florida statute, give if applicable, and only in cases where the defendant is charged with either A, an independent forcible felony, Martinez versus State, 981-449, Florida 2008.
Hang on.
Or the felony. And we're acknowledging that. But when you look at the case, and what it is stating is, the purpose of that is there has to be in the evidence an independent forcible felony. And that is what occurred in this case. She committed an aggravated assault. After that, the defendant is saying the victim placed her in fear of imminent harm or death by trying to escape her aggravated assault, by sticking his fingers out, and by saying, as he's trying to escape, I'm going to end you.
But isn't that in the giving the aggressor definition? I mean, is that, but unless I missed something, that's not what we're talking about right now.
I agree, but I think it cohabitates together.
Okay.
Okay.
And it's our position, we absolutely would charge her. And it's a legal technicality in part of this standard instruction that we can't because of the statute of limitations. We all know, all of us here together as attorneys, know that those facts, if believed by the jury, support that she violated Chapter 776.041, She should not be able to get away with murder because of a statute of limitations technicality that was through no fault of the state's own. The purpose and spirit of Martinez is to make sure that we're not up there arguing, ladies and gentlemen of the jury, she had no right to defend herself from an imminent threat of harm by killing somebody. That's not what we're going to say. We understand that. What we are going to say is, ladies and gentlemen of the jury, she had no right to leave him in that suitcase out of fear and great bodily harm or imminent death because she committed an aggravated assault to put him in that predicament. That is That's the evidence in the case, that's the arguments that's going to be made. That's why we're making a special instruction request based on the unique facts and circumstances of this particular case.
Give me a second.
Yes, sir.
Beth is asking if my sister and brother-in-law still call me Dan, and I'm wondering if she means as opposed to Dan D, which reminds me of a famous, well, not famous, but I remember an interview with LL Cool J, and somebody's like, so when you're at the breakfast table, you're there with your mom, do they call you LL? It's like, oh, yeah, mom's rapping, everybody's... No, she calls me my name. What are you talking about? Calling me LL. And yeah, LL for LL Cool J was Ladies Love Cool J. Imagine his name was J, probably spelled Jaehaigh. That's what I've settled on for my spelling of J. I think it has like a bit of a Welsh feel to it, and the pronunciation would still be a clean J, so Jaehaigh. That's canon now for me. That's Mr. J. Like, I'm glad I asked for the spelling. Jeez. You go and assume it's going to be easy. Would have had the wrong Mr. J the whole time. Yeah, another one to say. I just went in for my license renewal the other day. So, one more license. I get to put brown instead of gray for hair color. Kind of cool.
Proposed, the language in the instruction in pertinent part says, he or she was committing an act, insert the defendant's criminal activity that the defendant act, but the criminal activity cannot be the charged crimes for which the defendant is claiming self-defense or the defense of others. The charged crime, second-degree murder. So I'm struggling with understanding as the other crime is, because I'm not hearing any argument as to the applicability of aggravated assault.
Judge, because, and I didn't make any argument about aggravated assault applying because they can't get over the first hurdle. The first hurdle is it has to be charged. It's not charged. That's what the case law says. I mean, this is pretty clear to me unless I'm looking at it wrong when it says this is not to be given if there isn't an independent forcible felony charged.
Any other response, State?
Just that it defeats the purpose of the statute and is manifestly unjust when it is a legal technicality of no import. There is no interlocking verdict required. If we were able to charge aggravated assault, there's no requirement that they both be found guilty. They could go ahead and hear this instruction and find her not guilty of aggravated assault and still convict her of second-degree murder because of all the plethora of permutations we have in these instructions.
But in Martinez, the underlying charge was attempted murder and aggravated battery, both of which were charged, and we don't have that here.
Yeah, he sighs a lot. Disney
But
mom
it's still
pointing out Judge Cranick feels like he's talking to a
Those
toddler.
facts. We are talking about separate, clearly distinct facts here that support there's an aggravated assault that separately gets committed first, and then in response to the victim responding to that aggravated assault, she leaves him in the chokehold to die because if she lets him out, it's her belief she's going to face death or great bodily harm because she committed a forcible felony against him. This is purely a legal.
And Kelpes points out the important thing, judge protecting the record, which is, it's an ongoing thing as we rewatch the trial, especially knowing what the appeal process and Sarah's unrealistic hopes for the appeal process. I haven't independently verified this, but somebody in a chat, I think it was one of the Law and Crime chats, pointed out that Judge Cranick has never had a case returned on appeal. Independently, I did find out that prior to his time as a judge, he worked as an appeal lawyer or as an appellate lawyer. And that, I think, would give him insight into, you know, if you're working in appellate law, you know how it's so legal based. It's not about, feelings and, I think, and, it should be this. It's, this is the law. This is what it says. This is what they did. This is why they appeal. So I'm thinking in that work, he probably, as an appellate lawyer, learned, hey, don't fuck up your Richardson hearing, because if you fuck up your Richardson hearing, I'm going to come in there and I'm going to appeal based off of you fucked up the Richardson. And, not many appeals get returned, but the ones who do get returned over Richardson's, or they get returned over, discretionary, judge extending their discretion, whatever it is. I think that the experience in appellate law and seeing how narrow the judgments go and how focused they are allowed him as a judge to protect his own record. So that's a great point, Kelpass. And I think in the rewatch, it's a lot easier to appreciate it knowing that she got charged. Whereas in real time, it felt like he was being so deferential. Like, why is he giving the defense so many breaks? Why is he giving them so much opportunity? Just tell them what the law is. Damn it.
Technicality, the entire opinion on Martinez, until the very last paragraph, uses this language.
Dramatic pause much? Come on, Mr. J.
They use language like, the underlying facts of the present case demonstrate why it would be illogical to conclude that section 776041, paren 1, applies where there is no independent forcible felony. It doesn't say where there is no independent forcible felony charged. It goes on and uses that same language all throughout the opinion, and then in the very last paragraph in the conclusion,
I believe Judge Cranick says the exact words, I too am a fan of the Oxford comma. I think that's coming up in today's transcript. I, like Mitch Hedberg, is a straight A student, knows what's coming, just like juror number 2. Juror number 3, but number 2 in our hearts. Well, number 2 in the panel on the stand, because he keeps referring to him as juror number 2. I see you with your hand up. It's got to be juror number 3 in the final.
it changes to, in conclusion, we hold that it is error for a trial court to read the forcible felony instruction to the jury where the defendant is not charged with an independent forcible felony. But there is an independent forcible felony in the facts. There is a statute that says that Ms. Boone should not be able to get the avoid the.
Here's a fun fun Judge Cranick fact. Did you know that he is a deep sea photography aficionado? He did deep sea scuba diving with his wife. Liked it. She wasn't into the idea of him spearfishing and, catching fish while they were out. So he got into deep sea photography. He spent about 5 to 10 minutes in an interview I saw with him just discussing really deep, you could tell he was interested in it as a hobby. It excited him. He got all perked up and was like, yeah, no, thank you for asking.
Girth of this jury instruction. She violated, according to the facts that she gave us, she violated 776041 paren 1. She was committing an independent forcible felony, and therefore...
if you're interested in that, have a look, search Dan D. Judge Cranick, and that'll probably surface the video. It's interview... There's 2 interviews he did, but one of them was around COVID time when people were just getting used to Zooming for interviews. And I think he was running for re-election as judge, so he was doing a little bit of promotional stuff. And anyway, I cut a couple of his interviews and turned it into a rewatch with commentary, but also provide links to the original so you can see it with commentary, with the live chat replay, and also get pointed towards the full interviews if you want to see them in all their detail.
should not be able to get away with this instruction not being given because the technicality that the state can't charge a case or can't charge a count that is not required to be interlocked by verdict. Thank you.
Okay.
When he's focused, he's focused. Like Dave
Footnote
Catatouri.
4 provides, explanation in the Martinez opinion as to certain circumstances and whether or not in that hypothetical that the Supreme Court gave, whether the robbery is a separate and independent forcible felony and the forcible felony instruction is applicable. But the conclusion seems to state that it has to be charged, that it is an error for the trial court to read the forcible felony instruction to the jury where the defendant is not charged with the independent forcible felony. Anything else, Mr. J?
No, sir.
Then how do we want to accomplish this? Because I don't know how I can read the proposed language by the state, and there's a disagreement as to whether there's a duty to retreat. And it's not undisputed. It is, in fact, disputed.
In
Well,
fact.
Their complaint is in the sentence, on the other hand, if at the time Sarah Boone used deadly force, she was, then I just think we strike through committing an aggravated assault. We go to if at the time Sarah Boone used the deadly force. Okay.
And unless you just want to go to 2, on the other hand, if at the time defendant used deadly force, she was not in a place where she had a right to be, then the defendant had an obligation to, then the defendant had a duty to retreat. Just excise 1 completely. I don't know what else to do.
But she has a right to be there.
Right, under the Castle Doctrine and the case law.
Okay, then I think we go with the first paragraph and then we just deal with the initial aggressor at the end, which is kind of the exception to that. So
Okay, so then Sarah Boone had no duty to retreat before using deadly force.
Yes.
Okay, is that acceptable to the defense?
Yes,
I think it puts us back in the position where we started at anyway.
yes.
Okay, all right.
I just object for the record in case some assistant attorney general wants to potentially cross appeal something.
Objection noted. It looks like the next parts of the form instruction, if the defendant was in a dwelling, was excised, the give A, B, or C was excised. Are you on board with that state?
Yes, sir.
Then the next paragraph, a person is not justified in using force to resist an arrest. Clearly, that's not applicable. I don't think that's at odds. However, if an officer used excessive, I also don't believe that's applicable based on the facts. We then proceed to the give in all cases language. Any objection to this language state?
Just kidding.
Sure. It's the bottom of page 2 of the defendant's 3.6F red line.
I'm just finding where it's going to...
On the form instruction, it's the bottom of page 3 of 7. Give in all cases, right after Jackson v. State.
Yeah, just the agreed
Oh,
upon
that's
strike
interesting.
or threatened use.
Aaron Lives Here gives us a little
Being decided
tidbit.
whether Sarah Boone was justified in the use of deadly force.
Fine and dandy chat comment.
Any objection?
No objection to that, Judge.
Good. Then I'll pause it to speak of it. Aaron Lives Here says, I get a kick out of the fact that Lawyer You Know was once a student of Judge Cranick. He even stood in court like the students do now. Would that be Barry University then? And yeah, those are his mock trial students I know behind him. Interesting little tidbit. Thank you, Aaron.
We'll excise the threatened use, so it'll all read use of deadly force in that paragraph.
Yeah, no, this is great for chair yoga.
All right. Now we have a proposed instruction,
I've got it slowed
I
down to
believe, from the
2/3,
defense
so if it feels like a
regarding
long
battered
hold,
spouse.
it's not you, it's
Table
me.
the battered spouse proposed instruction since both parties have that.
Sure. Moving now to the presumption of fear, that's been struck out by both parties and agreed to. Moving to the exceptions of presumption of fear, that's been struck out by both parties and not necessary. That takes us to a person who unlawfully by force enters or attempts to enter, that's not applicable. Definition of dwelling is not applicable. Residence and vehicle are not applicable. That takes us now to the aggressor language.
No additional arguments as to why the facts show she was the initial aggressor, and thankfully for the state, there's no requirement under this provision that there be an independent forcible felon.
Okay. Looks like we have a disagreement between the parties as to the application of the aggressor instruction. It's struck out on the defense's side and not in the state side. What say you, Mr. Henderson?
Give me 1 second.
Sure.
Please.
Yes, sir.
James is gone for a long bathroom break. I don't think he's been at the table through the whole second half of the charging conference. And it's funny, Kevin Beck doesn't get to move up to the main table. It's like, no, I'll have Lauren come up, please. If Kevin's even there, he'd be behind me if he's here. Peekaboo. Oh yeah, there he is. Okay. No main table for you, Kevin. Get out of my shot. Get out of my shot. James is outside setting up his post-verdict interviews with Court TV.
All right, are we on 776.041 sub 2?
If I wear my green jacket, that won't get green screened out, will it?
Yes, sir.
Yeah, I try and use the yoga. I'm using it in bits. Too much of it, and you just won't you won't focus on what's important. But just when your focus starts drifting, I'll bring it back with a little yoga and get the ebb and flow, the yin and yang, little of this, little of that, a little comme ci, comme ça. Je ne sais quoi. Celebrate the joie de vivre. Should have some intermission music for this.
Judge, my own argument would be that the only evidence, the evidence from Sarah Boone stated that she did not do anything forcefully wise until after Mr. Torres had made verbal threats and was coming out of the suitcase. So that's, my objection is based on that.
James Owens doing
Any
a
other
Ted
argument,
Bundy
Steve?
escape.
It's
You're the lawyer, you're not the
play
client.
wrestling and not release
Leave me
the
alone.
chokehold when your buddy taps out.
Hey, Michael,
And-
good to
I
see
mean,
you.
Isn't there evidence as to what Ms. Boone had told the experts, which seems to be at odds with that issue, and it's really a factual issue and a determination for the jury to make that determination on what the real facts are?
I can't disagree with that.
Okay. Then with regard to the proposed language as the,
Mr. Henderson still can't help getting up. They've expressly told him he doesn't need to get up a couple of times. Well, at least the one time. But Mr. J the other time just asked. To be clear, I don't need to stand each time during the charging conference. No, sir.
776.01.
Sarah must be so bored. This is probably the worst. Like, nobody's even talking about her. Nobody needs her advice. You know, there's no papers to shuffle. Just like, you guys are all acting like I'm not even here.
1 sub 2 instruction. However, the use of deadly force is not justified if you find that Sarah Boone was attempting to committing, or escaping after the commission of aggravated assault. An aggravated assault is defined.
No, sir.
No.
No?
That's the friend one.
Am I on the wrong section? I apologize. I am at the wrong section. Forgive me. So it is the, however,
With my strike throughs, it's however, the use of deadly force
is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself unless, 1, the threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on George, that's spelled incorrectly, Torres, or 2, in good faith, Sarah Boone withdrew from physical contact with George Torres as clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force, but George Torres continued or resumed threatened use of force. What's your, just for clarification purposes, anything else as to that instruction?
Big thank you to Michael E. Huang. There are 5 Dan D True Crime gift memberships that have gone out to Jamie Hayes, Claire T807, Proud Mama Tater, Buzzed Boomer, and LR So 1Rs. You guys have all received free memberships to Dan D True Crime, courtesy of Michael E. Huang. Thank you very much.
Just one thing I need to put on the record, Judge.
Yes, sir.
The force at that time,
I'm just going to speculate. Proud Mama Tater very well may be. If you've ever seen the channel Hillbilly Crime, they cover the Mickey Stein's Judge Mullins case extensively. I think she's from Lecter County, which is the county where it happened. He's recently been granted a change of, or he hasn't. He wanted to have it heard there. The state asked for a change of jurisdiction, so it's going to the next county over. But I think Mom is called Sweet Tater. Anyway, that just reminded me of that channel. If you guys are interested in that case at all, that's a Boots on the Ground channel. They'll get you all the inside scoop. It's a little slower paced. Like I know I talk fast and kind of fill the airwaves a lot. A little bit more slower, a little bit more drawl, a little bit more of that Eastern Pennsylvania or Western Pennsylvania, Eastern Kentucky, slow and easy. But if you want facts on the case from people who like know the players and like know how things work in that county, Hillbilly Crime's a great channel to check out.
as testified to, was the poking of the bat on the outside of the suitcase. There was one strike when the hand was outside. These were bruises.
I'm looking forward to getting Cowboy back on a project.
The injury to the head area.
Cowboy and I worked together on the very first episode of the Sarah Boone trial rewatch. We watched a little bit of her, I think it was her pro se, just as she was firing her lawyers and moving into the pro se phase. But it's in the playlist. It's one of the first videos of this series. Take it slow and easy.
The injury to the head could be serious, but in this instruction,
Make love to
it's talking
me
about
completely.
deadly force. And none of those, as to the X-ray, as to the testimony from the medical examiner, none of those injuries caused.
Mr. Catatouri's bored. I thought it was Sarah who'd be bored, but check out this yawn from Mr. Catatouri.
As to the testimony from the medical examiner, none of those injuries caused.
No cover, nothing, just... Mr. Henderson is boring as fuck.
Is the force that we're talking about. It's just like that I cited in my special, state's request for special jury instruction regarding withdrawing from physical in my
As to the testimony from the medical examiner, none of those injuries caused the death.
the continued restraint on him that she did not undo is the force that we're talking about. It's just
You're
like the
gonna
cases that I
see
cited
me
in my
roar.
special, state's request for special jury instruction regarding withdrawing from physical contact. Batteries don't need to be skin to skin.
Mary Mack is a White Snake
Commit a
fan.
battery on somebody while driving your car and striking their car. A false imprisonment does not mean you have to choke somebody. You can falsely imprison somebody by barricading them into a room with a grocery cart. She unlawfully exerted that force and did not withdraw from using that force when her wrestling partner, so to speak, tapped out.
Okay. I'm going to include the instruction for now. The next paragraph reads, if you find that Sarah Boone, who, because of prior threats or difficulties,
Sarah looks like she's
All right,
had her
that'll be
bunk kicked
included.
at 3 a.m.
The
for
next
the last 2
paragraph,
weeks.
if you find that at the time of the alleged aggravated assault and/or criminal mischief,
Good comment,
Yeah,
Vel.
It needs to be secondary murder, manslaughter, or culpable negligence, and we don't object. There were specific acts put in evidence.
any objection to changing the beginning of that sentence defense, if you find that at the time of the alleged murder in the second degree, manslaughter, culpable negligence, Sarah Boone knew that George Torres had committed an act.
Yes.
Okay, thank you.
And then we requested the strike through at the end or threatened to use.
Agreed.
Give me a moment. So that sentence would now, or that section would now read, if you find that at the time of the alleged second-degree murder, manslaughter, or culpable negligence, Sarah Boone knew that George Torres Jr. had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Acceptable?
Yes, sir. I just don't know that we use Junior after his name anywhere else.
Give me a moment. Yeah, Junior's not used anywhere else, so I'll excise that. Is that acceptable to you, Mr. Henderson?
Yes, Your Honor.
All right, moving to the next line. If you consider that George Torres, removing Junior, had a reputation for being a violent and dangerous person, I don't know.
Good call, Elizabeth, pointing out the side eye that Lauren's given to Sarah.
Here, evidence of reputation?
The state's position is going to be there was no reputation evidence. Ms. Boone offered an opinion, but as everybody knows, reputation evidence has to come from a broad enough aspect of the community, whether it be a church or a neighborhood or perhaps even a large family. But
Defense?
I'm rethinking that, Judge.
No worries, take your time.
I'm rethinking it, Judge.
I know generally, and reputation evidence generally, it has to be something that is known based on the community.
There we go, Phil saw it.
And if that was the community. I know the only thing that I can relate to is the fact.
Phil saw it. Sarah is using a contraband pen. I knew, like, she's just pushing it because it's the last day, so it's like they're not going to be able to tell her tomorrow. She's, you allowed to use that pen? I don't know. I just did it.
That individually, she experienced certain things that could build that reputation, but that's on her. I think there's
That's on you.
evidence, though,
That's on
from
you.
people, at least that they knew about it or were told about it. Most of that was stopped. But I could go to at least the one situation on a text message that was.
Hey, bedtime lullabies.
That talked
Always
about
great to see a friend in chat.
his former wife or ex-wife.
Super
How's
Kelly
that
G.
reputation? It sounds like that's a specific instance based on that text message.
Correct. I agree.
Okay, so in agreeing, we're going to excise the reputation section, correct? Okay, thank you.
We'll take a second to give Bedtime Lullabies a proper welcome because Bedtime Lullabies came in gift and gifts. So Davis Pam D, Janice Sheenan, Nikki Davis, Ginger Snaps, and Miss Sweetie Pie herself have all received memberships to Dan D True Crime, courtesy of Bedtime Lullabies, popping into the chat.
We'll excise that.
State agrees to the physical abilities that's mandatory in each case.
What about the one that precedes that? If you find that George Torres
Lots of fun new emojis just added for today's stream.
had a reputation, well, also that reputation would be removed as well, correct, Mr. Henry?
If you receive a gift membership, just refresh the stream and then you'll be able to enjoy any of the benefits of memberships, which include the emojis I'm about to post.
If you find that George Torres Jr. had a reputation for being a violent and dangerous person, you may consider this fact in determining whether he was the initial aggressor.
That's correct.
Okay, so that'll be excised as well. State has no objection to the physical ability section. I'll just remove the word junior after Torres. Any other questions with regard to the 3.6F instruction?
Your Honor, state doesn't object to what we have produced as the final product. I'm impressed we did it so quickly. We just note our objection for the record to preserve a challenge to Martinez.
Understood. Do the parties, well, let me ask this question. Mr. Henderson, anything else we need to address with regard to the 3.6F instruction?
No, sir, I'd just like to preserve the objections that I made during this conference.
Objections preserved. Do the parties wish the court to reread the 3.6F instruction that we just went through, just to make sure we're all on the same page?
Yes, sir.
Can we do it at a time where it
Is in final form? Yeah,
Yes.
absolutely. Okay.
Perhaps a written copy that we can take during snack time.
Sure, absolutely. All right. Where does that take us now? Does that take us to the 3.6G instruction?
I believe so.
Okay, give me a moment. I have the state's proposed 3G instruction. I have the form instruction from the Supreme Court. And I have the defense's proposed revisions. Just move everything around here. Give me a second.
Take your time, Mr. Kranick. I'm just getting myself sorted as well.
Okay.
You're good? I'm good. Let's go. Judge? You let me know when you're ready.
As to the title, I believe that based on what we've discussed, the or threatened use should be removed. Is that correct?
That's correct.
All right. As to the first sentence, it is a defense to the crimes of second-degree murder and culpable negligence if the actions of Sarah Boone constituted the justifiable use of threatened use, as we're removing justifiable use of non-deadly force. Would be removing threatening, and we would also be including manslaughter, correct?
That's correct.
State?
Yes, sir. It is a defense to the crime of second-degree murder, manslaughter, and Oxford, or culpable negligence.
Oxford, comma.
The Sarah Boone constituted the justifiable use of non-deadly force.
I, too, am a big fan of the Oxford comma. So the defense would, or the, I, too, am a big fan of the Oxford comma.
Constituted the justifiable use of non-deadly force.
I, too, am a big fan of the Oxford comma.
Sarah Boone, and Oxford, or culpable negligence if the actions of Sarah Boone constituted the justifiable use of non-deadly force.
I, too, am a big fan of the Oxford comma. So the defense would, or the instruction would now read, it is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use of non-deadly force. Acceptable state.
Yes, sir.
Acceptable defense.
Yes, Your Honor.
Definition of non-deadly force is not at issue. Next paragraph.
I'll take
Sarah
a little
Boone does
break.
not have the burden.
Another one to say says, I wonder when Dan D's name will appear in her letters. I'll celebrate. And no Oxford comma, just left it hanging. To that end, there was a certain supporter from Australia that appeared in the comments responding to someone else. But I did take it upon myself to say, hey, saying hi. I don't personally care if you want to be pen pals. It's kind of a generous thing for you to do because not a lot of people would be willing to do it. So, that part I don't have a problem with. But say, hey, as a pen pal, as a, someone who just reaches out, writes the letters and, makes a connection. Have you ever mentioned, you're here on my page, you're responding to comments. Have you ever mentioned the fact that Dan D does music parodies, funny songs? Said I thought that Sarah would really get a kick out of the lyrics. Let me know. No response at all. No response. No, not a dislike, not a like, not a snarky comment. Just no comment at all. So that's I'll let you know if anything develops on that front. But at this point, I think she's still blissfully unaware of Dan D true crime.
Of proving that she was justified in using non-deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using non-deadly force. Acceptable state.
Yes, sir.
Defense.
Yes, Your Honor.
The law on justifiable use of non-deadly force is as follows. Sarah Boone was justified in using non-deadly force against George Torres, excising
Hey, Bernice,
Jr.,
good to see you.
and had no duty to retreat if she reasonably believed that such conduct was necessary to defend herself against A, George Torres, excising Jr., imminent use of unlawful force.
Are you kidding?
Is that instruction acceptable?
Fairball Yarn says that there was a Supreme Court decision that came down to the lack of an Oxford comma. So most lawyers use them now. Yeah, that's... What does a piece of punctuation cost, right? Just throw it in there if there's going to be any confusion.
Yes, sir. I don't know if you mean to include the A if we're not using the B. I would just suggest you make one sentence.
Any objection?
No objection.
Okay. Any other issues with the instruction as read so far? State.
No, sir. Thank you.
Defense.
None, Your Honor.
Okay. Looks like there are several agreements with the balance of this instruction as to the defense of property is not applicable, the 776.0134 dwelling and residence and vehicle, and force with regard to law enforcement, all of which is not applicable in the instant case. That takes us to the give in all cases. We would be removing the threatened use of non-deadly force in that section. Any other changes is to the give in all cases section.
Nothing to say. Thank you.
Defense.
None, Judge. No objection.
No objection, no objection.
Okay. Let's table the proposed instruction on the battered spouse for the moment.
Then the state will be making its request for the forcible felony instruction.
Under Martinez.
Yes, and we understand the court's ruling, and we're sending a strongly worded disagreement to the court's Supreme Court.
Received an
A strongly worded disagreement.
We're sending a strongly worded disagreement to the court's Supreme Court.
received and understood, but based on what the court said earlier as to the conclusion in the Martinez section, I'm disinclined to add your proposed instruction.
So I think what Mr. J might be referring to there is that they dispute Martinez and they've got a pending appeal with the Supreme Court regarding the intent of Martinez. And I'm just guessing that because I'm not a lawyer, but from context, I think that's what he's saying. And Judge Kranick is like, respect that. It's on the record. And at the same time, I've got to deal with the law as it is now. So I'm going to overrule that. But thank you for letting me know.
That takes us now to the 776.0412 section. Looks like we have a little bit of a disagreement.
Michael E. Wang wants an explanation of the Oxford comma. I'll let chat get to your quick ones, and then I'll let AI give me something I can read into the record, as well as there's a couple of funny examples where, God, what is it? Something about eat? No, I've ruined it. Anyway, I'll look it up. We'll find it.
Here.
You'll know.
Is it the same arguments that we received in the 3.6F instruction?
It's the same fact.
Any other additional arguments, sir?
No, Your Honor.
All right, for the reasons previously identified, the court will accept the state's proposed portion as to the 776.0412 instruction. Then it takes us to the prior threats.
Same requests and objections as in 3.6F from the state, sir. For the end of the instruction.
The Oxford comma, often called a serial or Harvard comma, is the final comma placed right before the conjunction and or in a list of 3 or more items. For example, writing red, white, and blue uses an Oxford comma after white, while red, white, and blue without the comma does not. It clears up confusion in sentences that have double meaning. A famous contrast: I love my parents, comma, Batman and Superman. Without the Oxford comma, you would be implying that your parents are Batman and Superman. With the Oxford comma, you see that it's just among a list. You love your parents, you love Batman, you love Superman. There we go. The Oxford comma. Brought to you by Dandy True Crime and Fine and Dandy Chat.
I agree that it should track with the...
Eat, shoots, and leaves, that's it.
Forgive me. Other than reputation.
Eat, shoots, and leaves. Thank you, Hairball Yarn. That's the famous... That was the grammar textbook. When I was in journalism school, that's what they gave you to kind of teach you what's what now, many, about all the rules of grammar as you're going into, for me, it was CP style, Canadian Press style, but I think for a lot of Americans, it would have been AP style or Associated Press style.
And what were the other issues?
Prior threats should...
Conjunction, what's your function?
Okay, thank you. Reputation should be excised.
The 2 paragraphs of reputation excised, and then physical abilities gets read in all cases.
Agreed?
Correct.
Okay.
Agreed.
All right. And then we'll remove the threaten language in there, correct?
And yes, as I like Mitch Hedberg points out, what if my parents are Batman and Superman? Wouldn't it be terrible that people aren't getting that your parents are the famous Batman and Superman? To say nothing of what it does for gender equality. But, you wouldn't want that getting overlooked by the Oxford comma's common disusage. So people wouldn't be attributing your parents to being such super stock. They would just think it was part of a list and you were not a fan of the Oxford comma. So Oxford commas unite.
Give me a moment.
The Oxford comma.
Okay. Any other questions with regard to the 3.6G instruction state?
No, thank you, sir.
Defense?
None, Your Honor.
Okay. I believe then, just double check my notes. I believe then that addresses those issues based on what we did not discuss this morning in the charging conference. And I think that now takes us to the state's request.
This is Forever Wander comes into the chat bringing up Word Crimes from Weird Al Yankovic. That's a great little parody song. It's to the tune of Blurred Lines, the famous Robin Thicke song where he grinds up against... it's a famous supermodel. She ends up... She's big deal now. And that said, if you're, pervy, I think there's even a bare boobs version of the video that's on YouTube. You have to be signed in. You're not going to just see that as a guest. But Blurred Lines, became Word Crimes by Weird Al Yankovic. And again, it's just a great song about grammar and people using it incorrectly. It's a lot of fun.
In the defense's request for special instructions.
Can we do the battered spouse one first, as the conflicting requests?
Yes. Specifically, we're making reference to the state's request for special jury instruction regarding battered spouse syndrome filed, I believe it was,
Hey,
it's not
Addie,
dated,
good to
but I
see
think
ya.
it was either the 23rd or the 24th that you filed these, Mr. J, and the court record will speak for itself as to when they were filed. Okay. Courts reviewed that motion and reviewed the proposed instruction by the defense. State, let me hear from you first.
So here's just I'm going to do a spoken word version of Word Crimes, just one verse. I hate these word crimes, like I could care less. That means you do care, at least a little. Don't be a moron. You better slow down and use the right pronoun. Show the world you're no clown. Everybody wise up. Say you've got an IT followed by an apostrophe S. What's that mean? You would not use it's in this case as a possessive. It's a contraction. What's a contraction? Well, it's a shortening of a word or group of words by the omission of a sound or letter.
Their instruction, I think the problem with it is that it kind of blurs the subjectivity component.
There's no X in espresso.
The objective, reasonable person standard. So if we make this change to their instruction, then I'm actually okay with it. What I would suggest that change be is in the second paragraph. If you find the evidence that Sarah Boone suffers
Hey, Miss King of anything.
syndrome credible, you may consider this evidence to
Your
assist you in determining
participles
whether
dangling.
the person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by
Some cunning linguist. You must distinguish.
the victim, no junior. I don't know what's necessary with the date. That makes it clear, because that's what the case law says. The case law makes it very clear it's about the objective component.
I agree with you.
And then I would just ask for my last sentence, which is like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse.
What say the defense? And if necessary, I can read.
Yes.
So it looks like there's no, first of all, just so the record's very clear, Stevens v. State identifies the special instruction circumstances. Special instruction is supported by the evidence in this case. Yes, absolutely. The standard instruction did not adequately cover the legal theory it is meant to. There is no standard instruction on battered spouse over and above what's included in the self-defense instruction. The special instruction was a correct statement of law and not misleading or confusing. We're addressing that third prong of Stevens at this time. The proposed instruction would read, you have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. It would then go on to read, like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome.
Agreeable.
Okay. Appreciate y'all working together on that. Give me a moment to finalize this.
Take your time, Mr. Kranick. We're enjoying each other's company, just quoting music in the chat.
As such, the third prong of Stevens has been made, and the court will give the special instruction as identified on the record. Now, the only question I also have is, do we want this as its own instruction, or do we want this included where it currently is in the 3.6F and 3.6G instruction state?
I would suggest it be 3.65, right after the.
It's Mom of Lola upstairs moving around. Sounds like she's well.
Okay. Do we want to label it or just have it as special instruction and then read it? Do we want to have the title special instruction on battered spouse? I welcome.
I'm fine with it just saying battered spouse syndrome.
That's fine.
Okay, so it'll be special instruction on battered spouse syndrome. Is that acceptable?
Yes, sir.
Is that acceptable?
Yes, sir.
All right, thank you. All right. And that will follow after the 3.6G instruction, correct?
Yes, sir.
Acceptable? Mr. Henderson?
Yes, sir.
All right, that takes care of that.
All of it should be left. Oh, go ahead.
Yes, I'm sorry, sir.
I'm sorry. I think we might be required to read it both times, after each one.
I have no problem with adding a paragraph into it that says this applies to both the justifiable use of deadly force and non-deadly force.
That's fixed.
Okay. Where, gentlemen, do you want that?
After the big paragraph that ends with George Torres and before like any other witness.
Sure. Okay, so let's go over that language one more time so that we're all on the same page. Mr. J, what is it that you propose?
To put between the paragraph that ends with Jorge Torres and before the paragraph of like other witnesses or whatever I said,
Mhm.
You can consider this testimony and evidence in the applicability or the use of whatever word people agree on of both deadly force and non-deadly force instructions, something to that effect. If that's too convoluted, I'm fine with it just being repeated.
I tell you what, I'd rather just repeat it.
I think so.
That gets way complicated.
Yes.
I'd rather just repeat it under 3.6F and 3.6G.
Agreed.
Okay.
Hey,
Is that work
Deb.
with you, Mr. Henderson?
Yes, sir.
All right, thank you, sir. All right. Okay. Moving now to the state's request for special instruction regarding withdrawing from physical contact, filed October 23, 2024.
There's about 5 more minutes left. I'm going to let you guys listen to that. I have to run upstairs for a second, but I'll be back before the Seal of Florida comes up. I promise. I'll be right back.
Or has reviewed it. I guess the first question is, what say, is there proposed language?
Trying to see if I'd actually put that in there.
I don't know that I see it, Mr. J.
Oh, paragraph 15. Physical contact includes any restraint on George Torres, apostrophe, movement.
And this would be after the initial aggressor portion in the 3.6F and 3.6G, correct?
Yes, sir.
Okay, what say you, Mr. Henderson?
If I could have one.
Yes, of course.
All right, looks like I've made it back in time. They're all quietly just hanging out, okay? The incense didn't stay lit. Now, is this the end of the charging conference, too? We come back with a little bit more outside of jury presence stuff. Not much, though. Oh, but then there's also some jury instructions as to how to interpret the closing arguments. Okay, so we still have like about
This is what I'm having a problem with, but I think it could
an
be
hour.
corrected. Because they're talking about at this, therefore, at the conclusion of the two paragraphs regarding initial aggressor, it should come in, not there, but shouldn't it come in, because that's not there anymore, initially provoked.
Yeah, in the 3.6F instruction, references to initial aggressor have been removed.
Yes, so now is the state asking for it to come in as the.
Punchable Baby, no.
Unless I missed something.
Asking about CBC Radio in Nelson, no. My only experience in radio was working briefly in Squamish. I did a weekend in radio at Mountain FM, just doing the Sea to Sky Highway traffic and weather reports. And there's no problems in traffic, but if you do see a problem in traffic, give us a call. Any wildlife or fallen rock in your area, just give us a call. It's a free call on your cell phone, star 1071. Now back to Wayne Discover in the morning.
My understanding was that it was the two paragraphs about aggressor are coming in. What's not coming in is the Martinez forcible felony. The facts of the case.
Right, but the language, you said at the conclusion of the paragraphs regarding initial aggressor, the words initial aggressor don't appear in the 3.6F. It's only after that. However, the use of deadly force is not justified if you find Sarah Boone used force to initially provoke the threatened use of force against herself unless, and then it's paragraphs 1 and 2. Is that where you're asking it to be?
Hold on, let me pull three.
Sure.
You got it here. So in 3.6F,
Another one that asks, is your mom joining us soon? And like Suma responded when I asked her, hey, are you ever going to get your mom on a stream? She said, I talk to my mom enough. I don't need to have her on the streams. She might join, but we'll save it for special occasions. I can't have her on all the time.
it should be, however, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke
Correct.
the
That's what I
threatened
have.
use of force against herself unless, parens 1 and 2,
Correct.
and then after 2, as an explanation for what is listed in paren 2 as from physical contact, just that elaboration of what we're talking about.
I got it.
Because
Okay.
the unique circumstances of this case, the remote force.
Okay, I got it. I just want to make sure we're all on the same page as to where. What say you as to the proposed language of physical contact includes any restraint on George Torres's movement as that portion in 3.6F and in 3.6G?
No objection.
Okay, all right, so court's going to grant the state's request for special instruction regarding withdrawing from physical contact. And the language of physical contact includes any restraint on George Torres's movement will be included after the, however, the use of deadly force language after paragraph 2 in the 3.6F instruction. And in the 3.6G instruction, it will be at the end after the physical abilities section. Also, it's George is spelled incorrectly. That will be remedied.
I thought the two paragraphs about aggressor were being mirrored in 3.6G. It shouldn't go after physical abilities, it should go after.
Oh, I'm sorry. You're correct. I apologize.
No problem.
Okay, got it. That takes us now to the state's request for special jury.
And to be fair to my mom, she, every time I come up from a stream, she's shaking her head like, I don't know how you do it. There's no way I'm sitting down there with you for one of your full streams, that's for sure. So Yeah, well, we'll special occasion it. We'll find a way to get her in on the stream, but don't count on it.
On causation, filed October 23, 2024. I have reviewed it and the proposed instruction on paragraph 3 therein.
Judge, the reason we're bringing this up is just during the cross-examination of Dr. Z, or Zadovich, you know, we poked the bear a little bit about his cardiovascular condition. My memory of the testimony was that she's emphatic that that was not the cause of his death. But because of that, and because of now the request of culpable negligence at misdemeanor for a lesser, I feel it might be warranted to give this explanation of causation in the second-degree murder and manslaughter instruction.
Happy birthday to Kelpes's mom.
Defense, what say you?
Judge, I would
You can hear the spirit is leaving Judge Kranick's voice. Huh? Defense, what say you?
I believe that just the instruction, the proposed instruction that I have it as one but for the defendant's criminal act, which we have a standard jury instruction that said the death was caused by the criminal act of the defendant, and that's what they're required to prove. This language, to me, would lessen that requirement by saying but for the defendant's criminal act. Then the second part, when it goes up to George Torres' death, was not beyond the scope of any fair assessment of the danger created by the defendant's criminal act. I think that's covered, Judge, in the fact that the state does not have to prove that Ms. Boone had the intent to kill George Torres. So that makes it confusing to me when the standard instruction basically simplifies it, in my mind, and it keeps them right where they're supposed to be with that instruction. They don't have to prove that she had the intent. Then, as to the third part...
I'll withdraw my request for that.
Okay.
If heart disease gets brought up in closing.
All right, fine. So withdrawn.
We'll
Court
deal
takes
with
no
it.
action on the state's request for special jury instruction on causation. That leaves us now with the state's request for forcible felony instruction and request for initial aggressor instruction. That's already been addressed, has it not?
I was just treating it as a special jury instruction for my argument.
Understood. All right, are there any other instructions sought by the state at this time?
I believe we've concluded this exercise.
Defense.
No other ones.
All right, here's what I'm going to do. I'm going to take all this upstairs. I'm going to re-review it. I'm going to merge it all into one document, and I will send it to all the parties. Let's plan on being back here at 1:30, and we'll address any other concerns of the jury instructions at that point in time. State, anything else we need to address?
125.
Let's make it 1:20.
All right, thank you.
Defense.
Nothing else.
All right, we'll see you all at 1:20. Thank you.
Happy birthday to Kelpes's mom. Happy birthday to all the Leos. Happy birthday to every Sarah Boone person who's having a birthday this year or next year. It's happy birthday to everyone in the Dandy crime universe that's having a birthday. Thank you for sticking with me through that little endeavor. We'll get right back to our regularly scheduled broadcast. There we go. Shackle her up and take her away. Get her out of here. Just so our viewers get to see that. There we go. Chain her up. Birthday, happy birthday to you. All right, so as soon as she gets pulled away, we will return to when she gets drugged back in. Pick her bunk and tell her to get her butt inside. Right about here.
Versus Sarah Boone. Back on the record.
We'll go from here. Or maybe not here. This doesn't... Looks like there's a glitch in the matrix here. All right, we appear to be back. Apologies if that came in a little hot, a little loud. I forgot how loud the background music would be, but I think I have a limiter on. Maybe I don't. We'll find out.
Record case number 2020 CF 2603, State of Florida versus Sarah Boone. Limited appearances for the state, please.
Dave Catatouri on behalf of the state. Will J for the state.
Defense.
James Owens for Ms. Boone.
Tony Henderson for Sarah Boone.
Kathy Callie.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. I apologize for
I apologize too. I didn't see that, but Kathy Callie is gifted memberships to Bernice Conklin. Cold Facts. It's me, Merelda, Shelly Beans, and Jilbo Baggins. Of course, it's Jilbo Baggins, Shelly Beans. It's me, Merelda, Cold Facts, and Bernice Conklin. You've all received memberships to Dandy True Crime, courtesy of Kathy Callie.
I realized that there were some typos after I'd sent this to print and needed to take them all apart to fix it. So thank you for your patience as we...
Was I muted?
State.
I was not freaking muted, was I?
Non-deadly force,
Page 12.
there was a couple strike-throughs with the use.
I saw.
However, there was also a mistake with leaving
Oh,
the
no.
reputation in at the very end of 3 points.
I was muted. Well, I was playing birthday music. Yeah, it was pretty jazzy. It was... Really? That wasn't playing? Should have been playing. I don't think I had that on the source screen for when I went full screen. So I was still listening to it, but you guys weren't. It was just me partying. Okay, well, I'll add it in post. Be like it never even went wrong. Gotta watch your chat. Chat knows all.
And that should have been a mirror of the relative physical capabilities of the parties.
I do see that.
Other than that, I saw the he, she bracketed still.
I fixed that on page 16.
Then it's just that one, I think, that Mr. Henderson and I noticed.
Okay, all right. I can have Madam Clerk start fixing them here.
Yeah, so what I have to learn there is just because I have a bunch of this is too much behind the scenes. I have a bunch of templates set up for my screen, but my music is a pre-show thing that I don't expect to be doing during the broadcast. No, but never mind. I had two different worlds collided there, and I thought in my headset they combined. In your universes, they were completely divergent and separate entities.
Yeah, I think we should proceed and get going if we can.
But they will have nothing in their hands.
Oh, and now,
That's the issue.
and thank you, Hairball Yarn. So I had to turn down the courtroom because the music was so freaking loud. And now the courtroom is quiet. So I'll go back to full volume and rewind you the appropriate amount of time so that everything is just like we didn't screw all that up. Happy birthday to you. Ba-da-da-da-da-da.
Force,
Page 12,
there was a couple strike-throughs with the use.
I saw.
However, there was also a mistake with leaving a paragraph about reputation in at the very end of 3.6G, and that should have been a mirror of the relative physical capability.
So they're talking about 3.6G. That's
do
where
see
we
that.
left off. So this is, yeah, we're back and rolling at 100% again.
That, I saw the he, she bracketed still.
I fixed that on page 16.
Then it's just that one, I think, that Mr. Henderson and I noticed.
Okay, all right. I can have Madam Clerk start fixing them here.
Yeah, I think we should proceed and get going if we can.
But they will have nothing in their hands.
All right, well,
That's the issue.
all right, let's face that one, Dave.
Sorry. All right, thank you. Just give us a minute to fix all this. Yes, be fabulous.
That would be fabulous. Do you want me to turn down the audio? That also would be fabulous. Welcome to the 100th member of the live chat.
And just so that I'm clear, back on the record, we're referring to the bottom of page 12, 3.6G, paragraph 2, where the use is struck through, correct?
Yes, sir.
4 people leave as soon as I say
And then
welcome
we're
to the
referring
100th.
to the top of page 13 as to that 2 lines as to reputation. Is that correct?
Yes, sir, that should be physical capabilities paragraph or sentence.
Let me pull back up to 3.6G inspection.
And as you'll see in the bottom scroll, I've updated that we're almost done. How much charging conference do we have left? You know, about 20 minutes. And then after that, we have the actual delivery of the jury instructions, which itself is 20 more minutes. Then we get into Mr. Catatouri's closing argument. I'm going to go full screen. I'm going to be as small and in the corner and just let that play out in its entirety. We may do a couple of rewinds at best, but yeah. So we're not far. You've almost made it. Now, Fleetwood Mac is really tough for shorts because they don't license a lot of their music. But Gold Dust Lacquer from Fleetwood Mac reminds me of Gold Dust Woman from Hole. I could see Sarah being a Gold Dust Woman with all of her cracks filled in with Kintu Sukuroi gold.
So that reputation paragraph should be removed in its entirety, and it should be the...
It's a lesson in psychology, the welcoming at 100, because it almost lets the people who have just joined to get you to 100 realize that you're like impressed by the fact that they're there. And then they're like, oh, okay, we've got somewhere better to be. But if you play it off like it's no big deal, then it builds. But I can't help but be excited. I'm just happy. So,
Considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Suarez.
There it is. Thank you. Take it. 10, 12, and 13. Thank you.
ooh, the mock trial students got a job to do. Looks like Sarah's hair is slightly improved. Whatever was happening with the back, a lot of those strands are now assimilated in one direction or the other.
Very strange. It is not letting me copy it over, and I don't know why.
LCB, I don't think she had an art book, but in one of the body cam footage, you definitely saw a coloring book. It may have been for young adults, but yeah, there was a coloring book, and you consider coloring art. So yeah, Sarah had an art book.
Correct. Was there anything else other than that? If you find George Torres had a reputation for being a violent and dangerous person, you may consider this fact in determining whether he was the initial aggressor. Anything else that needs to be added to the jury instructions from the state side of the ledger?
Well, the reputation should be deleted.
Correct, I agree with you, yes. I'm sorry. What the heck is going on here?
What the heck?
No reputation, Judge?
That's correct.
No reputation, Judge.
What does that state exactly? Is that
Oh, Owens has got his poster boards.
Mr. J, was there another line that we had added to the end of that?
I don't believe so. The physical contact sentence is where it should be.
Okay. Maybe that's what I was maybe that's what I was thinking of. So the sentence should read, in considering the issue of self-defense, you may take into account the relative physical capabilities and capacities of Sarah Boone and George Torres. Is that correct?
Yes, sir.
All right, thank you.
36F.
Correct. It matches 36F now. I apologize. I'm going to have Madam Clerk, I'll email it to her now, have her print out pages, 25 copies of 12 and 13, and we'll start taking apart our jury instructions and re-adding them. And I thank you for your patience. 12 and 13, that's it.
Lots of paper shuffling. Sarah's sitting there thinking, shuffling papers all trial. I could be helping you shuffle. Great paper
Mr. J, are you
shuffling.
going to be utilizing the verdict form in closing?
I am not.
Mr. Owens, are you going to be utilizing the verdict form in closing?
I may, where is it going to be at your bench?
Yeah.
I'll ask you for it if I need it.
Very good, sir. Thank you.
Judge, and, when you get a chance.
No, go ahead, sir. I can multitask.
I know there's a mic here. I know there's a mic right here.
I will
Mic
confirm
test.
with court admin that that microphone is on. I believe it is. They turned it on during openings. I'll confirm now.
Well, good that you're doing your mic tests. I appreciate that, Court.
And then, Judge, last time I used this fingerprint table as my podium,
That's fine.
I may just slide it back so I'm.
That's fine, sir.
And then, Judge, I've got 2 tripods. And I've got some demonstrative aids. One is this, it was originally a quote by Dr. Michael Brannon.
Judge, objection.
Okay, may proceed. What are the other enlargements, sir?
It's it's the one I tried to get in.
I hear no
an
objection.
opening, which was the justifiable use of non-deadly force.
No
No
objection.
objection.
Those two.
You bring in those stupid posters. Don't worry.
Remember my reasonable doubt? I was using it for.
You've seen them?
I
Okay.
had no objection to those 5. I didn't like the 3 charts. The defense agreed that we found reasonable doubt charts they won't use, so I think we're all good on your charts.
All right, very good.
And the only other thing I want to
Yeah,
use.
Mr. J has plans for those posters now. He's not going to object.
During closings that we were used during trial.
Okay, very good.
I've got 2 videos that I'm going to want to play, and Shelby Andrews is going to walk up.
They're in evidence, right?
They are.
Yep.
Okay,
One of them's been pared down.
One of them's
That's
been
fine.
pared down.
as long as it's in evidence, you can present whatever you'd like.
And Judge, I don't Do you want to talk about time for closing?
We can. What do you think, State? You advised an hour and a half.
Yeah, I think we both said hour and a half, but as the court knows, you can't really hold us to it until it gets a little ridiculous.
How much do you anticipate, sir?
Well, Judge, she's charged.
That's an interesting quote. As the court knows, you can't really hold us. Okay, I'll go back to it. So the court asks, what do you think, State? You advised an hour and a half? Yeah, but I think we both said an hour and a half. But as the court knows, you can't really hold us to it unless it gets a little ridiculous. You can't say, hey, hour and a half.
We've had a 2-week trial. I've got a lot to say. I've got a lot of notes.
We're good, let's go.
Say again?
I'm not hearing any,
Okay. The only
stammering.
thing
We're good. Let's go. Mr. J. It's almost like a couple of fighters in the octagon, and Owens is still like trying to hammer out points of his contract, and Mr. J's over there like, come on, let's go.
I've got a lot of notes.
We're good, let's go.
Say again?
I'm not hearing any,
Okay.
stammering clamoring from the state.
After the state has had their first opening, give them a
Agreed.
short break, and then let me start.
Agreed. We'll take our afternoon break at that point in time, then we can proceed
Oh,
with
here
the
we
defense
go.
closing and then rebuttal. I have received approval from the chief to work after 9 o'clock.
Let's get
So
ready to rumble.
We can go till about 10, maybe a little bit thereafter.
And
So-
then you're saying with the jury? And
Correct.
then at 10 o'clock, if we hit some number, 10 or 11, then we would come back Monday?
That's correct.
Oh, and here comes a slight sidebar, which is interesting because they've got no jury, so it must be just something they don't want the gallery to be hearing. Have they already called it? No. I can start reading it right now, but so he's going to ask the parties to approach. Mr. J says, is this us? Court says, yeah, but I got something to go over with you. In my haste to print this out, I missed the second for use up there. So if the parties are acceptable for the copy for the jury, just taking a permanent marker to it and excising it. Mr. J says, yep. Court says, in lieu of reprinting everything out all over again. Yeah, Mr. Owens, yep. Court says, okay, I take full responsibility for this. Mr. J says, we're good. Mr. Owens says, Judge, you're doing great. Little sucking up just before the end. Judge, you're doing great. Court says, thank you. I appreciate you guys. You need to make good on your copies, or you already know? Mr. J says, I'm good. The court says, okay, awesome. I'll do that on here. Thank you very much. So that just must be him proofreading it right now and noticing there's one little part with for use that isn't there. Okay, so let's see what else is going to happen as I look ahead. Jury's going to come in. They're going to recognize the jury. And then we'll get the jury instructions. So that'll be last chance, make yourself a snack. Do everything you need to do to get comfortable. He's going to read everything they've just discussed in the last 2 hours. And then 20 minutes after that, Dave Catatouri will be getting started with This is a Box. Switch to this while we're waiting for them to get their shit together here. Bell73 says, these sidebars are too fun. Thank you, Dan. And thank you, Bell73. Yeah, it's much more fun for me to be sharing them with you as they happen too. I read the beginning of it to see that the concept would work, and then I left the transcripts to be as much a surprise to me as I'm reading them as they are to you hearing them, so that we can all enjoy it the first time together. I know of like 3 of them from Guilty Words, but they weren't in the context of what happened in the trial. They were just, they've cut out the audio. First, they cut out that side, but then this side dropped too. I guess it is a lot of chit chat. This must be where they're going to that conference, the sidebar that I read out. We'll add some audio from Mr. Dave Catatouri.
And deep breath out. Let's lift the left leg up. Step it through. Virabhadrasana A, just for a moment. Deep breath in. Deep breath out. Coming into that Virabhadrasana B, Warrior 2. Again. Breathing for 1. Breathing for 2. Breathing for 4. Breathing for 5. Let's straighten the front leg. Reverse the palm. Come into that reverse extended pose. Breathing for 1. Breathing for 2. Breathing for 3. Breathing for 4. Breathing for 5. Let's bring our hands back up to Virabhadrasana. B hands at the front, upright on our mat. Let's hinge at the hips again and look forward over that left foot, and let's come into Trikonasana here on that left side.
Trikonasana, that's a great stance.
Looking up at our top hand. Breathing for 1.
And I have the courtroom audio on. There's just none of it.
Breathing for 2. You can also extend this top hand over your shoulder for an extended variation if that's in your practice. Breathing for 3. Breathing for 4. And 5. Exhale, release. Inhale, lifts you back up.
Word-wise is good too. She recently did something on Sarah.
Let's windmill the right hand inside the left foot. Come into that reverse low lunge just for a minute. Deep breath in. And let's bring the left hand by the left foot.
Oh, that's a
Extend
stretch.
the left leg high. Come through the plank. Chaturanga. Upward facing dog.
Chaturanga.
Back to chaturanga. And exhale. Downward facing dog. Deep breath in. Deep breath out. Deep breath in. Deep breath out. Let's look forward between our hands, and let's come through to a seat. And let's extend our legs forward into Paschimottanasana.
What is going on in the court?
With our feet pointing up, let's bring our hands over our head. Inhale, exhale, and let's exhale and reach for our feet. Breathing for 1. Breathing for 2. Breathing for 3.
This is just Judge Cranick proofreading his own document on their time.
For 4.
Good on him.
And 5. Let's exhale, release. Inhale, hands back up.
And then
let's bring our hands down by our hips.
Missed a page.
For Dandasana. And we're going to do a little modification of this, because in Dandasana, let's lift our hips, and you can either just lift just your
I can't do that.
Your bottom off the floor, or if you want, you can try to lift your whole body off the floor,
whole body,
just for a few seconds.
Wow.
And let's lower.
Wow.
Exhale, release. Inhale, hands back up. Fold forward. Breathing for 1.
Look at that.
Breathing for 2. Breathing for 3. Breathing for 4. And 5. Exhale, release. Inhale, lifts you back up. Exhale, hands down again for those Dandasana lifts. Exhale, release.
Wow.
Inhale, back up. Fold forward. Breathing for 1.
1,
Breathing for 2.
2,
Breathing for 3.
3,
Breathing for 4.
4.
And 5. Exhale, release. Inhale, lifts you back up. Hands again by our hips for Dandasana lifts.
Oh, I'm up.
Release.
Chair helps.
Inhale. Exhale, fold forward in Paschimottanasana.
Okay, now they're approaching.
Breathing for 1.
That's the sidebar I read. I can read that again, though.
Breathing for 2. Breathing for 3.
Well, no, we don't have to. Yeah, I'll read it.
Breathing for 4.
Okay, goodbye, Dave. Transcript. You guys can look at Sarah. I'll look at the words. In my haste to print this out, I missed the second for use up there. So if the parties are acceptable for the copy for the jury, just taking a permanent marker to it and excising it. Yeah. In lieu of reprinting everything out all over again. Yeah. Yeah. And I take full responsibility for this. We're good. Judge, you're doing great. Well, thank you. I appreciate you guys. Do you need to make good on your copies, or you already know? I'm good. Okay, awesome. I'll do that on here. Thank you very much. State, you ready to proceed?
State, are you ready to proceed?
Yes, Your Honor.
Defense, are you ready to proceed?
1 minute, Judge.
Yes, sir.
1 minute, you're on it. Yes, sir.
We're ready, Judge.
Let's go ahead and bring in our jury. Yeah, that would be fabulous. Just page 12.
Whatever Judge Kranick was just whispering about, he said that would be fabulous.
I do not. The jury. Okay, thank you.
Updated the scroll to reflect that now we are at the jury instructions prior to closing arguments soon. Hold on.
Jury entering.
I can hear her slightly. She's saying thank you and these need to be different, blah, blah, blah. I will go back. Right about there. Let's see. Full volume in the headset. It's something about just like this one. just like this. Okay. These individual.
Jury entering.
Thank you. Look at the smile. Whatever it is, she's pretty smug about something that's going to get brought up in the closing argument. She slipped into the final.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
Everyone can be seated. Thank you. Members of the jury, thank you for your patience. We had a long conversation about the jury instructions, and I missed a typo or two after I had printed everything, and took us a while to print everything out. I'm going to ask the courtroom deputy to come forward and pass these out to you. If you can, please raise your hands to confirm that you complied with the court's instructions during the break. All right, record will reflect all hands have been raised. Members of the jury, we are at the conclusion of the evidence and testimony in this case. The court is now going to instruct you on the law. The courtroom deputy is providing you copies of the jury instructions. Like I said at the beginning, you're going to be able to take these back with you into the deliberation room. There's not going to be a quiz or a test at the end. You don't need to memorize anything. If you'd like to read along, you can. If you just want to listen, you can. It's completely up to you. The court's going to read most of the instructions and then turn it over to the lawyers for their closing arguments. The state will go first, as they have the burden. Then the defense will go. And then the state will have the opportunity to rebut. Then I will conclude the instructions and release you for your deliberations. After the state's closing, we're going to take our afternoon recess. At that point in time, I'll have the courtroom deputy provide you that emergency number. So if you need to reach out into your family or loved ones to let them know that you are on the jury and are deliberating, you can do that at that time. With that, members of the jury, the court's going to go ahead and begin reading you the jury instructions. Instruction 3.1, Introduction to Final Instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give to you. 3.2, Statement of the Charge. Sarah Boone, the defendant in this case, has been accused of the crime of second-degree murder. 7.1, Introduction to Homicide. Sarah Boone is accused of second-degree murder. Murder in the second degree includes the lesser crime of manslaughter, both of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find George Torres was killed by Sarah Boone, you will then consider the circumstances surrounding the killing in deciding if the killing was second-degree murder or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual, ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such, does not include mere bruises. I now instruct you on the circumstances that must be proved before Sarah Boone may be found guilty of second-degree murder or any lesser included crime. 7.4, murder, second degree. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, George Torres is dead. 2, the death was caused by the criminal act of Sarah Boone. 3, there was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. 3.4, when there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is charged, there may be evidence that she committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of second-degree murder is manslaughter, culpable negligence. 7.7, manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, George Torres is dead. 2A, Sarah Boone intentionally committed an act or acts that caused the death of George Torres. B, the death of George Torres was caused by the culpable negligence of Sarah Boone. Yes? I apologize. Or, thank you for that clarification.
Just
Sarah Boone intent, I'll reread those for you.
Just
2A, Sarah Boone
You just missed the word or, and Mr. J pointed it out just so that it's an absolutely 100% accurate reading of the jury instructions. So back and reread the part with the omitted or included.
intentionally committed an act or acts that caused the death of George Torres, or B, the death of George Torres was caused by the culpable negligence of Sarah Boone. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty, without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Capable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. 8.9, culpable negligence. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1, Sarah Boone exposed George Torres Jr. to a personal injury. 2, she did so through culpable negligence.
If you guys are wondering about that screen right there, the piece of paper is just the jury instructions they're reading. So believe me, I did take the time to zoom in and do my research. If I had news to bring to you, I would.
Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life, or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such indifference to the rights of others as is equivalent to an intentional violation of such rights. 3.6D, as in Delta, voluntary intoxication. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. 3.6F, as in Foxtrot, justifiable use of deadly force. It is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use or threatened use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. The law on the justifiable use, deadly force, is as follows. Sarah Boone was justified in using deadly force if she reasonably believed.
This is a zoom on the Torres family. You can also see Melissa Roughgarden, the CSI, in the second row at the back corner.
That such force or threat of force was necessary to prevent imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat before using deadly force. In deciding whether Sarah Boone was justified in the use of deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself, unless 1. The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. Please silence your cell phones.
Oh, watch this. They don't.
And had exhausted every... Out. Whose ever phone is on, get out right now.
GTFO.
Members of the jury, I apologize. I'm going to read that over for you for the beginning.
We're going to
Paragraph
go
1,
back and enjoy that.
The threat of... I'm going to read... Out. Or great bodily harm.
You
Please...
see the Torres family? That's a good shot. There's Scott Lowen sitting beside the sort of top middle of the frame there. He's the first one, detective, right? Picks up the cell phone. Well, not the first. You can see the woman that is in the near foreground. She's also closer to the sound. And looks like Juan Torres is also looking over in the direction of the cell phone.
It's your cell phones.
And they can't
And
shut
had
it off.
exhausted every...
Mr. J jumps up at the second, like, oh, you didn't turn it off?
And had exhausted every... Out.
Love the look. Like Mr. J loves seeing people getting smacked down by Krennic, whether it's attorneys, whether it's people in the gallery.
Had exhausted every... Out. Whose ever phone is on, get out right now.
Even James Owens. Yeah, it wouldn't go for that Milton either.
Members of the jury, I apologize. I'm going to read that over for you for the beginning. Paragraph 1. The threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm, and had exhausted every reasonable means to escape the danger, other than using deadly force on George Torres. Or 2, in good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force. But George Torres continued or resumed the threatened use of force. Physical contact includes any restraint on George Torres's movement. If you find that Sarah Boone, who because of prior threats or difficulties with George Torres Jr., had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of George Torres, you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder, manslaughter, or culpable negligence, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres.
Judge, I'm missing page 10 and 11.
I am too.
Missing page 10 and 11.
We will remedy that. Thank you, sir. Is it just your copy, Mr. Owens?
I hope those pages weren't filed through Australia and then rerouted to New York before they got there.
Everybody else missing 10 and 11.
Sarah's looking around like, I bet she folded them into pages. She's out sorting papers. All of a sudden, you don't need 10 and 11. We'll just get rid of those. Those look bad for me. Missing from everybody's. The algorithm speculates that the phone may have belonged to a journalist. Certainly possible. They have a bit of a air of,
Yes, sir.
not me.
We'll bring it to you, sir. And we'll wait till I have those, sir, and we'll continue. Thank you.
Yeah, so for people wondering if it did seem a bit extreme, I think it was a third time.
Thank
Like,
you.
I think he's brought
Record
up cell
reflect all
phones.
thumbs were up.
He's definitely done
Page
it on
11.
one previous.
Special instruction.
And there was the time that the woman jumped up and was like, I'm the mayor of Orlando and blah, 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 and did an outburst. And he was like, I'm going to make absolutely clear, we're not going to have any of this in this case. So by now, you know, how many warnings are you going to give? This is the last day of the trial. So go. Get out.
Battered spouse syndrome. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome. 3.6G, justifiable use of non-deadly force. It is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use non-deadly force. Non-deadly force means force not likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight,
Hey, Alexa.
trivial, minor, or moderate harm.
Alexa, I'm going to try
Sarah
not
Boone
to
does
trigger
not have
anyone's
to,
Alexas.
It does
with
not
my
have the
greeting.
burden of proving that she was justified in using non-deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using non-deadly force. The law on the justifiable use of non-deadly is as follows. Sarah Boone was justified in using non-deadly force against George Torres and had no duty to retreat if she reasonably believed that such conduct was necessary to defend herself against George Torres's imminent use of unlawful force.
That was the first Miss Bless You. And it shows priorities because Judge Kranick never missed a bless you, or so I thought. But the jury instructions are that important, and he knows it. And it is one of the things that's an appellate issue. I don't understand how. It seems like everything was pretty buttoned up. But if you've got headphones on, listen, there's a sneeze, and Judge Kranick, he wants to. He really wants to bless it, but bless you is not part of the jury instructions.
Conduct was necessary to defend herself against believed that such conduct was necessary to defend herself against George Torres's it was necessary to defend herself against George Torres's imminent use of unlawful force.
The discretion. You know he wanted to. It's probably nagging at him like, oh, I didn't bless the bless. So you know, you do what you can. You try and you fight the battles you can.
In deciding whether Sarah Boone was justified in the use of non-deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use of non-deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed the use of non-deadly force was necessary. Moreover,
Michael Wang is getting over double chemo in 7 days, ass kicked. Michael, every time you see the lasers pop up in my background, that's a shout out to you. Wow. And send their energy to Mike.
a reasonably cautious and prudent person under the same circumstances would have believed the use of non-deadly force was necessary. However, the use of non-deadly force is not justified if you find that Sarah Boone used force to initially provoke or threatened use of force against herself, unless the threatened force asserted towards Sarah Boone was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using non-deadly force on George Torres. Or, 2, in good faith, Sarah Boone withdrew from physical contact with George Torres and indicated clearly to George Torres that she wanted to withdraw and stop the use of non-deadly force. But George Torres continued or resumed or threatened use of force. Physical contact includes any restraint on George Torres's movement. If you find that Sarah Boone, who, because of prior threats or difficulties with George Torres Jr., had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of George Torres Jr., you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder and/or culpable negligence, Sarah Boone knew that George Torres Jr. had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use non-deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Special instruction on battered spouse syndrome. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome.
Don't believe Sarah.
3.7, plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. 3.9, weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. 3.9 Bravo, defendant statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to: 1, whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get her to make it. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. 3.10, Rules for Deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this matter. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence in these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this.
Unless you're watching this as a rewatch and you're free to judge the lawyers. What do you think of them? Let us know in the comments.
5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. 3.11, cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. 2.7, closing argument. Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. With that, state, you may proceed.
Okay, so this is it. This is it. I'm going to give you a second. This is it. If you've been waiting all day for it to get to the closing arguments, Mr. Catatouri has just brought out the suitcase. He's laid it in front of the jury. He's going to walk over with absolutely no nonsense and say, this is a box. I don't think there's a lot of objecting during his. I'll try and keep an eye on the transcript on the side. I know there's some objections during Mr. Owens. There must be one or two, because there's a reason why they're kind of pissed off with Owens by the time Owens gets up to give his. Anyway, I think I've given you enough time to settle in. This is it. Closing arguments begin. Dave Catatouri for the state.
This is a box. This is the box where George Torres was killed. It's a small box, 28 by 20 by 8 7/8 inches. George Torres was zipped up in this box. George Torres took his last panicked breaths in this box. The medical examiner explained to us that with each breath George Torres took in, there was less oxygen in this box. George Torres was murdered in this box. Ladies and gentlemen, on behalf of myself, my trial partner, we thank you for your time and attention in this most important of trials. We now have the law from the judge in this case. This is what our duty is to follow. And let's have a discussion regarding that law that we've just been read and given. The first section of note we're going to come to is called Introduction to Homicide. But this being a legal document written by a bunch of lawyers who you've seen for the last 2 weeks arguing with each other, pay careful attention to ands and ors. Remember, if an and is somewhere, we're going to need both things or all the things, and if an or is there, then only one of those things we're going to need. So as we start out here on Introduction to Homicide, we come to the first section on Justifiable Homicide. And it reads, the killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time. Ladies and gentlemen, this section is completely inapplicable. It's inapplicable because George Torres was zipped up in that suitcase. He couldn't commit or attempt to commit a murder on anybody. He couldn't even scratch his own head while he was in that suitcase. Next, we turn to excusable homicide. Here we have several paragraphs, and it reads, the killing of a human being is excusable and therefore lawful under any one of the following three circumstances. When the killing is committed by accident, and the misfortune of doing any lawful act by lawful means, with usual ordinary caution, and without any unlawful intent. Well, the problem in this circumstance for the defendant is that she took the law into her own hands. Her testimony was that when George Torres was in here, he was laughing and giggling and they were joking. And then he started to complain that he couldn't breathe. And that's when she said that she wanted him to stay in there so he could feel uncomfortable. so he could feel her grievances. Ladies and gentlemen, that is not lawful. That is not the use of ordinary caution. And that is not applicable in this circumstance. Second, when the killing occurs by accident.
I'm not going to interrupt very much, but this is, I think, a very effective thing that he does here, how he just takes the jury instructions and is like, if this, then you can find her not guilty. You know what? No. Draws a big X through it. You know what? For this one, no. You can ignore that because of this. I think he does a really good job of setting it up so that when the jurors go in to discuss it, they can very quickly, do we agree with all those things? Yeah, no, those are absolutely, cut those out. Don't apply. None of us are in disagreement on that. It's so clear. And how clear it is only becomes clear to us when you see how opaque and greasy Owens' argument is when he steps up. It's such a contrast.
Or misfortune in the heat of passion upon any sudden and sufficient provocation. George Torres couldn't provoke anything from his circumstance. George Torres was confined to this box. Next, when the killing is committed by accident and misfortune resulting from a sudden combat, a dangerous weapon is not used.
There's another sneeze not acknowledged by the judge. It's like, no, stakes are too high. So the contrast is very high, just so you know, on the screen that he's referring to, that flash of whiteness, it's the jury instructions that were just read and explaining the different sections. Occasionally when it zooms in, you can see the text, but that's what Dave Catatouri is referring to here.
The killing is not done in a cruel and unusual manner. This fails on 2 counts. There was no sudden combat. In her words, this was laughing and joking and we're all having fun when she decides that it's going to get a little extra real for George Torres. And it fails on the 2nd count because George Torres was killed in a cruel and unusual manner.
Absolutely.
Next we turn to our main charge of 2nd-degree murder. And the law informs us that to prove the crime of 2nd-degree murder, the state must prove the following 3 elements.
My apologies, but my big thanks goes to Michael E. Wang, who has gifted 5 more memberships to Dandy True Crime. The recipients of this is No Thanks, okay, Door, 2413, Claire in Maine, Swifty Sarah, and Stephanie Poston. So if your name is Stephanie Poston, Swifty Sarah, without an H, just Swifty Sarah, Claire in Maine, Door 2413, or No Thanks, okay, you've all received a membership to Dan D True Crime, courtesy of Michael E. Wang. Thank you very much.
Beyond a reasonable doubt. I think it's important to stop.
I'm going to go back 10 seconds.
Murder, the state must prove the following 3 elements beyond a reasonable doubt. I think it's important to stop right here. This sentence right here is telling us what...
We're going to take one more interruption because Kelia has noticed her badge has turned into LWAP. So she's graduated from the Pro Se C to Pro Se to LWAP. And I think that's the natural progression, right? You go from Drunky the Bear to the Bloody Keyboard stage, and then you become a Pro Se. And eventually you're going to end up with LWAP, which is where she is now. I have to figure out what the next evolution of Sarah is, if anyone sticks around for a year.
In order for the crime of 2nd-degree murder for the defendant to be found guilty.
Addie's me celebrating her LWAP.
We've been hearing
Yellow badge for
all
you.
kinds of facts for almost 2 weeks now of trial. But these are the 3 facts that had to have been met.
I'm sorry, through all those celebrations, we'll just give Mr. Catatouri back a minute of his time. Let him get his flow, because it's much more important that we catch everything he's saying than it is that with Mr. Owens, who, that's funny because he falls out. We don't hear every word he's saying. I'm going to have to use the transcript to bring it all in. But yeah, we'll go back a minute and let Mr. Catatouri keep his yoga flow.
And the law informs us that to prove the crime of second-degree murder, the
Final interruption for this, or at least for now. Happy birthday to all the Leos. Any Leos that are out there that are having a birthday today, yesterday, tomorrow, right up into the 22nd, maybe even 23rd if you're on the cusp. Happy birthday, Leos.
state must prove the following 3 elements beyond a reasonable doubt. I think it's important to stop right here. This sentence right here is telling us what has to be proven in order for the crime of second-degree murder to be, for the defendant to be found guilty in this case. We've been hearing all kinds of facts for almost 2 weeks now of trial, but these are the 3 facts that had to have been met by the reasonable doubt standard in order to be found guilty. Ladies and gentlemen, I submit to you that the state has proven second-degree murder beyond all doubt. And the proof of that guilt is overwhelming. But I will cite for each element just one fact that conclusively proves each of those elements beyond all doubt. As to the first fact, that George Torres is dead, well, we have stipulation, amongst other things.
So we have fact 1.
To that. As to the second fact, the death was caused by Sarah Boone. Sarah Boone, in her own words, from the time that this case began on February 23rd, 2020, to when she took the witness stand a few days ago, was consistent about one statement. She zipped him up. She didn't zip him out. She zipped him up in the suitcase, and she refused to zip him out. 3, there was an unlawful killing of George Torres by an act imminently dangerous to another in demonstrating a depraved mind without regard for human life. The law goes on to define for us what a depraved mind is, and also what an act is. And it's going to tell us that an act includes any series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another in demonstrating a depraved mind if it is an act or a series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself displays an indifference to human life. Ladies and gentlemen, her conduct fits every one of those things. And if there was a scintilla of doubt that this was not the actions of a depraved mind, I point to you, IMG 1062. It states 17. Mr. J, may you publish? States 17.
Shallow. For everything you've done to me. Shallow. For everything you've done to me. Shallow. Fuck you. Shallow. Fuck you. Shallow. Stupid. Shallow. That's my name. Don't wear it out. I can't fucking breathe, babe. Seriously. Yeah, that's when you do me, choke me, Cheryl.
I think that's the sound in the courtroom because there was the approach. Must have been because of Torres crying. Video is still playing. Transcript. Catch up myself. Okay, that's Mom Torres leaving the courtroom. She knew that the video would be shown, but she hadn't seen it before, and thought that she'd be able to watch it in court and couldn't. James Owens really makes an ass of himself, getting all bent out of shape by the interruption. Because it's not even his, it's Mr. Catatouri's presentation. It's not like it's his presentation. That's what's happening here in silence. Time to scroll the transcript to get to, because they are going to move up to talk. Okay, let me just pause the actual, because they have been up there talking. They just immediately went to silence because I guess part of the transcript. I wasn't quite ready for that happening, but now we're ready. Up. And let's read. At the bench. Please ask the jury to go out. She's weeping and crying. I'm going to ask for a mistrial if she's not allowed. If the jury is not allowed to go out. Court, hang on. Mr. Owens, hang on. Mr. Catatouri, I don't think we need to do that. Just give me the opportunity to go over there and ask her to step out of the courtroom. Mr. Owens, hell no, no. She's bellying over, crying, sobbing. Hell no. I'm going to make the transcript bigger. Oh, Sarah's, so you can see her. Start the video. She's leaving, says Mr. Catatouri. Oh, no, okay, so Mr. Owens. Hell no, she's bellying over, crying, sobbing. She's leaving. Judge, please let the jury go out. She's leaving, says Mr. Catatouri.
You may continue.
Okay, hold on. No. That will be okay. She's leaving. The court says, go out. Mr. Catatouri says, they don't need to. Mr. Owens says, that's highly prejudicial to my client for that to be happening in front of the jury. Court says, she is gone. Thank you, says Mr. Owens. Anything else, Mr. Owens? Yeah, I don't know what else other than an instruction, some kind of curative instruction, but I have to think about it. Okay, well, think about it. Tell me what you want to do. Can we have the jury go out for a minute? No, I don't want to do that. Mr. Catatouri, no, not. The court says not in the middle, not right now. Mr. Catatouri says, I mean, Mr. Owen, I should have asked, Judge. It's probably my fault because I should have said, because a lot of times the judge will say, anybody in the audience is going to have an adverse reaction, yeah or nay, sad or glad, whatever the case. You're going to show some kind of physical or audible reaction, you need to leave the courtroom now. Court says, but I don't want to bring any more attention to it than is necessary at this point in time, so I'm hesitant to give that instruction to highlight it. I don't know if the jury saw it. I don't want to point it out that someone has left or anything along those lines. Mr. Owens says, just leave it alone. The court says, okay, all right, as you wish.
Sarah. Sarah. Sarah, I can't breathe it. That's on you. Sarah, I can't breathe. It's on you. Sarah. Real or ransom? Now you want to give it for it extra. Because I got this. Sarah. Real or ransom? Sarah, I can't breathe it. Oh. That's what I feel like when you jingle me. Sarah. Fuck you. I can't breathe, Sarah. Yeah. You should probably shut the fuck up. Shh.
Ladies and gentlemen, that exhibit removes any scintilla of doubt about the depravity of the defendant's actions. But we know from the evidence that this was not the first time she had considered killing George Torres. We know from the evidence that on January 13th, 2020, approximately 1 month prior to George Torres' murder, the defendant had a text message conversation. Please do something with yourself, Sarah. God bless you. And bless you and all of you too. I'll get rid of him, then I'll be better. Torres. But ladies and gentlemen, in this case, the law actually specifically tells us that the intent to cause death is not necessary. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Next, we turn. I'm going to bypass the lesser included offenses because though she is guilty of those offenses as well, the law instructs us that she is to be convicted of for the highest offense in which the evidence supports, which is second-degree murder in this case. So turning our attention towards voluntary intoxication. If there was any question about the fact that Sarah imbibed alcohol on the night that George Torres was murdered, and that maybe somehow that would excuse the conduct or be some type of defense for the conduct. Well, this tells us that that's not the case. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. Ladies and gentlemen, there's ample evidence of the defendant's intoxication from watching her on the public surveillance, buying the bottles of wine with George Torres, to her admissions to drinking, to her voice that we heard on the video while she was torturing George Torres. Next, we come to defenses. First, we come to the justifiable use of deadly force. It tells us it is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone were justifiable use or threatened use of deadly force. Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. The law on the justifiable use of deadly force is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent the imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat. Ladies and gentlemen, in a few moments, Mr. Owens will rise, and he is going to show you this. And this. And this. And he's going to talk in this as well about the list of grievances that Sarah Boone had for George Torres. he's going to talk to you about curtain rods.
He's so disdainful when he throws it to the ground, just like.
He's going to talk to you about black eyes. He's going to talk to you about what an awful, awful boyfriend George Torres was. And ladies and gentlemen, at the end of all of that, it still will not change the fact that the defendant is not entitled to the justifiable use of deadly force. Because as we continue to read this instruction, it tells us, in deciding whether Sarah Boone was justified in using the use of deadly force, you must consider the circumstances at the time the force or the threat of force was used. Danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed that deadly force was necessary. Moreover, to justify the use of deadly force, and this is important, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. Ladies and gentlemen, no reasonably prudent and cautious person would believe that a man who could barely fit into this box, who was incapable of movement, who was begging for his life, who was slowly asphyxiating, suffocating with each breath, would have needed to use deadly force against him. The justifiable use of deadly force utterly fails, utterly crashes like a house of cards. But there's more. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself. Let's stop there before we consider the next two paragraphs. Some of the most critical testimony in this trial is her testimony on the stand. It was a great day. We were doing puzzles and artwork, dancing with the dogs, listening to music. Tag, you're it, hide and go seek time. George gets into the suitcase. She comes and zips him up. They were still laughing about it. We're still laughing after he's zipped up in the suitcase. And then that's when George had the temerity to ask, George Torres had the temerity to ask to be unzipped from the suitcase. And that's when Sarah Boone decided he needed to suffer. She was the initial aggressor, ladies and gentlemen. She provoked the use of force in this case. In her own words, we were laughing and playing right before he wanted to be let out because he couldn't breathe. Paragraph 1. The threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on George Torres. He couldn't exert anything, ladies and gentlemen. George Torres couldn't even exert his arm out of the suitcase. How on earth could he have exerted a force so great to justify his...
Judge, I object.
Approach.
Oh, okay. I wasn't ready for this either. I think this is what he's doing to endear himself to the state. Okay, let's see. Look up Judge, I object. Okay. Find what they said. Apologies for the delay, but you can blame James Owens for it.
Judge, I object.
He exerted a force so...
Exerted a force is what I'm looking for. All right, found it, and we'll let it play while I read.
Great.
Oh, hold on. Get it up
To
on screen
justify...
for you too.
Judge, I object.
Approach.
That's a misstatement of facts. He could not exert his arm out of the suitcase. Court, it's an argument. It's a closing argument. It's a misstatement of the facts. Only testimony in this case is that he reached his hand out of the suitcase. Correct. There's no testimonial evidence that he did not. Okay, hang on. Response? Mr. Catatouri, an arm is not a hand, and your client gave several versions of events to include only fingers, so court says he's correct. There were different versions, as reported by experts and Ms. Boone, Mr. Catatouri, but there has been zero testimony that an arm ever protruded from the suitcase. The court says response, if anything else. Mr. Owens says, we all heard the testimony that his hand came out of the suitcase. Court says, right. Mr. Catatouri, a hand is not an arm. The court says, I agree. I think it's closing argument. There's a fact in the record for him to argue it, so your objection's overruled.
This is of no help to the defendant. Second paragraph. In good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force, but George Torres continued or resumed the threatened use of deadly force. Ladies and gentlemen, George Torres never got a chance to do anything. George Torres never was able to mount any aggression towards the defendant. Therefore, this paragraph is inapplicable. And the law tells us as well that physical contact in this case includes any restraint on George Torres's movements. The law also tells us, again, you find that Sarah Boone because of prior threats or difficulties with George Torres, had reasonable grounds to believe that she was in danger of great bodily harm, of death or great bodily harm at the hands of George Torres, you may consider this fact in determining whether the actions of Sarah Boone were reasonable. Now we're going to get to battered spouse syndrome in a moment. But again, I submit to you, this will be the opportunity for the defense to air grievances in regards to George Torres. But again, those grievances will not change the law, and they will not change the fact that the justifiable use of deadly force fails as a defense for the defendant. If you find that at the time of the alleged second-degree murder, manslaughter, culpable negligence, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Considering the issue of deadly force, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Now we come to the special instruction on battered spouse. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find Sarah Boone suffered from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether, in Sarah Boone's circumstances, would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony in regards to battered spouse. Ladies and gentlemen, we heard from 3 experts in the areas of battered spouse. In this case,
Dr. Julie Harper, Dr. Tanya Werner, and Dr. Michael Brannon.
I think at the outset, it's important to note what battered spouse is and isn't, and what the law instructs us here. Battered spouse is not some carte blanche. Battered spouse is not a license to kill. The fact that George Torres at points mistreated Sarah Boone, did things that were worthy enough to get him arrested, to get restraining orders placed upon him, doesn't mean that she walks around with an ace in her pocket when it comes to George Torres. It doesn't mean that because he did these awful, bad things, that now, through the rest of time, she's a battered spouse and she just has the right to kill him, or to make him suffer, or to punish him, or to make him feel uncomfortable, or decide that he needs to be confined to a box. No. What the battered spouse syndrome instruction does, it talks about the imminency of fear. And when we heard about that testimony, we heard about it from Dr. Harper, and we heard about it from Dr. Brannon for the defense. And some of the testimony was a little difficult to understand at points, but there was one point in Dr. Brannon's testimony that was very critical.
I thought Dr. Brannon was great.
Talked about rule-outs. He talked about the fact that when emotions and emotional reactions are involved, like trauma and trauma-based disorders, other possibilities have to be ruled out before we can even ascribe those actions to battered spouse syndrome. Other possibilities, according to Dr. Brannon, include alcohol abuse. Dr. Harper should have listened to Dr. Brannon's testimony, because Dr. Brannon completely undercut Dr. Harper's testimony. Dr. Harper relied heavily on the words of the defendant, who was abusing alcohol at the time of these events. And then you heard from the expert for the state, Tanya Warner. In her opinion,
I'm going to let that play one more time. That was a pretty key little paragraph there. Time without bells.
Dr. Brannon completely undercut syndrome. Other possibilities, according to Dr. Brannon, include alcohol abuse. Dr. Harper should have listened to Dr. Brannon's testimony, because Dr. Brannon completely undercut Dr. Harper's testimony. Dr. Harper relied heavily on the words of the defendant, who was abusing alcohol at the time of these events. And then you heard from the expert for the state, Tanya Warner. In her opinion, was much more straightforward. Remember, Dr. Brannon did not render an opinion as to whether or not she suffered from battered spouse. Dr. Warner said affirmatively, yes, I believe she did suffer from battered spouse syndrome. But she also applied what Dr. Brannon was talking about. Other possibilities have to be ruled out as the trigger for a behavior, for an event. So, in Dr. Warner's estimation, the fact that at the time of this incident, they were laughing and joking and carrying on, meant that the trigger was not domestic violence or some threat. In the defendant's own words, the trigger was him wanting to get out and her being reminded of the bad things that he had done to her. That's not imminence of fear. That's reminder of bad things a person has done. And again, even if you were to believe that she was battered spouse triggered at the time of this event, it still does not save the day. Because all the battered spouse trigger law tells us is that it goes to that imminency requirement. It doesn't say there's no imminency requirement. It doesn't say that, look, if you're suffering from battered spouse and you're triggered by battered spouse, then, hey, there's no more imminency requirement, do as you wish. It just gives the ladies and gentlemen of the jury another thing to consider in determining whether or not that threat was imminent. And we know from the evidence, we know from the videos, there was absolutely no threat. And we know there was no threat because George Torres never got out of that box. He was never got out of that box until sometime on the early afternoon of February 24th. Mr. J, can you please publish from stage 21?
Oh, this one's sad too, yeah. Hostage video. California Dreamer, we will be doing complete closing arguments, so Mr. Owens close and state rebuttal close before this stream is complete. And welcome to the stream.
I'm going to go to court and I'm going to tell the judge, listen, my fiance has nothing to do with this. It's all my fault. We were both drinking and got out of hand. It's an isolated situation. It has never happened before. I love my fiance. She's a good woman. Never been in trouble in her life. She has a 7-year-old son that she loves and cherishes.
A blind Boston Terrier.
She has 2 dogs. One is blind, one is deaf. She goes around and she's driving and sees an animal that's injured. She'll stop in the middle of the street, no matter what kind of traffic it is, just to make sure that that animal doesn't get injured any more than what it already has. We both love each other. We both live together. Yes. Every relationship has their arguments, but we are not the type of people that you guys are portraying us to be.
She especially.
Especially her. So please, if you can, dismiss this case.
Closed.
Drop it. She is not the type of person.
Good person.
Great person.
Angel.
Not an angel.
I know she'd be an angel. She's close to it.
That's my favorite part of this video. It's so sad, but I love the fact that George, even in a place like this where, you know, he knows that he's got to read from the script, Sarah says, well, he says, nice person. Sarah interjects with, you know, up at angel. I wouldn't say angel, but, you know, nice. Anyway, I'll let George speak for himself on this, but that's just one of my favorite moments in this is just George like, I'm not going to call you an angel. Like, we both know. Both know.
Drop it. She is not the type of person.
Good person.
Great person.
Angel.
I know she'd be an angel. She's close to it.
Best thing that has ever happened to you.
Yes, ma'am.
Best thing that's ever happened to you.
And I love you.
Yes, ma'am.
And I hate that we're going through this right now.
Sonnet.
What?
And they could.
Good, I love you, baby. Wherever you want me to say. God will prevail, and He will take us out of this situation. Love you.
Clearly, George Torres is dominating the defendant. Clearly, George Torres is the one telling the defendant what to do. Clearly, George Torres is the one calling the shots at 4748 France Lane.
France Court.
Ladies and gentlemen, are we so sure that George Torres wasn't the person suffering from battered spouse syndrome? Next, we're going to come to the
Yes, hairball
justifiable
yarn.
use.
Hairball yarn. I'm just going to interrupt quickly because there's a comment where Hairball says that's sarcasm, right? And I think a little of Mr. J wore off on Dave Catatouri because he's taking the chance that on the record it says clearly that's her dominating him. Clearly that's her. But it's I think the juxtaposition between that and reality is going to stand so stark on the page that he's not even afraid of using a little sarcasm here, because the jury's going to go back and, oh yeah, remember that clear dominance. Poor Sarah sitting there being dominated by him, saying every word she told him to say.
The language in the arguments are pretty close to what we've already heard in the deadly force instruction, including the key language that it requires a reasonably cautious and prudent person under the same circumstances would have believed the use of non-deadly force was necessary. Ladies and gentlemen, I submit to you that this was not a case of non-deadly force. George Torres lost his life as a result of these actions. We have heard the testimony of Dr. Sarah Zadovich, who described his cause and manner of death, who described the mechanism of death, how that oxygen dissipated in that suitcase. And when we also look at the imminency, we heard in opening statements by Mr. Owens that, the big threat in this case, the awful threat, was in the magic 9 minutes between the video at 11:12 that she took, torturing George Torres, to her follow-up video at 11:23, after she had moved the suitcase. Mr. J, that you publish from States 17, IMG 1063. It was a short video. Well, what's one of the things that we notice by this point? You can hear how loud George's voice is on the 11:12 video. But now, roughly 11 minutes later from the time that that started, we see that the makeshift coffin that he's in has been moved, and his voice now is softer. The life is draining from George Torres, and it's evident in that video. And that, ladies and gentlemen, is evidence that there was no threat in the magic 9 minutes that was not recorded. There was only George Torres in this box, slowly being killed. Next, we come to weighing the evidence. This instruction tells us it is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted as well as what they said. Some things you should consider. Did the witness have an opportunity to see and know the things about which the witness testified? In focusing on the defendant, absolutely. Two people walked through the front door on the evening of February 23rd, 2020 at 4748 France Court. George Torres and Sarah Boone. But only Sarah Boone ever walked out of that front door alive. Did the witness seem to have an accurate memory? This is an emphatic no. And the litany of her intoxication in versions of events is evidence of that. Was the witness honest and straightforward in answering the attorney's questions? I would submit to you she wasn't. 4, did the witness have some interest in how the case should be decided? Clearly. Does the witness's testimony agree with the other testimony and other evidence in the case? And I would say largely no. Because on the issue of whether or not George Torres could have threatened her the way she says that he did, the answer is clearly no, and we know that from the forensic data. We know that from the items itself. witness at some other time make a statement that is inconsistent with the testimony he or she gave in court. In regards to the defendant, it's almost more appropriate to ask about the time she did make a consistent statement. You listen to her version of events on the 911 call, on the body cameras, on her first interviews with law enforcement, and then you hear her in her next interview the next day with Detective Kopsel and Detective Lowen, and more details come out. Things change. First, she was never intoxicated, then she was intoxicated. Then there's just the whole fact of she omits the fact of, oh yeah, he was actually trying to attack me. Oh yeah, I was in fear for my life. When she said at every turn, no, it was just a great day. We were having fun. Oh my God, I can't believe this. We were doing good. The only stress we had was about jobs. And now, 4.5 years after the fact, it's time to come up with a new story. But ladies and gentlemen, I submit to you that the truth does not change. The facts do not change. The videos do not change. And on any version of events that the defendant has given, they all add up to the fact that there is absolutely no doubt that she is guilty of murder. I ask you, ladies and gentlemen, do you have any doubt about the defendant's guilt when she described using that baseball bat to hit George Torres's fingers back in the suitcase when he attempted to save his life? Do you have any doubt when she is given how many versions of events in this case? Do you have any doubt after hearing the testimony of her neighbors about the loud crash and the arguing that night? Do you have any doubt after hearing the testimony of Dr. Sarah Zadovich? Do you have any doubt after watching the videos of George Torres being murdered and her laughing about it and talking about the fact that he cheated on her? Do you have any doubt after reading the text messages from her phone? After seeing the videos of how she controlled and manipulated George Torres? And if you say, Mr. Catatouri, I still have a doubt, well then the law asks you, is that doubt to an element? And is that doubt a mere possible doubt, a speculative, an imaginary, or a forced doubt? I submit to you the idea that she had to do this because she was a battered spouse is an imaginary doubt. It's a doubt born from the imagination of Sarah Boone. It is not a reasonable doubt. But if you find yourself back in that deliberation room, and you are just trying to think of some way in which the defendant is not guilty, just searching, struggling for that way, that also is not a reasonable doubt, ladies and gentlemen. That is a forced doubt.
No forced doubt, please.
Ladies and gentlemen, I'm confident that when you read the entirety of those jury instructions and apply the law to the facts that came out in this case, that you are going to come back with the only lawful verdict, which is guilty as charged, second-degree murder. Thank you.
All right, with that, it's 4:04. Members of the jury.
Members of the jury, it is 4:04. As I promised, we were going to take that afternoon break before the defense proceeds with their closing argument. You're going to leave everything behind. Similar instruction that I've given you before. Please don't conduct any independent investigation, research as to the person, places, thing, or charge involved in this case. And do not have any discussions among yourselves or anyone else. We'll bring it back in about 15 minutes. Thank you very much.
So we'll come back in 3 minutes. I'm just going to put on an intermission song for you, and if you need to go do anything, now's the time to do it. Okay, looks like that's playing for you too. We'll be back in 3 minutes. Court's getting back in session in 15. We're just going to leave the screen live.
Okay, may proceed.
Oh, hold on.
Sarah Boone's entitled to a fair trial.
Whoa.
I think that right.
Okay, this is happening now. Come right back. I don't know where you went, but James Owens is taking the time now to get upset about that outburst during Mr. Catatouri's statement. So, jury's gone. Let's hear it, Mr. Owens. What do you got to say?
I've got a motion.
Okay, may proceed.
Sarah Boone's entitled to a fair trial. I think that right has been compromised here today. I don't know who's scheduled to put the two detectives on the front row with the Torres family, the family of the victim. But they had to have known to tell them that the suitcase video, which has been around for 4.5 years, was going to be played during opening statement. And the state attorney's office or the sheriff's department had to advise them, or the victim's advocate had to advise them, that if they couldn't take it in front of a jury that's trying to decide the case, they needed to get out of the courtroom. Now, what happened here today should not ever happen.
Oh, lecture the court. That's going to go
There should
well.
be safeguards in place. There's no room for this after 2 weeks of a murder trial for something like that to happen. One of the Torres members of the family audibly, during the 2-minute suitcase video, expressed some kind of emotional reaction. I look back, he or she were bent over in agony, physical pain. The physical pain followed the audible announcement. You can't unring that bell. That's their responsibility to ensure that kind of thing doesn't happen, especially when they know they're going to show a video and the family of the victim is on the front row. I've never heard of such. I asked for a mistrial.
Response.
In all
I've
my
never
years,
heard of such a request. The victim's family has a right to be here.
I'll let that go. But I never heard of such. Response. I've never heard of such a request. He says so deadpan, doesn't mock the accent, but definitely mocks the words.
I asked for a mistrial.
Response.
I've never heard of such a request.
I've never heard of a video and the family of the victim is on the front row. I've never heard of such. I asked for a mistrial.
Response.
I've never heard of such a request. The victim's family has a right to be here. They were advised as to what will be used during closing arguments. I cannot make a decision for the victim's family and the homicide survivors as to whether or not they believe they can handle it. She clearly, or he, I don't know, couldn't, and I believe the appropriate thing was done. They left the courtroom. But again, to say this is intentional sabotage and all the accusations that continuously get made are unsubstantiated. And it does not warrant a mistrial. People get warned, and sometimes they misjudge their own emotions. I don't understand what test we are expected to run on homicide survivors. So the motion should be denied.
Motion's denied.
Motion should be denied. Motion's denied.
Jury's going to be back in about 13 minutes, Counselor. So we'll reconvene at that point in time.
Could the state put the suitcase back in the water?
Yeah, can we clean the well from the state's materials, please? Thank you.
Agreed. All right, we're going to take a quick break. Court's going to be out of session for 15 minutes. We'll be out of session for 3. This song lasts for 2, so I should be back. But if you need to go do something, we'll come back in about 2 minutes and 40 seconds for Mr. Owens. And there will be some sidebars. I'll be right back. Welcome to the stream, Dabs for Dummies, Beth Serrano, Greg Add, everybody who came in while we were watching the close. I didn't want to interrupt too much during the closing argument, so I didn't. See you soon. All right, I think we're back. Looks like we're on the seal of the great state of Florida. I'll just leave the piano vibes in the background while we get ourselves sped right back up. All right, well, let's bring it back.
We are back on the
session.
record, 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
Dave Ketchner on behalf of the state. William J. for the Florida, State of Florida.
James Owens for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Tony Henderson, Sarah Boone.
Ms. Boone is still seated at counsel's table wearing the same clothing from this morning. Are we ready to bring in our jury for the defense closing at this time? State.
Yes, Your Honor.
Defense.
Judge, I would like you to give the audience an instruction, and then if you would, instruct the state attorney to instruct whatever family members or friends of George Torres may not be in here, may not be able to hear the instruction, but may come in during the trial, so that we can try get some order.
Are there any other members of Mr. Torres's family that may be outside that may be joining us? Okay, all right, so she's left, she's no longer here? Okay, that's what I just asked. Is there anyone outside? Okay.
She's outside, but she's not coming back in.
Okay, all right. So, members of our gallery, good afternoon. I'm going to please ask you to please contain yourself and not to have any emotional outbursts. We had a minor one, and the person, whoever it was, had a small outburst, then hid next to another family member, and then excused herself during the last during the closing. It seemed to be minor in nature. However, I'm advising everyone that at this time, if you believe that you cannot control yourself or your emotional responses during the defense's closing argument or any rebuttal by the state, I'm going to politely ask you to excuse yourselves at this time. All right, thank you very much. Mr. Owens, anything else, sir?
No, sir.
All right, state.
Ready?
All right, let's bring back in our panel.
Oh, there'll be a delay. They're taking more time to make their selections for dinner.
Okay, thank you. All can be seated. They're making their dinner selections. We'll just give them a couple minutes to do that. Thank you.
All right, so dinner selections means we can hear the rest of Running Errands by Track Tribe. Funny that they're spending the time to pick dinner and Sarah's doesn't get her snacks. There's Chelsea Capsule out on the end there. Looks like Scott may be outside but talking to Mom Torres. Hey Mandy, welcome to the stream. We're just taking a quick break while the jurors decide on what they'll be having for dinner. It's a choice that they want to deliberate on. It's not like deciding whether Sarah's guilty. They can do that in a snap, but this is their last night to get a free meal. Jury compensation's a little light. I think tonight's steak and lobster night for the jury. None for you, Sarah. That hair's looking bad. Bit of a drowned rat quality to it. I hope one of them's getting like a nice medium rare steak, some McPotatoes. Oh, don't get it twisted, Margarita. I don't dislike her for her short hair and excellent handwriting. I love her handwriting. I hate that hair. Hate that hair. And I don't have good hair. But, you know, my hair is just kind of free. It does what it wants. I don't get in its way as long as it stays. I figure if I start making rules for my hair, it's just going to abandon, vacate. And then I'll have no hair. So I let my hair do what it likes. Sometimes I cut it. We will save that. Ooh, that's got some funk to it, though. That's Back Scratcher. We might finish the stream with Back Scratcher. Save that queued up. Are they not back from lunch? Well, fuck it. Let's have a little Back Scratcher while we wait. This is a little bit more funky than I normally would put on the stream, but here we go. you're just joining us, we're waiting for the jury to decide on their dinner. Normally I'd skip ahead, but now that we can sit and watch Sarah and know that she's sitting there waiting for her life to be decided on by a bunch of people who are taking the time to decide on dinner, kind of nice. Little Sarah stew. We're listening to Back Scratcher by Alex Hamlin. This is available in the YouTube audio library. This is free. We've got a few people who like their horny music out there. Are they still not back? I'm letting it play, don't worry, I'm not just... Every second I'm enjoying this is Sarah hating her life. You notice I've got the trumpet blaring right into Sarah's ear. That's intentional. I think the deputies relayed that they've made their dinner order. We'll get right on it. Let's get court back in session. That was Back Scratcher by Alex Hamlin. And we'll be returning to our regularly scheduled court. Let's just take this trumpet right off the screen. Boom. Goodbye, trumpet. Hello, court romantics of James Owens. Let's see what happens here. Making their dinner discussions. Okay, Mr. Owens comes back to say, Judge, did you check to see if this was working? This speaker that comes straight down? Yes, those have been operational since we started closings. Yes, sir. I got confirmation at 2:17. They're operational. Thank you. Judge? Yes, sir. We just found out that they're splitting up their closing. I think Mr. J is going to do the rebuttal. Are we allowed to split up our closing? That's right. Who's handling rebuttal? William J. The court says, okay. Mr. Owens says, I don't know if that's allowed by the court. Anything? Mr. J. It's been allowed since I started practicing in 1997. The court says, if you want to split up your closing between the two of you all, that's fine by me. Mr. Owens, well, I intended on doing the closing, but when I finish, Mr. Henderson wants to say something. I may ask him to. Mr. J, I've never seen it done that way. I've understood the sandwich can be broken, but I've never seen a single closing argument split by another attorney. The court says, if it's a discretionary issue, I'll leave it up to you, sir, on what you want to do and how you want to present your closing. A pause, and the court says, yes, sir, Mr. J. Mr. J says, I would just ask that they decide who's going to be designated to object during their rebuttal argument. The court says, yeah, that's reasonable. Who would be objecting during rebuttal? And Mr. Henderson says, Mr. Owens. The court says, okay, there you go. Then the court deputy comes back. As soon as they're done, you're going to be ready for them to come in, right? The court says, yeah, let's do it. We're lining them up. Oh, that was an Owens voice. As the court, yeah, let's do it. We lining them up. Court deputy says, they said they had 2 more people. The court says, okay. There's another pause. Then they finally all rise, jury entering. Okay, I'm not going to make you guys wait any longer. Let's put on some, speed it up. Ridiculous how long they've been making her wait. This is her life. This is the rest of her natural life that we're talking about here. Got it on triple speed. And we've got the volume on, so if the volume comes on, I'll kick it right back to normal. Sarah flipping some papers. J, Mr. Catatouri taking full advantage of their chairs that do move. Sarah stuck in the green chair that does not move. Henderson getting a little fidgety. Owens folding. Oh, pointing. Look, they're ready, Judge. Whenever Mr. Owens points like that, I just think 3-point back. 3-point back. Oh, there's Mr. Beck. Mr. Beck is always the last one to the party, so Kevin Beck has entered the room. We should be getting started anytime. He was probably trying to get in a lunch order with the jury. Hey, if you guys are ordering, maybe you can get in on a 2-for-1. Sometimes they have a deal, and then I'll take your sides. Whatever you got. We're doing this. I don't know if I'm ever going to get paid by James. He says that we're going to get paid out of the old money. There's like some old money that Sarah's going to pay us with. I swear I'm not on mute. There's James Owens standing up. Oh, there we go. Hey, shh.
Been allowed since I started practicing.
Okay, perfect. So that's the part that I just read to you. The part you missed. Mr. J is just about to say it's been allowed since I started practicing in 1997. We'll go back about 10 seconds and I'll bring up the transcript for that. All right, we're back in action.
I don't know if that is allowed by the court or
Anything?
Been allowed since I started practicing in 1997.
If you want to split up your closing between the two of y'all, that's fine by me.
Well, I intended on doing the closing, but when I finish, Mr. Henderson wants to say something. I may ask him to.
I've never seen it done that way. I've understood the sandwich can be broken. I've never, ever seen a single closing argument split by another attorney.
If it's a discretionary issue, I'll leave it up to you, sir, on what you want to do and how you want to present your closing.
And this is a weird thing. I don't think he ends up getting Mr. Henderson to speak up because Mr. Henderson, you want to say your last 3 words? It could be that he doesn't want to say something that Sarah's going to have him say. And then he's like, okay, so you can get up and say that little bit that Sarah's trying to get me to say because I did the snacks motion. I'm not doing anything else. Sick of these stupid tasks. Be hilarious if they let Sarah get up and advocate on her own behalf at the end of the closing argument. Okay, well, what's happened? Why have they gone silent again? Oh, it must be the lunch order coming in. I want to keep that confidential. Yeah, Deputy 1 is passing the lunch order to Deputy 2.
It's reasonable. Who would be objecting during rebuttal?
Mr. Owens.
Okay, there you go.
Mr. Owens. Okay, you're messing with me there. I'm trying to get out a little private text message and all of a sudden it goes completely silent. This isn't good TV. What are you guys doing? Get it together. Okay, we're going to go back to full speed again. You guys figure out what's going on. Henderson writing things down. Sarah thinking about papers that can be organized. James Owens showing off the red folder for Lana. Got a thing for Lana too. Okay. Lots of texting going on between the glam squad. I see a lot of them. Oh, court's coming back in. Okay, we'll go back to regular speed. Finally, get some action. Yeah, you stand at attention there, Drew.
Henry.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? Thank you. Y'all may be seated. Members of the jury, for one of the last times, if you could, please raise your hands to confirm that you complied with the court's instructions. All hands have been raised. Members of the jury, at this time, the defense is going to proceed with their closing argument, similar to the state's closing argument. These are not evidence. These are just arguments, and I ask you to pay attention to them. Thank you. Mr. Owens, you may proceed, sir. Yes, sir. Thank you.
Ladies and gentlemen, good afternoon. Y'all know me, I'm James Owens, along with Tony Henderson and the girls. We're all from Milton. I think y'all figured that out, that we were from out of town. Santa Rosa County, it's northwest Florida, close to Pensacola. And my buddy Kevin Beck, he's a longtime friend, he's from New Mexico. The team, the defense team, is here, and we're here to represent Miss Sarah Boone. And we feel confident that we're going to be able to show you why she's not guilty. Okay? And I'm going to take my time. I've got some notes. I'm not the most organized person in the world. I've got some exhibits that we're going to show you. And then we got a couple of videos at the end. Okay? And we're going to try our best to help you make the right decision. Okay? But yeah, Milton's a small town.
Objection. Relevance.
Overruled.
See how small it is. 7 miles away is another small town called Pace. In between that is a Walmart. It's a very small town. We didn't know what to expect coming down here to Orlando.
Relevance.
Judge, I'm allowed to.
I'll give you a little bit more for intro, but then we need to get into it.
I'm going to get into it, but I wanted to say, it's a small town, good people. We've been down here 3 weeks. We didn't know what to expect. We've been surprised. From
Objection. Improper argument.
Mr. Owens, approach.
All right, here we go. There's our first sidebar. The court. I'm a little worried. I didn't know what to expect, Mr. Owens. It's just that we've been treated very well, very hospitable by the people on the street, by the people in the court system. Okay. I'm just simply trying to explain to them that we're from a small town. We didn't know what to expect here. We got here and pleasantly surprised with how we were treated. Mr. J, anything else? It's completely irrelevant. I'm going to overrule. I'm going to give them an opportunity. But I don't want to belabor this for too long, so thank you.
Since we've been here, we've been treated with respect and hospitality, and just like we've been at home. We appreciate that. Now, I'm going to do some reading, and then I'm going to do some talking. But ultimately, this is about justifiable use of force. That is a legal defense in Florida. We as citizens, the law is designed to protect us from defending ourselves, to protect us from potential attack. And
now I'm just a simple hyper chicken from a backwoods galaxy, but you of the jury must understand that we appreciate that you've welcomed us.
you are the only ones, in this case, because Sarah Boone was arrested, that's going to be able to look at it critically and objectively. Objectively, not like the state attorney.
Objection, improper argument.
Overruled.
Objectively. And the law in Florida gives y'all the power and authority to do that. The state attorney can't make the decision. They can't make the decision. They can try to influence you. And we're going to talk about some of the things they did here in this trial. And some of the things they said.
Objection. Objection. Any motion?
Yes.
Court says, yes, sir. Mr. J says, I believe the court made it very clear that there weren't going to be ad hominem attacks. And that is exactly what we're starting. Court says, where are we going, Mr. Owens? Judge, I can make comments on the state and the state's case and what evidence they presented. That is argument. I agree with you, but we're not going to have attacks on individual persons. That's my only point. Judge, he objects to everything. Everything he objects to, everything. I can't speak to Mr. J and his objections, okay? He thinks he knows it all, and he objects to everything. This is my chance. And this, stop. That right there, that's an ad hominem attack. That he objects to everything. That he thinks he knows everything. If that's where you're going to go with your closing argument, I'm not going there, Judge. But you're doing it right now. You're doing it right now. It's outside the presence of the judge. I understand that. So I want to make it clear that the line in the sand is unremarkably clear or remarkably clear. We're not going to have ad hominem attacks. If you want to attack the state's position, their evidence, what they've provided, and that it's insufficient for the burden of proof, I 100% agree with you. 100% fair game. But if I hear Mr. J or Mr. Catatouri in an argument, we're going to have a talk. And Judge, I'd move to strike that the state is trying to improperly influence you. The arguments have to be about the evidence and the influences from them. He's attacking the other party. Mr. Owens. Judge, I'm saying that we're going to show the state's evidence, what they presented. What I overruled an objection on. The state is trying to influence you. Now, I let it slide.
You may proceed. Objection's overruled.
Okay, we're going to have to find our way back there. Oh, shit. A lot of Owens to go. Sorry.
I don't believe there's anybody.
It goes back a little before that. I'm going to read it out. We'll see if we're at the right spot. I'll just finish what I did. Judge, what I'm saying is, we're going to show the state's evidence, what they presented. What I overruled an objection on was this: the state is trying to influence you. Now, I let it slide because let me see where you go with it. I'm going to sustain Mr. J's objection at this time, but let's not attack a person. You want to attack a person, you want to attack evidence, go ahead. We are not going to be attacking persons. Okay. Thank you. You may proceed. Objection is overruled. And then Mr. Owens should be starting with, they've got their side, their position, we got our side.
Is overruled.
Thank you, Judge. They've got their side, their position, we've got our side. So we're going to talk about that. But, and we're going to talk about justifiable use of deadly force and non-deadly force. But either way, however you rule, it still justifies her behavior. And the result is not good. Now, I don't believe there's anybody.
Objection, proper argument.
Overruled.
Objection, reproach.
Yes.
The court says, is it with the I don't believe there's anybody language? Mr. J says, he's interjecting his personal views. Mr. Owens says, I haven't finished the... Mr. J says, excuse me. Court says, hang on. Mr. J says, The proper way to make these arguments is, I submit. What he's doing now is saying, I believe, and he's going to interject his personal beliefs on the evidence. That is impermissible. What is it that you're going to say, Mr. Owens? I forgot now. Okay, let's be careful with interjecting our own personal beliefs. Similarly, we can't use the golden rule. We can't ask the jurors to put themselves in the position of the party. Be careful with interjecting personal beliefs. Okay, you may proceed.
I think you will find from considering the evidence in this case that
Bless me.
there is no doubt that Sarah Boone...
Did I miss that? Did Owens literally just pray to God? Oh, I think he does it after the objection, doesn't he? Good call, Phil, if you saw it. Where are we now we're at 8:11:02. We'll go back quickly to before the objection just to see, because I think that's the part you're talking about. Because he's losing it, and he mentioned in an earlier, I'm getting a little hot under the collar, Judge.
The result is not good.
So I'm not able to watch the video with you guys while I'm reading the transcripts, but I think what happened, I think it's right here, where he's about to lose it over being objected to and the third time in his close, but he started it. He was objecting to Catatouri.
I don't believe there's anybody...
Proper argument?
Overruled.
Objection to reproach?
Yes.
Yep, okay. Our Father who art in heaven, hallowed be thy name. Kingdom come, I will be done for defending Sarah Boone on earth as I will be forced to do in hell. All right, let's skip ahead to 1 minute further. Thank you, Meowgarita. Yep, found it.
From considering the evidence in this case that there is no doubt that Sarah Boone is a victim. That Sarah Boone has been traumatized. That Sarah Boone is still traumatized. And the reason for the trauma is George Torres. The reason for the trauma is George Torres. From the positive things about the man that we've seen on video, to the positive things Sarah Boone is testifying about, to the violent monster he becomes. And I mean monster, because it was repeatedly. And what happens the next day? Man, I don't remember. I was drunk. I don't remember. That's the gaslighting.
That's the gaslighting?
That this young woman, vulnerable woman, with nobody, just starving for love, starving for attention, and seeing the good in the man. And it was good. But every day was on the balance.
6,
She
7.
measured every day, depending on how it started and then how it ended. And that's the way she had to live her life. Day in and day out. Day in and day out. Dr. Harper and Dr. Brandon talked about trauma. Dr. Harper spoke of the veterans that she had treated for post-traumatic stress disorder. I don't know if you remember her testimony. But she spoke about some of the veterans that had been in the war in Iraq, you know, and people in war a lot of times get post-traumatic stress. It used to be called shell shock and other things.
Good question, because James Owens just brought up the vulnerable young woman, Sarah Boone, 10-10-7-7. How old do you think James Owens is at this point of the trial? He mentions his age. He makes it part of his closing argument, so we'll have an answer, a definitive answer. But how many years removed from Miss Boone do you think he is?
But people in wartime, or police officers will get post-traumatic stress. And a lot of them come in, the males come in with this bravado, I'm all right. I'm all right. And so, that's why Dr. Harper was talking about the veterans, that's what they'll do. But you got to spend time with them. It just can't be one session. And you've got to run post-traumatic stress testing.
One of the things I'll say about the ages is myself, I thought personally they both looked similar in age, which manages to insult both of them at the same time, I think.
Whether they really have post-traumatic stress. And we all probably have experienced some trauma. All of us have lost some loved ones. And it's awful. You're in shock. You can't believe it. It's disbelief. You don't sleep for days. And eventually, you have to go back to work. You take a week off. Life has to go on. Life has to go on. You go back to work. Kids are in school. You get a little time. Right? Time heals. Right? These veterans that come back from a deployment, they get back, they get some semblance of normalcy. They may or may not get some treatment, but time helps. Time heals. Everybody, it helps. Just time.
Are you speaking as a professional psychologist or psychiatrist there?
Overcoming a divorce, overcoming a death, whatever trauma. Sarah Boone had no break. No break. Learned helplessness. Just giving up. Just giving up. I can't get out of this situation. They broke up. She'd go about 2 days. She'd go about 2 days.
Hugs, need, now.
Texting, calling. Just learned helplessness. And it's, in the manual. Battered spouse syndrome is not, but what did you hear Dr. Harper say? She suffers from post-traumatic stress. That is a mental disorder. You are actually undergoing the psychological effects of post-traumatic stress. You're not in your right mind. And it's repeating itself. It's repeating itself again and again, day in and day out. And when you look at this law, that's what you have to apply. Someone in Sarah Boone's shoes, when you're deciding whether her conduct was reasonable. Got a bunch of notes.
Got a bunch of notes.
Not that. It was something I wanted to read.
Compelling argument, Mr. Owens. A few moments later.
Sarah Boone's long-term exposure to abuse created a state of learned helplessness and diminished her capacity to assess risk, especially in moments of heightened stress. The cyclical nature of this violence, the tension building, the battering, the contrition phases, caused Sarah to be trapped psychologically in that relationship. Due to this clear abuse, Sarah Boone had a reasonable belief of imminent harm under her state of mind. George Torres had a history of violence against Sarah, and as a result, Sarah Boone's actions were the result of fear conditioned by abuse she endured over time. The cumulative effects of long-term abuse, as we saw her behavior on the 2-minute suitcase video, is a trauma response. Sarah Boone acted out of a sense of preservation. While tragic, it was not driven by malice, but a mind ravaged by abuse. And I'm going to ask you to try to understand. Try to understand.
Try
Sarah
to
Boone, being emotionally and
understand.
psychologically broken, whose actions may have been misguided attempts at survival but not murder.
Magic.
Imminent danger, her response reacted to that belief. It's somebody suffering from the long-term psychological effects of domestic violence. Who spent a lot of time? Dr. Brandon, you remember him. He was the first expert on trauma. Took some notes. Kevin Beck, you remember, did the direct examination of Dr. Brandon. He was from down in Miami, I think. He talked about the trauma, that you cannot escape from the abuse, so you develop coping skills to protect yourself, knowing that the bad things will happen to me. It changes your behavior, not only your behavior, but your thinking. Your subjective thinking about fear and what to do. And if you remember, Dr. Brandon said it's all about that person's perception. Okay? A lot of times they will self-medicate with alcohol or drugs. A lot of times they suffer from anxiety. Basically, he said the trauma ends up being terror because you do not know what to expect. You do not know what is going to happen that night. It may be a great night. You may drink, and both of you have a great time. He falls asleep, passes out, you fall asleep, passes out. But it may turn, by depending on his mood, I don't know if you can tell, she would try to placate him. Dr. Brandon said, you know, when you're trying to evaluate somebody, it takes time to get them to trust you. And the ultimate goal, he said, is to be a behavioral detective. If you're a forensic psychologist, is to be a behavioral detective. And the ultimate goal is to put yourself in the abused person's eyes so you can better understand their world. But ultimately, it's their perception of danger. Their perception of danger is what you have to look at. What a reasonable person would do under their perception of danger. Now, I want to go on. Trauma experts explain how victims' reactions in moments of stress are the product of the damaged psyche. Her actions, although tragic, and it was a tragedy, George Torres lost his life in that suitcase. It's a reactionary response to sustained trauma. It's as if Sarah was acting out of a deeply ingrained fear and helplessness developed over the years. So it's a desperate need for survival, but battered women do things to keep the peace from time to time. And when they feel like they have a small portion of momentary power, they may enjoy that by vocalizing their position to the abuser. Sarah Boone's not perfect. Sarah Boone would argue with him, talk down to him. Some would say was somewhat abusive to him. Sarah's not charged with that. Sarah Boone is not charged with that. And I want to read you something.
Just have to find my notes. And it's important, so I'm just going to flip pages until I find it. But it is important, so I got to get it just right.
Essentially,
But it's not that important, so I guess I'll paraphrase.
okay, I don't know where it's at, but I'm going to have to come back to it. But essentially what it said was,
Don't tell us essentially. Wait till you get it right, Mr. Owens.
essentially what it said was eventually
Why don't you just tell us essentially what it said then? Don't worry about an exact quote.
it's been a 2-week trial. I got a bunch of notes. I'm trying to get this right. I know it's important.
Okay, well then get it right.
What I wanted to say was someone can be mean and angry and hateful and intoxicated and still be abused. They're not mutually exclusive. And mutual abuse exists where one is abusive towards another. And eventually the victim, Sarah Boone, trying to fight back against the abuse, became verbally abusive. While the victim has committed verbal abuse, it is important to remember that they, Sarah Boone, are the victim and have been pulled into an extremely vicious cycle where they are trying to survive. Sarah Boone intentionally left George Torres in the suitcase. What's the act of a battered spouse syndrome woman?
Sorry, say that again, Mr. Owens. Why did she leave him in the suitcase?
Of a battered left George Torres in the suitcase. What's the act of a battered spouse syndrome woman? She went up.
I don't believe that any more than I believe those glasses are hanging off your ears.
Room, she fell asleep or passed out. These actions are disconnected. Ultimately, she didn't let him out because of her fear that she knew if he got out in that moment, what he would do. That's real fear, that's real trauma that she was experiencing at that time.
It's so it shows such an you've got the facts of the case. Like, you're trying to say that Sarah's scared. Meanwhile, you've got video of George obviously terrified that he's going to die. And we know he dies. And you're trying to argue that she's terrified on the other side of the suitcase with complete freedom. It's just bizarre.
That's real trauma that she was experiencing at that time. Now, I talked to you about force being used. And I think I talked to you about blocking an attack using a physical restraint like the suitcase to block somebody's attack. And the example I give, I got a couple of examples.
Terrible examples.
Let's say you're in a bar and you got your buddies and the other guy's got their buddies and they're drinking and there ends up being an argument between two of them. And you realize that these two are fixing to get in it. Well, one of your buddies comes around on the other side and grabs the guy before he's able to strike him, right? So you're committing an offense on this guy, but it's a restraint. It's a restraint where you grab him by the neck and try to get him out the bar.
And just so everyone is clear, this is a story to be an analogy towards George sticking his two little fingers outside the corner of the suitcase. It's the same as grabbing a guy in a bar that's about to beat up your buddy, who's, good guy and didn't start it, but form of restraint.
So yeah, you're committing an act, but it's designed to defend another, which is legal. Or let's say you have a situation where you have a police officer and he's on...
Yeah, let's forget about that example. It's a terrible example. Let me think of another example that, oddly enough, is even worse, because now he's going to bring up an example about qualified immunity, which is, a police officer in the course of doing his job, he's afraid that there's a suspect that may be armed. He may make a decision, and maybe he draws his gun on somebody who's holding a cell phone. But if he went into the situation thinking that he was at risk of his own life, then there's qualified immunity from discharging the firearm, possibly. Like that's a possible defense. There's no defense for that in Sarah's case. But yeah, now prepare for that example, because James is going to lay that one out here.
Patrol. He's in uniform, he's wearing a firearm, and he's on patrol. Or let's say you have a situation where you have a police officer and he's on patrol. He's in uniform, he's wearing a firearm, and of course he's got the bulletproof vest. And he goes to a call where there's a suspect that may be armed. A suspect that may be armed. And so he gets there, he gets out of the squad car, he's walking around. Of course, he's taking out his gun because he realizes he may be armed. And eventually he sees the suspect, and the suspect reaches...
Calling all cars, please respond to 4748 Transcourt. Be aware the victim is sticking two fingers out of the suitcase. Do not go in unarmed. Do not go in unarmed. Two fingers outside the suitcase.
Waist. Now, in that moment in time, that officer has to make a decision. Am I going home with my family tonight? And I asked Dr. Werner about this basal instinct, it's called.
He got closer to the correct pronunciation. He called it a basal instinct. He called it a basal instinct on the stand. BASAL, basal instinct, basically your primal fear instinct. Tanya Werner wasn't having it with James Owens by the time he asked about the basal instinct, and she looked at him. Basal instinct? No. Basal instinct. His accent not helping him out, and the fact that he was a dick to her earlier, she wasn't going to help him out either.
Werner about this basal instinct, it's called fear response or fight or flight. Those decisions are made, it's instinctive based on your set of circumstances. She instinctively reacted to her unique set of circumstances to save her life or save herself from another one of these. I'm 63. I can't imagine that. I can't imagine that.
All right, so anyone who was playing along with the How Old is Owens game, Margarita was correct, 63, and that's why he refers to Sarah as a young woman. Tell the truth, I really thought that Owens and Sarah were similar ages, and, to some degree, it's a bit of a compliment to Owens. He looked like a mid-50s guy. I guess I just can't tell, you're either a kid or you're an adult. Maybe it's how old Sarah looks, that she looks like a 63-year-old man. I thought they were very similar aged. I didn't realize there was that big an age gap.
That? I can't imagine. 3. myself from another one of these. I'm 63. I can't imagine that. I can't imagine that. Her father's not around.
Her father's not around. Speaking of her dad not being around, I did a short called Hey Dad, I'm in Jail. And if her dad was around, that would be the sort of phone call she could expect. Well, Hey Dad, I'm in Jail, Was Not Was parody from Dan D. True Crime.
I need to talk about the case a little bit.
Mm-hmm. Talk about the case.
And if you'll remember,
That's a great idea, Mr.
I'll get
Owens.
back. If you'll remember, lost my place a little bit. Let's start with the witnesses, and then I'll talk about the sentence.
Oh, it starts getting bad here. Here we go.
The first witness out of the box
Strap in.
for the state, if you remember, was Juan Torres, the brother. Remember that? It was some time ago. I know it's been a while. Y'all taking notes. You may have to go back.
5 days ago.
Their first witness was a good witness for us.
Say it again.
Their first witness in their prosecution of Sarah Boone for murder was a good witness for us.
Well, if you just keep telling them that, I'm sure they'll believe it. You don't need to explain why you think that. Just restate it.
Remember Tony Henderson did the cross-examine of Juan Torres. Asked him, what did you hear Sarah Boone say? Juan Torres, she was yelling, he's been choking me. He's been choking me. Mr. Henderson said, did that surprise you? Juan Torres said no.
Really pausing on that to try and let that sink in, but I remember when that came up in testimony, and all I thought when he said, no, that didn't surprise me, is, yeah, Sarah is usually saying crazy, stupid shit every time I try and talk to my brother on the phone. She's screaming in the background. So the fact that she said, he's choking me, yeah, unremarkable.
Juan Torres said no. That family knew what was going on. The police knew what was going on. The neighbors knew what was going on. Pearl Walker came in here, 80-something years old.
It's them peoples that drinks all the time.
No wheelchair. Kevin Beck called her up.
You've even suborned to perjury. We don't know.
She saw it. Is there any doubt? Is there any doubt? I tell you why there's no doubt. In cross-examination, I got Dr. Warner to even admit. Did you hear it? Yes? Okay, Mr. Owens. She suffers from battered spouse syndrome. Wouldn't admit it on direct. Well, maybe. I don't really know. I hadn't had enough time to really see her.
Just trying to pat himself on the back like, I
You
got
hadn't
her.
seen the pictures? You hadn't seen the 2-minute video? You've seen her one time earlier this month. One time.
Because that's all the state gets.
And she's going to start testifying about stuff she's never said before until she showed up in court?
I think they could have objected there. But the expert witness doesn't get multiple visits with the person. They get their visit. And when they found out there'd be a battered spouse defense, they had about the same amount of time as Owens had to find experts, because prior to that, it was an accident defense, and they were prepared to fight the case on those grounds. So Dr. Julie Harper had been on the case from the beginning, so she had 9 visits, but that's not a state witness. That was Sarah's witness.
About, well, based on what she told me, I don't think she was in imminent fear? Come on.
Come on.
This is a courtroom.
Yeah.
This is a courtroom.
Where are we?
Good thing y'all are here. We thank you. But it gets even worse than that. It gets even worse than that here in this courtroom.
From the trailer.
The state attorney referred to these pictures. And I was going to rise up and show these pictures to you.
Overruled. You may proceed.
And I was going to rise up and show these pictures to you.
Well, you're not going to do that, are you?
Well, yeah, I'm going to do that.
Oh, never mind.
They put her on trial for murder. But what did they say? And I got to turn to this. Make sure I get this exactly like they said it. 'Cause I took a bunch of notes.
You don't want to get this wrong, so make sure you get it right. Take your time.
Let me make sure I got this quote.
When something's this important, you don't want to get it wrong. You don't want to just paraphrase, right? Don't worry. I'm sure you can find it.
It was something to the effect,
What do you mean something to the
maybe
effect?
George Torres is the battered spouse. Can you believe it? Can you believe that? Now you know why we're here. Now you know why we're here. Little boys learn early on
Here we go.
that girls are different. You do not put your hands on a girl. You can't wrestle with them. You can't punch them. You can't kick them. You can't treat women that way. When you become adults, I don't care what she does to you. I don't care what she says to you. If she gets in your face, whatever she does, you do not have a right to hit a woman.
Say it again.
No, sir. What has the state attorney tried to do?
Objection, upper argument.
Sustained.
What have they done?
Objection.
Objection.
What evidence have they tried to put on?
Overruled.
What evidence have they tried to paint Sarah? Sarah's?
So that's where the sidebars help out. Basically, Owens was told, he's like, if I hear you bringing them up, we're going to have a talk. Talk about the evidence. And that's why Owens, like, even though he's talking about, what have they said? What have they said? What evidence have they shown? Sustained. There you go. Continue now, mister. You've been told.
What evidence? Controlled and manipulated were the words they used.
Does anyone know what decade it is? My calendar's broken. I'm just trying to figure out, is it
Now, this
18?
ain't the 1900s. This is 2024.
Thank you. Not the 1900s.
What's all these text messages? Why is that relevant?
Those are depraved mind.
What are they trying to claim?
That she's psychopathic. He was always a danger.
She provoked his violence?
That this was a road she was always going to go down, whether it happened this way.
She provoked his violence.
No, that's not what they're saying.
Isn't that what they've done here in this trial?
Proper argument.
Sustained.
Why don't you get back on track and talk about the witnesses, Mr. Owens?
We'll get back on this. Abraham Marino. I don't know if you remember him.
Why does he assume they won't remember all these people? Like, we've been doing this 1 week at a time, and I think people remember the witnesses. For the people who've been there, they've been there every day, all day, just like the lawyers. What do you mean? Abraham Moreno, I don't know if you remember him. Property maintenance worker, knew George from Philadelphia. Bit of an age gap, so it's not like they were friends, but they were friendly with each other. Like, hey, I remember you from Philly.
Abraham Marino changed his statement. They took a statement from Abraham Marino in which Sarah stated, I don't know if you remember, but it was when the police were all there. I think they got the tape out, and some neighbors were coming around, and there were 2 or 3 neighbors sitting around. He said Sarah came out and stated it was an accident. Okay? Well, then, it was an accident. And this, Abraham Marino knew George Torres from Philly. Okay? They were friends. They would talk either at the complex, or if Marino went to Hall's Ace Hardware or Ace Hardware, what it was called.
And this is where Owens tries to read from his cell phone, but Mr. J is like, no.
State attorney notified us.
Judge, I'm going to object to reading from things that are not in evidence.
Approach.
Judge, this is completely improper. All he has to do is say that the man made 2 different statements at 2 different times. It's completely. The court says, I don't believe that the statement that Mr. Moreno gave came into evidence. I know that there's questions about the statement. Mr. J says, but Judge, we concede he made an inconsistent statement. What's appropriate is talking about our obligations to turn that statement over to them and going through all of this. Just make the argument that he's an uncredible witness because he did not make consistent statements. It does not have to come back to the state attorney has this, he's reading from his phone. It's not in evidence. Mr. Owens, I didn't read from my phone. I was reviewing the notes. But Judge, what happened was they're getting ready for trial, and they call Moreno, and he's got some discussion about an accident. And then all of a sudden he remembers additional evidence 4.5 years later. Additional statements that my client made 4.5 years later. Court says, okay. Mr. Owens says, they notified us. Mr. J says he's attacking the state. The court says, I'm not going to let you read from a statement that's not in evidence. That's the primary objection. He's starting. Tony Henderson brought it out, but he stated that in September he changed his testimony. And now he's saying, Mr. J, if he can lower his voice. Now he's saying Sarah Boone said I was teaching him a lesson. I have that, yeah. And things got out of hand. Uh-huh. And then I fell asleep. I have it in my notes, correct. And that's his new statement. Okay. Then highlight those 2 things. I'm not going to let you read from the statement. Okay. Because the statement is not in evidence. But I got it on my phone, so it's refreshing my memory. That's fine. I just don't want you reading from... My concern was there is an issue with impeaching or potentially trying to impeach Detective Kepsel with an interview statement at some point in time that never came into evidence. I just want to be mindful that I'm not going to be relying on these things and arguing things that are not in evidence in closing. That's my only point. And I'm going to ask you politely to stop putting onuses on the state. The state had influenced you on this, or the state did this. If you want to attack the evidence, that's fine. but we're getting dangerously close again to the ad hominem attack thing, which we've spoken about previously. Judge, it wasn't until he met with the state attorney preparing for trial that all of a sudden he had a change in his testimony implicating Sarah Boone. There was a phone call with the ASA on or about September 23rd, and that information was addressed at that point in time. And there's a jury instruction that says it's permissible for... You can't read into that. I agree. You've read it into the jury already. If you want to make the argument that the testimony was different and this goes to his credibility, you're absolutely free to do so. But I'm not going to let you read stuff to the jury that's not in evidence. And I'm asking you to be politely mindful of the ad hominem attacks with regards to the state. That's it. Judge, I don't know how they've chose to put it on the case. I have a fundamental right to attack the evidence. But you're not attacking the evidence. You're attacking the person. You're attacking the state's choice to do this. The state's evidence shows this. The state's evidence says this. The witness says the state says this. And that was impeached and contradicted later. That's all acceptable. But the state did this. The state did this. The state did this. It's a different argument. It just is. It's a different argument. Judge, number one, the state got up there and claimed that George Torres was the battered spouse. They posed a question to the jury as to whether or not. You have to question whether George Torres. That's different than a statement. I just believe you can attack the way the state attorney is presenting their case and the evidence they're presenting. Attack the evidence.
You may proceed.
Do not attack the attorney. That's the end of that. Thank you. You may proceed.
Marino says, all I heard Sarah say that afternoon was it was an accident. Then he came in here today, or this week, and said, no, she said I was teaching him a lesson, things got out of hand, and then I fell asleep. 4.5 years later, we know he's friends with the Torres. We heard it here.
We heard it here.
Now, I want to talk to you about the
boys.
The two boys that live right next door.
Maybe the boys would like to date the girls. You should introduce them, Mr. Owens.
Vincent Battaglia and Brandon Motes. Remember those guys?
I remember them.
And you remember it came out in the testimony, this event happened on February 23rd of 2020.
This is a great point, too. I didn't even think about this till now. So he's asking, you remember those guys? You remember Brandon and Vincent? And he's looking at his notes because he doesn't totally remember them himself. But regardless, as long as the jury can remember Brandon and Vincent from 5 days ago, they're going to be like, it's pretty reasonable that Brandon and Vincent probably remembered the night of the thud from 3 days ago or 2 days ago. Whether it was the day after or 4 days after George died, they would remember, thud, that was the same night that George died. I remember those two things. Not that it happened the night before, and I can't remember, was it the night or was it the night before? But anyway, James Owens saying, do you remember those guys? Well, they clearly remember them. They were there. They were taking notes. They know how the trial went. So them being able to remember Brandon and Vincent actually totally vindicates Brandon and Vincent's ability to remember what happened, as opposed to 2.5 magnums deep Sarah trying to assert that it was the night that I got dragged down by my hair. The hair's so greasy. How would you even get a hold of that? You'd get your hand in there and it'd just slide right out like you're, fighting a wrestler.
20.
Pro wrestler.
But it came out in the testimony that Sarah had said, George Torres, the night before, February 22nd of 2020, grabbed me by my hair and pulled me down the stairs in my apartment.
So yeah, total bullshit story. And who's more believable? This is what Owens is asking the jury. Who's more believable? The two guys, one of whom doesn't drink and doesn't like to associate with drunks. The other, who is just his roommate and neither with a vested interest in the case. And both, probably the most remarkable thing to happen to them all year, as opposed to Sarah, where this is just like any other Tuesday night, except somebody died. And Owens is asking the jury, who's more credible? The boys, or Sarah? Okay, good question. Owens, let's move on from that.
From top to bottom, which is consistent with what they were saying happened, remember?
Remember?
But they got their dates wrong. And remember...
They got their dates wrong. Sarah, she's a straight A student. Obviously Sarah got the dates right and they got them wrong. So once you accept that, you must have quit.
But they got their dates wrong. And remember Mr. Henderson called Deputy Copsel, or Detective Copsel up in our case?
Can't even remember that her name is pronounced Kepsel, and he's talking about people not being able to remember shit.
And she had to say, yeah, I didn't take their two statements until the 27th. February the 27th, remember?
So 3 days. And yeah, this is 4 days since their testimony. So if you remember their testimony, it's not that crazy to think that they could remember events associated with the night somebody died in their apartment block.
So they're remembering back, and they both had similar stories. Of course, they had time to talk by then, the 27th. I think the only recorded interviews they got the night of this event, February 23rd, was from Sarah Boone and her ex-husband, Brian Boone, right? So they came back following up on the 27th. That's when they got a statement from Brandon Motes and Vincent Battaglia. And at that time, they said, yeah, we heard that sound. You remember Sarah testifying? No, that was the night before. I complained about that, and I think one of them had testified. Yes, she had said something about being drugged down the night before. It may have been, can't remember now who it was. One of them.
Can't remember.
And,
he can't
It
remember.
looked like that there may be some implication that Sarah got him in the suitcase and pushed him down the stairs. But I think we didn't hear anything more of that. Remember? And then this photograph, which we introduced, which shows the bottom of the stairs. As you can see, there's Lucas's bookshelf right here.
Look, there's a bookshelf, and there's things on here that haven't been knocked over. They're trying to say that a suitcase went down the stairs. Isn't it crazy? Be a bunch of stuff knocked over. Of course, she cleaned up from the night before. When she got pulled down the stairs, all the things got knocked over.
This is where Sarah Boone stored Lucas's stuff. And you can see it's not disturbed at all.
So yeah, if the story's true, then it would have been disturbed from the Saturday night thing. And unless she totally fixed it during, 2.5 magnums deep, painting, puzzling, sense of accomplishment, maybe that was the time they did it. They're polishing off the magnum from the night before. And how did he get the bruises? Tell me and we'll both know.
I want to get back to Sarah.
Yeah, get back to Sarah.
A little bit about that. But let me talk a little bit about the law on justifiable use of force.
Oh, talk about the law.
Is legal and lawful if you reasonably believe, I think we all probably already understand it by now, you reasonably believe it was necessary to prevent imminent threat to harm. The law is crucial, ensuring that individuals can safeguard themselves in potentially dangerous situations. By acknowledging you have a right to defend yourself when you have a reasonable belief that force is necessary to prevent an attack. Okay? What did Mr. Henderson say in jury selection? You don't have to wait. You do not have to wait. If you're facing, in your mind, a reasonable, imminent threat, you don't have to wait. Let's talk about Sarah Boone and this unconventional form of physical restraint to block the attack of George Torres. What did she say? You saw the tape.
Saw the tape.
You got to think about that. You got to think about what was going on. You got to think about the trauma she was undergoing. You got to think about they've both been drinking. And you got to think about the fact that it was all fun and games for a while.
For a while.
And I think the biggest thing to know is that George Torres chose to get in the suitcase.
Based off the testimony of the most unreliable witness of the entire trial.
He's a grown man. That was his choice. She didn't force him in at gunpoint.
Not at gunpoint. That's interesting that he adds that. Why would he add that? Didn't force him in at gunpoint. He doesn't want to lie because maybe didn't force him in. He knows that he can't say that. That's interesting. Didn't force him in at gunpoint. There was no question of a gun.
Chose to get in the suitcase. He's a grown man. That was his choice. She didn't force him in at gunpoint to get into that suitcase. He voluntarily got into that suitcase because they were drunk and being silly and stupid.
Based off the testimony of my client.
Playing hide and seek. Which I guess when you get so drunk, that seemed like a good thing.
He can't even defend that.
Zipped him up, they're laughing, carrying on. And as you know, Sarah likes to videotape a lot.
A real budding Spielberg.
And I know you've seen some of these videos and you're wondering why, but I think the evidence shows that when George is being videotaped, he's not going to do anything. If you think about that. When George is being videotaped, that's like her power. You know, Dr. Harper said that Sarah's words are her power. Sarah's words are her power.
Sarah's words are her power would explain why she's such a loser and so underwhelming. Like, my superpower is my words. Well, you actually got a kind of mediocre vocabulary there, Sarah.
Physically, she's no match for George. Physically, she's no match. But that's her power, in certain words. When she gets a chance, to have
Power of an adjective, shape of an adverb.
control. That's what she does. And she videotapes, because she knows when she's videotaping, she can tell it like it is.
Wonder Twins
I
activate.
can tell them what I want to tell them. A couple of these videos you've seen where she's telling them like it is. But she's got that video camera on, and George knows. He's being videoed. We've got one that we're going to show you in a little bit, where he loses it just a little bit, right at the end. And then, of course, we got the TV.
Got the TV. Got to remember the TV.
But they're kidding around, playing around. Then, Sarah realizes, okay, this is my chance to say something to him. So she sits down, she turns on the phone, and you've seen the tape. You've seen the tape.
We've all seen the tape.
For everything you've done to me, are the first words out of Sarah's mouth when the video begins.
Well, that must mean he did things. That's
There's a lot packed into those words.
uncontrovertible proof.
Think about that.
Think about it.
For everything you've done to me. This is how it feels when you choke me. Now that's in direct response and the result of the abuse that she has suffered at the hands of George Torres. She wants him, for that moment, to feel how she feels. She wants...
Like to teach him a lesson? No, there was no lesson to be learned. I just wanted him to understand so he could be a better person the next day. Okay?
That moment to feel, for him to feel how she feels.
Oh, good point, Kelp. Didn't even think about the connotations of that. Kelp S points out that Owen just said there's a whole lot packed into there. How can you be talking about a whole lot packed into anything during a trial where your client is on the stand for packing her boyfriend into a fucking suitcase? A whole lot packed in there. Yeah, I'm going to make you eat those words, Mr. Owens. Thank you for bringing it up, Kelp.
Now that's in direct response for everything you've done to me. This is how it feels when you choke me. Now that's in direct response.
A little further, sorry.
This is how. Think about that. First words out of Sarah's mouth when the video begins. There's a lot packed into those words. Think about it. There's a lot packed into those words. Think about that. There's a lot packed into those words. Think about that. For everything you've done to me. This is how it feels when you choke me. Now that's in direct response and the result of the abuse that she has suffered at the hands of George Torrance. She wants him, for that moment, to feel how she feels. She wants, for that moment, to feel, for him to feel how she feels. How uncomfortable.
You know, make him squirm a
Lack of
bit.
control that she feels when George is violent with her.
Give him 5 minutes.
Just for a moment, she wanted him to feel.
5 minutes
If
for
you can
what?
imagine,
Approach.
Oh, okay. What is happening? Didn't even see that coming. Approach. Okay.
I think from the evidence, you can determine she was crazy.
Mr. Owens just very quickly said, I'll withdraw those words. And they go back to action.
She was crazy about that. And I don't know if...
Oh, and it was a golden rule
syndrome,
objection.
but she,
So golden rule, I'm assuming, is don't ask the jury to put themselves into the shoes of the defendant. It's not about what they would do. It's about what's reasonable under law. So that was a quick one.
she couldn't do without it. And let's say she videotapes it, and then it's turned off. And there's a 9-minute gap, 11-minute gap, whatever it is. I said 11, they're saying 9, but I think if you count 2 of the others, then it's 9. But there's 9 minutes that we don't have video. But what did Sarah say? Now, if you remember when you listen on that video, George is talking in a normal voice. He's not stressed. Of course, if
Yeah, be careful. Where are you going with this, Owens? Because she knew the tone. And it was the tone that was the reason why she knew things were escalating. But think about it, Owens. Where are you going with this?
listen on that video, George is talking in a normal voice. He's not stressed. Of course, if you're talking, you can breathe. She had said she had some air. And of course, she doesn't realize the situation, that it's going to end the way it ends. So she has no appreciation of that. It's a canvas. All she knows is an old canvas suitcase that she's got.
They've seen the suitcase. To call it an old canvas suitcase implies that, you know, you could just stretch your legs and, you know, rip your way out of it like you're the Incredible Hulk or something. We've seen the suitcase. It's kind of one of those clamshelly. It's got the handle built into it. It's got wheels. It's, you know, Mr. J beats it with a bat. We'll see it. It'll speak for itself. Or maybe we already saw that. We might have already. No. Okay. No spoilers. But yeah, a canvas. It's a canvas suitcase. What the heck? Where are you going with this? Like, and this gets back to some weird stuff that Sarah did very early in the investigation, suggesting that George was just depressed. Like he climbed into the suitcase and just killed himself that way. It's so ridiculous. But if you listen to some of her early explanations in the context that she's trying to explain away a suicide, it makes a weird sort of sense. Like she's trying to imply that, oh no, I thought he could get out. He just must have been just so sad that he just stayed in there didn't have the will to, unzip himself.
The two zippers removed or spread out a little bit so he can. And she's got some. The two zippers removed or spread out a little bit so he can. So she thinks he's not being serious.
The crying wolf, or woe, depending on how you tell the story.
But eventually he gets angry. She gets angry, he gets angry. He says words to her, and then his hand starts to come out of the suitcase. She also said his tone changed. And I know everybody's got a cadence with their spouse or boyfriend, girlfriend, but
I got to interrupt on the tone, but again, this is one of the things very early, very, very early in following the case. When she claimed the tone changed, and it was like, we hear in the suitcase, his tone goes from polite and begging to sad and desperate and begging. That's the only change in tone. This is such a bizarre argument. Like, somehow between the two, he was like really violent and I'll end you. But he made a sandwich, and the first one was, "Hey babe, please babe, I can't breathe. Fuck you, I'll fucking end you." Sarah, that's not a normal order of events.
you know what I'm talking about. We've got a way of talking to people. We've got a way, your wife, your husband, you know each other. You know when they come in from work, what kind of mood they're in. Just by a couple of things, the way you can just sense it, right? Well, especially somebody as hypervigilant as Sarah and as hypervigilant as a battered spouse woman would realize that he can flip the switch at any time. When I get out of here, I'm going to end you. And he realizes he's getting out. He got his hand out. At that moment in time, in Sarah's mind, that's an imminent threat. So she's got a justifiable right to use force. What did she do? She went over there and grabbed it. She lifted it up. She tried to get his hand back in, remember? She tried to get his hand to go back in. Wouldn't go back in, so her son's back was 3 feet away.
Split-second reaction.
Where the police found it the next morning. Same spot. No attempts to hide. No attempts to delete the phone. No attempts to tamper with evidence. Nothing.
That is an important point. It's been speculated before, so we'll just put it on the record for people who are rewatching it now, perhaps for the first time. A lot of people have questioned, did Sarah delete the videos on the phone? Did she just delete them and didn't realize? One of the things that came out early in the trial when they were discussing evidence and bringing it in, Mr. J made the point of how some file names have the file name as associated with how Apple gives out file names. So IMG 5066, 5077, whatever, they're sequential and they're, got their metadata. But if an item's deleted, it might not have its original file name. So they might have a recovered movie file or something like that. The two videos that are the suitcase video 1 and 2, as well as the photograph, those have proper file name. So that implies, based off of Mr. J's presentation, that they were not deleted. There was deleted content they found on the phone, and I think they were going to bring up some of that if they needed to in rebuttal to show that at the same time Sarah was complaining about being beaten or choked, she might have been taking pictures of artwork in her house. But realistically, the state had way more than they ever needed, and some of that didn't come in. But in pretrial motions where they were doing the motions in limine to make sure what could be or wasn't going to be brought in as possible evidence, they referred to a lot of things, including deleted files. So I'm just putting it on the record. She did not delete the suitcase videos. She woke up pissed drunk, maybe cleaned the scene, but had no idea that the videos were on her phone.
Spot as it was. She picks up the bat, she pokes. She pokes him hard, trying to get him to stop trying to get out. And eventually he does. And you've seen the blunt force injuries, and you saw some of the circular injuries where you can tell there's a poking I think it's right around here.
I wouldn't say it's a poking. I would say that when you hit someone with a baseball bat and it hits them with the end of the bat, it's not a poke wound. Like, it might look like a circle, like the same as, you know, if you poked something really hard. But if you look at the impact damage on the TV set when George is swinging the bat into the broken TV, you see it's also circular damage. And he didn't poke the TV. He swung the bat and hit the TV. And that made those circular wounds. So when Owens is talking about circular poke wounds here, you don't have to believe him. You can believe that those circular wounds came from somebody swinging a bat.
He does. And you've seen the blunt force injuries, and you saw some of the circular injuries where you can tell there's a poking. I think it's right around here. And she poked him several times. You remember the pathologist said, I think, maybe 5, 6, or 7 times. She pokes him.
The pathologist did not say poked. The pathologist may have referred to 5 to 7 contusions, or the fancy word that we learned. Oh, it's a pretty cool word. Have I already forgotten it? Disappointed. Ecchymosis. Several ecchymosises. Ecchymosis is just a buildup of blood below the surface, but more pronounced than a bruise or contusion. So, yeah, there were ecchymosis. That's consistent with a baseball bat being swung into a person.
And he's got some scratches. I don't know if
Scratches.
they'll let you look at it, but on the back of that suitcase, it's got some bars, some metal bars that are inside the lining. There's some lining, and it's for support when you are walking it down. She testified. You heard what she said, that she was justified. That's uncontroverted testimony. Now, let's talk about the jury instructions just for a minute. And,
L73 is giving me a little kudos for calling the similarity between the TV wounds and George's wounds. And yeah, it's easy to think of a baseball bat as causing sort of a cylindrical type wound, but think about, where the impact of a bat is, and when you're swinging it to hit a person or an object, as opposed to a baseball, you're much more likely to hit with the end of the bat. You're not going to connect mid-swing. It's not like the person's coming down the middle of the plate and you're trying to connect with the barrel of the bat. Or if you do, you're doing some Joe Pesci, cornfield wounds, like boom, ping, ping, pow, ow.
I want to talk about reasonable doubt for a minute. Can't find the page, but
Michaela says, I thought the scratches were from sex. That was one of the stories, yep. I know what that's from. The defense said I would rise up and show these posters. Yeah, I'm going to rise up.
let me find it. If y'all are all looking,
This is important, so let me just quote directly. Oh,
I think it's on page 15 of 22. And we're going to talk about reasonable doubt in a minute, but if you look at those bottom three.
We'll get
short
back to that.
paragraphs, it is the evidence introduced in this trial and it alone that you're to look for the evidence or look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence itself, a conflict in the evidence, or lack of evidence. But here's the main thing. And,
Hey,
obviously,
Gen X, welcome.
I represent her, and I'm trying my best to show you honestly and fairly the doubt in this case. And 5 reasonable doubts, 17 reasonable doubts, 25 reasonable doubts. You have to have 1 reasonable doubt. I'm trying to show you throughout the evidence that each one of you can have a different reasonable doubt.
Thank you, Mitch
Difference,
Hedberg.
but 1 reasonable doubt about the state's case, and your verdict is not guilty, according to law. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, speculative doubt, or imaginary or forced doubt.
This poster was the subject of one of the very last pretrial motions in limine for people who are watching this on replay. There was some argument about, I think, 3 of the posters, and 2 of them got allowed in. Owens was quoting from 2023 law that had been updated, and Judge Granick knew it instantly. He's like, the problem for you is that 907B6 has been updated in 2025 to include language that, well, oh, well, this one's just a part of the law. Is this one okay, yeah, Judge? That appears to be fine. And then he still wouldn't let him use them in opening. He's like, we're not giving jury instructions. We haven't even decided what the jury instructions will be. It's probably going to be in it, but you bring that up in close. So that was the foreshadowing, and here it is in close, one of Mr. Owens' posters.
A mere possible doubt, speculative doubt, or imaginary or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. And this is a deeply held belief. You know, reasonable doubt is the...
Okay, Detective Wobefit wants to put out to the chat that it was premeditated hide and seek. Wants a pause for thoughts on that. I definitely, I wouldn't discount it as a possibility. I just don't give Sarah the credit for being clever enough to enact a plan that nefarious. I think that she, at her core, is an opportunist. Well, she's an opportunist, but also an opportunistic killer. I think she has a power fantasy, and I think the minute that she saw George in a vulnerable position and how he got to that position is probably where the debate comes in. But the minute that he was completely vulnerable to her and she was drunk and had no inhibitions, everything clicked to where she became a murderer that night. I think independent of the opportunity, she may have lived a life just being, a regular drunk, getting into DUIs and, minor incidents. But I think this was the perfect convergence of feeding into her power fantasy and a complete lack of inhibition from her frontal cortex being so destroyed by alcohol, and being a bad person to the core, because sometimes, you can be destroyed from alcohol, but if you're a good person, your inhibition is to go around and hug people and say, I love you. I love you. You don't understand. I really love you. Just come here and give me a hug. A lot of us, that's what happens to us when we lose our inhibitions. Not Sarah.
Standard we recognize in litigation. Car wreck or something like that is preponderance of the evidence standard, 51% you're entitled. Abiding conviction, that's a deeply held belief.
Hey, welcome, Detective
that you
Koala.
must have if you're thinking about something. That's a firm belief. That's a level of certainty that you would have. That's what you got to have as a juror. I've got to be certain of her guilt. If, on the other hand, if after carefully considering, comparing, and weighing all the evidence, which we want you to do, there is not an abiding conviction of guilt. So I'm not certain. I'm not certain of her guilt. Or if you have a conviction, I think there's some evidence of guilt, but it is one that is not stable, one which wavers and vacillates. One which wavers and vacillates.
To be fair, this is probably one of the strongest parts of Owens' closing argument. The idea of exploiting reasonable doubt and, doubt. You can even be in doubt about what doubt means. I don't doubt that you doubt what doubt means. I doubt. I don't even know. So if you don't know, maybe you want to let her go. I'm not saying you should. I'm just saying you might.
Charge is not proved beyond a reasonable doubt, and you should find the defendant not guilty because the doubt is reasonable. You understand that? You've got to be certain of guilt. That's the high standard we recognize. If I've got some evidence of guilt, so okay, there's some evidence for conviction, but it's not stable. It wavers and vacillates. Then under our system, you've got a reasonable doubt.
Wavers and vacillates.
And you've got the power and authority.
I'm not saying vacillation without
obligation
wavering.
under
There's
the law.
wavering and
If
vacillation.
that's the way you feel, to vote that way.
Indoor camper bringing up Tanika's got some recent
Later in the
reporting
instruction,
with
it goes on. It's up to you to decide
very
what evidence
detailed
is
contents of
reliable.
the
You
suitcase
should use your common
included. Check
sense
out
in deciding
Tanika's
which is
videos.
the best evidence and
I'll
which
just pause Owens for a quick second to shout out Tanika. Not only great new reporting on the contents of the suitcase, but also on who Al may be. This mysterious Al fellow.
should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You may rely on your own conclusion about the credibility of a witness. That is totally the province of the jurors to decide that. A juror may believe or disbelieve any or all the part of the evidence or the testimony of any witness.
Another $80 poster got its use.
I want to show you this before I forget it. But Dr. Werner said, this is their expert again. He testified that Sarah Boone suffers from Battered syndrome.
Why does he say Dr. Werner said this? Because the blacked out part, he did say previously this was a Michael Brannon quote. But maybe he managed to get her to agree to one of these statements? That's weird that he would say Dr. Tanya Werner said this and it's got a blacked out name. Definitely said one of the sidebars that it was Michael Brannon, or maybe not even sidebar, outside of jury presence.
Battered women's experiences affect her perception of imminent danger. Those past experiences with George Torres,
Or George's past experiences with Sarah did the
affect their
exact same.
perception. Remember Dr. Brannon, Michael Brannon talked about perception.
Oh, so I think he just got confused and
Victims
said
of
Werner.
repeat violence may fear death in situations others would not. The reason
I see.
Sarah experiences all this, the reason she was feeling the way she was feeling, that
No, there's no way he got this printed within a day of Dr. Werner. Maybe he did. It's not that complicated, but again, why would it have to have Michael Brannon's name blocked out? I assume the name was blocked out because he got some psychologist to say this on a previous trial and he was reusing poster boards, but I don't know, too much analysis into the poster board.
imminent threat of danger from George was because of George Torres. George Torres is responsible for her mental state because of the way he has violently treated her. She reacted to his attempts to get out because of the way he treated her and the way she knows what is he going to do if he gets out of the suitcase. She knows. The
Gonna
second
live
video
is
is
what he
playing.
does.
She's flipped it back upside right.
Upside
You hear him,
right.
It's 22 seconds. He says, Sarah, she's not going to open that suitcase. She's not going to open that suitcase. He's already threatened her. She used the bat to get him to stop trying to get out of it.
Saved her life. We got about 25 minutes of James Owens, and I think the rebuttal from Mr. J is the remaining 25 minutes of their hour and a half that they had allotted to their argument. And we will be closing with Mr. J.
Why would she do that? Why would she do that?
Tell
I
us.
know what he's going to do. I know what he's going to do to me. I know him like I know him more than he knows himself. I know what he's going to do to me.
Didn't know that he was dying. Someone who knows him like better than he knows himself.
You don't have to wait. That was justifiable. Now, you got to understand this. She intentionally used the bat to defend herself. She intentionally didn't unzip him to defend herself.
That's new.
To defend herself. Used the bat to defend herself. She intentionally didn't unzip him to defend herself. She intentionally didn't unzip him to defend herself. She intentionally didn't unzip him to defend herself. Both of those are lawful under our law. She went upstairs. The dogs were upstairs. At some point, she called her husband, or ex-husband, Brian Boone. We know that many times she testified, or somebody in court said, she would often flee to her ex-husband's house.
Somebody in court said.
I believe that testimony came out from either Sarah or somebody.
Well, who else would have testified to
Sometimes
it?
she would flee, or sometimes she would flee to upstairs.
911
One of those
operator.
two.
She told me sometimes she
The
would
dogs
flee.
were up there. She made a phone call. At some point, she fell asleep, passed out, fell asleep. We don't know. They had 2 big bottles of wine, right? That was unintentional. That was unintentional. His death was unintentional. You remember when she was in the interrogation room? You remember that? Now,
I remember. Pepperidge Farms remembers.
I don't know if we did a good job of this, but
You didn't.
it came out that she got arrested. You remember the one time when she got the black eye? She got arrested for strangulation. And you remember that? They ended up over there by the dryer, and he was banging her back of her head on the floor that had very little carpet on it. And she ended up getting her arms out, and then she grabbed his neck. And she eventually got him off of her, and that's when he got up and
James Owens going through more contortions trying to make the story plausible than Sarah would have had to actually have done this.
stomped her in the eye. Remember?
He's trying to justify how she strangled him. Think about that. So you're getting a heel in the eye because you go to the ground. From the ground, you reach up and strangle someone as a defensive. Like, how short was George? Like Peter Dinklage.
Well, the police came for that event, and they took statement, and Sarah was honest with the officers about what all, and they arrested her.
Chest on flag.
You remember?
Chest on flag.
Remember that? They arrested her.
I remember.
And she said, why? I was fighting back.
Chest on flag.
You remember that?
I remember.
Why? I was fighting back.
Chest on flag.
So from that point on, she didn't trust law enforcement.
And law
The
enforcement
video
didn't
that they
trust
showed a
her.
while ago about George, that was about dropping the case, where she was defending herself and fighting back.
Interesting. I'm interrupting him a lot because I have no respect for Mr. Owens, but much less than I did for either Mr. Catatouri or Mr. James later. So getting it out of my system now. Go back a half second to remember why I interrupted him.
George, that was about dropping the case.
Right. We did a live stream where we looked at the 2018 arrest documents. And Sarah's first lawyer very well may have been the lawyer that kind of set the Lana bar of expectations for all future lawyers. Because when she was arrested for the strangulation defense, the public defender wrote this 15-point memo to the state attorney about, we want every witness statement that's ever been made to a law enforcement agency against our client. We want every witness who may have tangential information. We want every document that has ever been seized. It was this real pain in the ass make work project for the state. And the state's response to it was, we've reviewed the case and we've decided not to proceed with the arrest or with the prosecution, whatever it was. Sarah got out of it, and you can see, I bet she kept a copy of this letter, because there's a part about like if there's been any wiretapping. Maybe that's a boilerplate thing for a lawyer to ask as a make work project for the state. But Sarah asks about the wiretapping 2 years later. And I think it's because she tells the lawyer, look, I've got this. You can ask for it. I know you can. I know for a fact. I'm not some dummy. I've had lawyers before. Because it's stupid. Why would you ask for wiretapping when you've given your phone? It's not like they had to tap her phone to find out, you know, oh, she's a real danger. Let's just keep an eye on her phone in case she's going to do something crazy. They found out after the fact. But anyway, look into the live streams. There, we do break it down a bit. There's not a whole lot of new information that you find in it. It's just a matter of us taking the time to deep dive and go line by line. But definitely, I think that 2018 arrest and the fact that she got out of it from having an aggressive, zealous lawyer gave her a complete, the police are now my tool kind of attitude towards the police from that point on. So what he's saying about her being afraid, this emboldened her with the police, this experience, and the fact that she never did get arrested. The whole thing, the whole exercise she makes George go through, doesn't matter, never ends up coming into court. But she's doing that. She's got like 15 different irons in the fire to get herself off of this assault charge. So it's a bit of a window into pre-Sarah and how she became the Sarah we know today.
The video that they showed. So from that point on, she didn't trust law enforcement. The video that they showed a while ago about George, that was about dropping the case, where she was defending herself and fighting back.
Best on flag. Yeah. Cat's eating. Cat's
I want
done
to talk
eating.
about this
Screen time.
investigation by law enforcement. Now, she didn't know the law. She's not a lawyer.
He won't tell
She
you
gets up
that.
the next morning. Brian's calling.
Brian's calling. No, she's ignoring Brian's calls.
Pick up Lucas at 3. Brian's calling. Eventually she walks down. She's looking for George. Where's George? He's quiet down there. And she looks in the bathroom. She looks out. He's smoking a cigarette. Is he on the computer? She sees the suitcase. And you can imagine.
Objection, golden rule.
Sustained.
She sees him in the suitcase. She panics. What does she do? She tries to get her fiance out of the suitcase. They're engaged to be married. She's not trying to kill him.
He wants her
They're
ring back.
engaged to be married. She gets him out. She tries to do, he's purple. She tries her best to do CPR. She doesn't, and you heard her, I didn't know what to do. I didn't know, call Brian. That's her safety valve. That's all she's got. Brian eventually says she's come over. She calls again in 2 minutes. I'm on the way. He gets there. You got to call 911. May have told her before. Call 911. She calls 911. She tries to do CPR again. Is she busy trying to hide evidence? Is she busy trying to hide evidence? Is she busy trying to hide the back? No. She's trying to save his life. If she can. So the police get there. She knows if she told them, she fought back, she's going to be arrested. That's what happened before.
Best on flag.
That's what happened before. Like George has said on the video, she'd never been arrested before. Before that time, she was charged with that with George. She lies. She lies. She's scared. She's scared. She doesn't know what to do. So she lies. She makes a decision to lie. Don't trust law enforcement. She doesn't know the law. She doesn't call a lawyer. She talked to Officer Rodriguez, was the first short black female that came up here first, the first one that arrived.
The first short black female that showed up? Not the first officer on the scene, not the first responder. It was the first short black female showed up.
Talks to her. There's a recorded statement there where she doesn't tell the whole story. She lies. And then the detective...
Hold on. We can't process this scene. Do we have a short black female? Okay, perfect. Now we can get going.
Eventually get there and get her in the squad car. You hear the audio. I think it was played. She lies again. Then the next day, she goes down to the sheriff's department. Now, if they would have told her, hey,
it's a trick.
Man, we're going to arrest you. And she gets a lawyer to go down there to make a statement. And the lawyer would advise her.
Objection. Facts not in evidence.
Sustained.
Move to strike.
Stricken. The jury will pay no mention or give any weight to that statement.
She's not a lawyer. She didn't have a lawyer present when she made those statements. She didn't know the law. She didn't know she was justified in defending herself the way she did in this dysfunctional, toxic, abusive relationship. I don't know if you remember, it was a 2-hour video, but there were some things she said, it was not intentional.
He did say that, yeah.
And eventually, she wanted the detective, it was Detective Lowen, the male detective. And she said, I swear to you on my son's life, it was not intentional, what she was talking about.
Do you think that she made Owens bring that up in closing? Because this again shows how out of touch with reality Sarah is. To think that nobody would ever say that if they didn't mean it. And it's like, yeah, like, even if I'm telling the truth about something, I'm not going to wager my daughter's life on it. I swear on my daughter's life. No. Why bring her into it? She didn't have anything to do with what I'm... This is a big wow.
The detective, it was Detective Lowen, the male detective. And she said, I swear to you on my son's life, it was not intentional. What she was talking about was that George passed.
And you think this is a defensible moment, that this is like, going to endear her to the jury. Like, I'm telling you, she said, she swore on her son's life. This young woman sitting here before you, Sarah Boone, swore on her son's life. Does that sound like a guilty person to you? I don't think so.
George died. That was not intentional. She thought he was fine in there. Would he sober up?
Thought he was fine. Thought he was fine and dandy. Everything was fine and dandy.
We've learned from their history, when Sarah gets drunk, she calls for help. When George gets drunk, he beats Sarah. That's their pattern.
Oh, may God strike you down right now on that one. My God. You just said that like it was, we hold these truths to be self-evident.
We've learned from their history, when Sarah gets drunk, she calls for help. When George gets drunk, he beats Sarah.
No, when Sarah gets drunk, she records things. She doesn't call for help. She calls for help when she wants to end the fight. Have George taken away so she can have the bed to herself for the night. so he can have the fear of the police put into him. Sarah calls for help.
Sarah gets drunk, she calls for help. When George gets drunk, he beats Sarah.
Good night, Charles.
That's their pattern.
We'll catch you on the
How many
replay.
times do we see Sarah call the law?
I think about an hour left in today's
That's
broadcast
their pattern.
total with commentary.
Sarah told him, I didn't know, I think she said, I didn't know something like this could happen. I've never done it before. And Detective Owens said, well, what did you expect that was going to happen?
Hey, Dr. Candace, thank you for joining.
I've got a daughter that she...
It'll all be here for you on the replay. Give it a couple of days, though.
18 or 19, and she got a grandmother's hand-me-down pickup truck.
Hold on, you're bringing your daughter into this now, Mr. Owens?
I've got a daughter that she was about 18 or 19, and she got a grandmother's hand-me-down pickup truck. And it was an older truck, but she didn't have it long, and she was gassing it up, but she didn't put any oil in it. And eventually, it burnt the motor.
This is the analogy. My daughter once had a car where she forgot to put oil in it, so Sarah just forgot to, put air in her George, Instead, she just didn't put any air in him, and because of that, she's just a young girl. She didn't know any better. It wasn't intentional.
You don't know what you don't know. I hadn't done a good job of explaining, hey, you got to put oil in it too. Sarah Boone didn't know that he could die in there. It's an old beat-up canvas suitcase that she left a gas.
Keeps calling it an old beat-up canvas suitcase, like they don't see the suitcase. Maybe this is why Mr. J brings it out and makes such a spectacle of the old beat-up canvas suitcase, because it's fairly sturdy. More sturdy than, 2 out of 3 suitcases that I have.
And as naive as that sounds, she didn't appreciate the danger. I mean, is that the way you want to kill somebody? Is that the way you're going to do it?
No, not if you're a planner, but if you're an opportunistic killer, then yeah, Again, what kind of defense is this for your client? That just doesn't make sense. Who would use a suitcase to kill someone? You wouldn't plan to do that, would you?
She had Lucas to take care of. Am I going to go to prison doing it like this? No attempt to hide the crime.
That just means she's stupid.
I think the evidence is clear. That's how this happened. I don't want to belabor the point. I do want to show you.
Like, hiding the crime's a bad idea too, but if you're too stupid to even consider hiding the crime, it's your own fault. Oh yeah, get those photos up one more time, Mr. Owens.
Sarah Boone got stabbed.
In the back of her leg, sword fighting with steak knives. By her own testimony. This is also just a close-up of a person who has stitched skin that could be related to any accident at any time.
Think about that.
Really think about it.
Stabbed with a steak knife in the leg. And she stayed with him.
If you believe her testimony.
She stayed with him.
And even for a steak knife, pretty impressive. Because you'd think that, it's serrated, right? There should be a little bit more trauma along that line. There's like there's a bit of a messy part in the middle, but it's a fairly clean cut. That looks like, glass.
Poked between the eyes with a curtain rod.
There we go. Michaela feels the same. Is that a curtain rod wound or a blemish from a popped pimple on the forehead? Could be either. I like the little swoop of hair that comes down too. Just one strand fighting the helmet. I don't want to be a helmet. I want to be Bangs. Part of the helmet. One of us. One of us. I want to be Bangs.
Stalked in the eye.
Ah, the shoe polish eye.
I mean, who does that?
Who does that? Why, I can't believe y'all didn't take the curtain rod, too.
The law empowers an individual.
I do have a theory on the curtain rod, as long as we're talking about it. It's come up in chat. Plausible scenario. They're putting up the curtains, drunk, taking them down, whatever it is, and too much pressure, and they pull down the curtain rod. So now, George is on the couch. He's got the curtain rod split, come apart from hanging off of the curtain while pissed drunk and fighting with each other. Hey, get back, get back. And he's holding the curtain rod, and Sarah comes in to, tickle or do whatever she was doing, and then takes a curtain rod in the forehead. Because if I'm using that curtain rod defensively, again, I'm swinging it, I'm, poking it into a midsection, a torso. You're not going for the eye with it. So, yeah, it's implausible. We'll say it's not completely busted, but as far as curtain rod wounds go, I don't think it was you don't attack somebody and poke them between the eyes, unless your last name is like Stooge.
To defend their life and safety when faced with a threat and to prevent an attack. That's what Sarah Boone did. That's what Sarah Boone did.
If there isn't a suitcase-shaped cell at Lowell, there should be, Shiloh gal. Get your papers in order. Hand them to Sarah. She's good at shuffling papers. What else you got for us, Owens? Save the good stuff for the end? Gonna finish strong, right? Well, don't let me down, Owens.
I think it's important to understand Sarah had to be the parent a lot of times. It was her place. She had that $1,000 a month from the divorce settlement coming in. She had the car. She had the phone. She had the keys.
He had all the power and control.
She had to be the parent in a lot of ways.
I don't know why when he brings up Miss Dr. Harper, he just wants to talk about geography.
I want to talk a little bit about Dr. Harper. If you remember, Dr. Harper is from Okaloosa County, which is up in the Panhandle, close to where we're from. And she's the doctor that treated Sarah from early on. Remember, this happened in 2020. I think she first saw Sarah Boone shortly thereafter.
If I remember, it was May or June that she had her first meeting.
4.5 years, saw her 9 times, and did
within a month
all
or
the
two
testing for
of
post-traumatic
the murder.
stress. Of course, she has the experience from the veterans, and she's testified that she's now
Did I write Owens?
traveling
I
around
might
the
have.
state, testifying as a forensic
A
psychologist.
little small
But-
on my end. No respect. No respect.
She talked about how important it was to develop trust with the patient over a course of time. It's just going to take time when you have somebody suffering that kind of trauma and that kind of damaged psyche.
Thank you, Addie.
It's going to take some time. to get them where they can trust you and really tell you and
Hey,
talk to you
Dr.
and tell you
Candace,
what's going
thank you.
on.
Going to take a
She talked about
quick break from James Owens, just getting himself together to thank Dr. Candace, PhD 9243. She's given 5 Dandy True Crime gift memberships. Michaela, Detective Wobbuffet, Shiloh Gal, Low Tears Steers, or Low Tier Steers. Low Tier Steers. I think it's low tiers steers. Tears. It might be low tier tiers. That's a tough one. It's a good name. Anyway, you and Tracy Conrad, the 5 of you have all received True Crime gift memberships to Dandy True Crime, courtesy of Dr. Candace, PHB 9243. Thank you.
that Sarah uses her words for power.
Uses her words for power.
I think her testimony, I don't think, but I think the evidence supports that her testimony was credible.
Objection.
The evidence supports that her testimony was credible.
Objection is sustained.
I can't give my personal opinion. Okay?
I can't give
The
my
evidence-
personal opinion.
The
Okay?
evidence supports that her testimony was credible because of the time that she spent, because of the number of tests that she did. And she diagnosed her with post-traumatic stress disorder, alcohol use disorder, I think anxiety disorder, and battered spouse syndrome. Of course, Dr. Warner confirmed that. And, Dr. Michael Brannon, the first witness, he was brought in as a subject matter expert. So he hadn't treated Sarah. He was just testifying about the condition.
He did a
He's
good
been doing it
job.
a long time. He's an expert at it.
Yep. I think he gave us a
That's
very
to
good.
advise you.
Take a
to
quick
try to-
second and just say I think he did an excellent job. I think I have to keep bringing it up because I think this is an example of what the expert witness should be. You get him because he's able to elucidate the finer points of your own case, if he knows about it, and you can ask the questions in a way that's going to help your jury understand. But if you're a guilty person, an expert witness shouldn't tilt the favors tilt the balance in your favor. If you're a guilty person, a skilled prosecutor, or vice versa, if you're an innocent person, a skilled defense attorney should be able to use that expert witness quite effectively to defend your case. And that's the way it should be. They should be experts on the subject matter, not experts on getting the defense off or prosecuting people, whether they're guilty or not. So I really like Dr. Brannon's testimony, and it's kind of underscored in the absurdity of everything else in the trial, but just a good solid moment from a professional wrestler of all people. Like, you'd think if anyone was going to come into this and be ridiculous, it could have been him. And he ended up being, for sane moment for both sides.
And what's going on? And as crazy as it sounds, in this syndrome, they try to protect the abuser. They're in love with them. They try to protect them. I don't know if
And if you watch George in all the videos, he does try and protect Sarah. So, 100% right on how a battered spouse will try and protect the person that's being. Get all the evidence into who protecting and who do you see that's being mean. Get him. Upstairs, he's in there. Not a gentleman.
that there was a time where Sarah Boone had a conversation with one of the neighbors, and they were talking about something, and she said, "Did you hear anything yet last night?" Remember, she said, "Shh, it's okay." Both George and Sarah lied to the police. They lied to medical people. I don't know if it's shame, but it just comes with the syndrome.
Dr. Candace is not a real doctor, but those are real gift memberships. So thank you to Candace. Whether you're a real doctor or not, your credentials, I will stipulate to your credentials here in the chat.
That you stay trapped in it.
Detective Wobbuffet, real detective.
I think another big, if you'll think about this,
California Dreamer actually asleep right now.
when Sarah gets beaten by George, she calls the police. When Sarah gets beaten by George, she calls the police. And a lot of times she just wants him out. Just get him out. Get him to.
Sub Rosa is below the rose.
She doesn't want him to get in trouble. She just wants him out. There never was a report of George calling the police on Sarah. She wasn't physically abusing him.
No, it's because George was protecting. Look at that. So he makes the argument that the person, a battered spouse, would protect the person that's beating them, and then says George never called. George never. Yeah, because exactly as you recite how a battered spouse would act, George would never risk calling the police on Sarah to get beaten for it after. Just him even making a statement about, yeah, I guess those are from her hands on my throat. He had to go through the whole hostage video and recite a script. So, of course, George isn't phoning 911. Doesn't even have his birth certificate. Sarah destroys that. So maybe he gets pulled away because he can't prove his citizenship.
Present evidence. Did she emotionally abuse it?
Sustained.
Move strike.
Stricken. Members of the jury will pay no attention to that comment. Give it no weight whatsoever.
I believe the evidence that's been presented by the state is an attempt to show that Sarah mentally or emotionally abused George Torres. Again, she's not charged with that. She's not perfect. Some of that was her trauma. In Sarah's situation, you do become numb and hardened, I think, over time. That's a coping mechanism. It's a day-to-day thing, some good days, some, But the homicide detectives, I know if you saw that 2-hour video, at some point during the 2-hour video, they started talking about some of the violence. And they go, we know. They had already checked with neighbors or whoever. They knew.
No, James Owens is confusing the Reed technique, where they basically give a plausible thing for the suspect to admit to make it easier to get down the path of admitting the truth. So they're like, well, maybe he abused you and this was just you fighting. No, it was a good day. It was a good day. Hadn't had a day quite like that, actually. Things have been good. Yeah, don't try that, Mr. Owens. We know what you're doing. He's trying to claim that, the detectives were like sympathizing with her because they knew how bad it was. Like they'd all checked her record. And no, things weren't that bad.
Neighbors knew, police officers knew who responded, Torres' family knew. They all knew about the abuse.
They all knew she was claiming abuse. We'll say that. I think that's reasonable. They all knew she was claiming it.
Dr. Harper testified that abused women act differently.
Abused spouses act differently. It doesn't have to be women.
I think Sarah Boone was loyal to a fault to George.
To a fault. Loyal to a fault. Well, I'll agree with the fault. I don't know about the loyalty, but definitely to a fault.
Through all the abuse.
Owens with his hand, and I'm interrupting him a lot. I'll try and slow down a little bit on this. He's almost done, but there's kind of a poker tell thing. But when people are under stress, further up on their face that they're touching, is an indication of stress. So, on the chin, they're just listening. It's kind of casual. Start, brow touching, scratching. That's an indication that, maybe the person's under a bit of stress. Start top of the head. Owens is almost halfway down his back. Sorry. Owens is almost halfway down his back. He's so stressed right now. Sorry about that, headphone users. I'll be less animated.
Judge, I want to make a comment about a couple of things that were said by the prosecutor in opening statement.
Thank you, Ramono.
Okay. prosecutor in opening statement, when he was talking about George Torres passing away, and started talking about Sarah Boone, and his quote was, because I wrote it down, George, in Sarah Boone's mind, George Torres deserved it. George Torres deserved it. That's the position they're taking. He deserved to die. She loved the man. She wasn't trying to kill him.
I'd
He
bar.
also commented about...
Judge, we move a motion.
Yes.
Yes, sir, Mr. J. It's fair to point out things that didn't come out in evidence, but the evidence in this case was she said that he deserved to be put in that position, to have to listen to her and to feel the pain of being choked and cheated on. That's what Mr. J, excuse me, sir. Court says, hang on. Mr. J says, that's what we talked about in opening statements in regards to putting him in the suitcase. We've never taken the position that she intended to kill him. The argument has been made repeatedly during defense for whatever reason that she didn't intend to kill him. But that is the jury instruction. We don't have to prove that. It's improper. He's attacking me now. That argument is ad hominem. The court says, what are the three other things that you wanted to address that were in opening other than what's already being addressed? He was implying that George Torres died, and he pointed to my client in opening and said she thinks he deserved it, or words to that effect. He deserved it. I think the evidence, it could be taken in such a way based on the videos and other statements that were made that the jury may be able to make that decision. The other comment being made about all batteries, the violence that George Torres has committed on Sarah Boone is referred to as a bunch of violent nonsense. That's his quote. I recall it. Mr. J, this isn't Mr. Owens. I'm entitled to comment in closing on the statements the prosecutor made in his opening. Response? It's one thing to say that the evidence doesn't support that, but it's another thing to just attack the prosecutor. So again, I'm going to allow you to address that issue. Let's just frame it with, this is what was said in opening and this is why it's not accurate. Or here's, look at the pictures again. Whatever you want to do, but let's just avoid the attack individually. Just say this is what was said in opening, yes? Mr. J, approximately how much longer? We're just circling back and forth to what Dr. Harper said 3 or 4 times, and the court says, you've been at this, don't worry about it, you've been at this for about an hour and a half, ballparking it. Mr. Owens, I'm not like him. I'm kind of scatterbrained. So I'm going to bounce around a little bit, but I'm trying to save her life, Judge. I know, I understand. I'm not putting a cap on you. Just ballpark it for me. Where are you at? I'll try. I feel like I'm finished. I'm getting close, but I don't want to miss anything. I understand. I'm afraid I'm going to miss something, and one thing that a juror may think is important. I understand. Are you going to have, since we're up here, are you going to have someone else jump into the breach, or are you just going to conclude yourself? Tony Henderson said, James, why don't you do your deal? And then if I feel like I need to add something, I don't think he's planning on it, unless he thinks I missed something. Okay. So the case law seems to be, as it should be based on old common law, and I'm looking at case law back from the 1930s, that there should be one lawyer in closing. Now, that was based on a statute in common law and Wharton's treatise, and I think on criminal procedure. So I'll defer to you if you want to switch over. It's a matter of discretion. And just for the record, I'm referring to the Tyndall decision. It's Tyndall v. State, Florida Supreme Court, May 17, 1930, 128 Southern 4094. In that decision. So it's a matter of discretion, but only one lawyer can. But it should be, and it also cites Stelendrum versus State, Florida Supreme Court, March 1st, 1920, 84 Southern District 535, which says, when there are 2 or more counsel, the order in which they are to speak is determined by the court, citing Wharton's treatise on criminal procedure. If you want to, I think it's odd, but I'll leave it to your discretion if you want to do it. We weren't planning on doing it. It's just when we found out they were using 2 lawyers to make the argument, that's when I said, Tony, they're using 2. I wasn't planning on it. The court says, with that, I'll let you point out I remember the nonsense comment or words to that effect. I'll let you point that out, but let's just avoid particulars. Just, this was said in opening, and this is why it doesn't work. You may proceed, sir. Back to open court. Shelby's there to comfort Sarah. That's your glam squatting is over, Shelby. After today, no more. You've already done your last work.
About the violence, the violent episodes. It's a bunch of violent nonsense, was his statement to you, an opening statement. All this here, the photographs.
Bunch of violent nonsense.
Bunch of violent nonsense. You'll have to make your mind up whether that's that.
Owens wouldn't know honesty if it took a shit in his hair, says Sabrosa.
That I introduced late, and they were no contact provisions. Where there had been a court order from a judge, not only a verbal order, but it was reduced to writing. So there was a court order for George Torres not to have any contact with Sarah Boone. Okay? Court system got involved. They would have no contact with George Torres. Now, I need to talk a little bit about that. And they talked about coercion, coercive control, power and control, power and control. We know about his abuse. We know he destroyed the home, the TV. We know about his jealousy. You know, some of the things he said to her. We know about how he treated her dogs. Nicely when he was sober, but at times he abused the dogs.
Dancing with the dogs.
If you think about power and control, when you're controlling a person, and I think she testified that he kind of smothered her. He's always around her. Part of his fear was her realizing that she'd had enough and to leave him for good. That she would get the strength over time if she had enough time away from him where she wasn't in control of it and he wasn't in control of it. Enough time away, she would come to her senses and realize she could do better. The judge has been giving court orders all week.
And 5. 1.
That didn't stop George Torres. George Torres knew he was going to lose control. If she had a bunch of time away from him, she might move on. He was willing to violate a court order to maintain control. That's George Torres. I want to show a couple of videos. And I want to say something to you.
Got a couple of videos to show.
Is just going to help me. If we could dim the lights. Yes.
Oh, these are going to be edited. Let me give him the benefit of a full screen for this little presentation.
Do you understand? What do you mean? As of this moment, and until I can get you out, get the fuck out of here. You're a roommate. Get the fuck I dare you.
Did you see him
Yep,
flip the
look,
switch?
look at him. Look, get away from me. Get away from me.
So if we're not familiar, we're going to see a longer version of this video, and we have seen a longer version of the video. But James Owens has decided to take the one moment where he tries to pull away the phone, which is Sarah's power, because she's been domineering him for about 6 minutes.
Get away from me. I'm gonna scream bloody murder. I'm gonna scream bloody murder.
George says, I'm not doing anything. Go ahead, scream. Down the stairs meekly, and there's no incident. This is the defense's evidence.
Did you see him flip the switch? In that instance? Where he lost it, even though the video was going? Show the next one.
Show the next one. Yeah, circular injuries from swinging a bat. So if you look at those circular injuries, they're not from being poked with a bat through a suitcase. They're from possibly being in a suitcase and having the power transfer through you the same way that it's transferring through this television set with codeine or whatever is on there between the glass and the pixels. The bigger ones, you see the full bat, and that's the difference between, but you can see there's a lot of little circle holes that are the end of the bat connecting rather than the barrel.
Thank you. Thank you, Judge.
Also interesting here, kind of a background thing, but you look above that doorway, and Sarah had the live, laugh, love, decorations, but threw away live and love. So there's just laugh. That's a little bit of macabre foreshadowing to know that Sarah didn't want to have any living or loving going on in the home. Just laughing. Both were laughing.
Thank you. Thank you, Judge. You turn it off. Can you turn it off?
Turn it off.
Ladies and gentlemen, I'm going to finish up right here. And Sarah Boone, I've gotten to know.
Objection.
Proper argument.
Sustained.
Sarah
Sarah
Boone,
Boone is like any other citizen.
I gotten to know.
Equal justice under the law. She's to be treated like any other citizen. Fairly and impartially. Based on the circumstances she was facing at the time of this tragedy. Based on the battered spouse instruction, which is a special instruction that's given when women have a heightened sense of fear and trauma that you're to utilize in applying her subjective standard to the reasonable standard of what a reasonable person would do under her circumstances in using the force that she used to defend herself.
Detective Wolbethit makes a special request. It says, Dan D. True Crime. Daniel, please say Yankee Doodle went to town being a bad lawyer. So, assuming you want more than just the straight read, you want like a little bit of rhythm, like Yankee Doodle went to town being a bad lawyer, put a green jacket, end of trial, and left for California.
I hope I hadn't missed anything. I tried my best.
Tried my best, Judge.
Sarah Boone fought back and survived.
She lived.
We ask that you do justice in this case and find her not guilty because the doubt is reasonable. I
Unreasonable.
tried to show you where the doubt was. I trust your judgment. We spent a long time picking the jury, 4 days. We trust you. We appreciate your service and your obligation to do your duty. You have the power and authority to right this wrong. That's what we're asking you to do. And give Sarah Boone some hope for a better life and freedom. Thank you.
Thank you, sir.
Some hope for a better life for you and me. Show 'em a better way. Da, 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 da. Put a little love in your heart. Okay, well, that's it. Mr. J, do you think what are you going to say to that? That's, I think it's ironclad. I think at this point the jury's got to be unanimous to let this Sarah woman go. Is there anything that you could possibly say in response, Mr. J?
Any rebuttal?
Yes, sir.
You may proceed.
Oh, there will be a rebuttal. Fantastic. All right, I'll just give everyone a chance to settle in. This will be the final portion of the show. Just going to adjust the backgrounds and stuff so this gives Mr. J his full credit. There, we'll move the screen over here. Okay, so we got Mr. J in the margins just above me. I have to change that to a Mr. J text, I think. J, state rebuttal closing. Oh yeah, this looks good. I think this is, let's make them a little bigger. Okay, I think that'll work. All right. This is it. This is the last bit of programming for today's stream. When we return next week, we'll be listening to the jury instructions. Then we'll do a little verdict watch. We'll do some highlights. Remember the trial, kind of give the impression of waiting for a jury. We're not going to wait the whole hour and a half. We'll probably wait 12 minutes or something like that. Then we'll have the verdict. Then we'll have the sentencing statements. Some of those really tough. If you're easily triggered by emotions and need to give it a pass, I understand. At the same time, this is going to be documented as an archive of the trial. So when Mom Torres gets up there, it's devastatingly heartbreaking. And I think enjoying Mr. J's closing here is it's a nice counterbalance to what we're going to have to go through for that. And everything that the Torres family has gone through as being the extended family of the victim of this case. So we've got that. We're going to wrap up next week, but we're going to wrap up today's stream with Mr. J today. And without any further ado and a lack of interruptions, I'm not going to interrupt unless it's critical. I'll try and say what I have to say in the chat. If there's anything, make a note on a separate sheet of paper, and we'll talk about it at the end of the stream. Okay, here we go. Mr. Owens, you can take your stupid easel. What I will need is the suitcase. Oh, he's just doing some tech cleaning up first. Okay. I love the splash of color from Mr. J's tie. I'm going to use all the live action silence moments to get out what I need to. Okay, what's in the box, Mr. J? Old beat up canvas suitcase. Oh, it sounds pretty solid.
Ladies and gentlemen, George Torres is dead. The because the defendant believed he deserved to be zipped shut in a suitcase so that she could make him feel how she felt when he cheated on her, when he choked her, and to hold him there as a captive audience, according to her testimony. Now he has to listen to me. Well, right out of the gate, there are credibility issues. Cheating to me means viewing pornography. Well, we saw cheating really means women. And the heated conversation on June 14th about these women in Facebook, and that is what leads to the arrest on June 15th. He's out whoring, Candy Crush, all the bizarre things that you see in her phone. She uses the legal system as a weapon at times. There's no denying that they are engaging in violent behavior, and it is over nonsense. It is smashing TVs. They call the police, and then they're standing there looking bewildered about what to do and who to say, and laughing and joking. Ladies and gentlemen, the courtroom is the place for justice, not a suitcase. The reason we have a jury system originally started with the idea that the king, the crown in England, shouldn't be able to go and incarcerate citizens on his whim. So it developed into a system where citizens would have to say, yes, you can take our fellow citizen. But the opposite is also true. A citizen cannot take another citizen's life because he or she feels like it. That likewise requires a jury to decide that it was objectively reasonable for a person of ordinary prudence and caution. Like Mr. Catatouri argued earlier, battered spouse syndrome is not a license to kill. Past grievances, even being stabbed in the leg, so on and so forth, do not give her the license to kill. There are still laws in place about when and how this can be done in a justifiable manner. I want to talk about the most important jury instruction in this case that has not been discussed very well or thoroughly. Excuse me. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself. And we'll stop at that comment. The facts of the case that came from her own mouth, if she is to be believed, and we will explore thoroughly why you should disregard every bit of her testimony, from court to the detectives, to the 911 operator, to the doctors. Her testimony, if it is to be believed, the most favorable light that she has presented of herself, is that at the end of a Sunday fun day, where we are drinking, we're outside by the dartboard, we're doing puzzles, we're doing arts and crafts, and there finally comes a point in time where we're going to play hide and seek. And he says, tag, you're it. Even though she's it, she goes upstairs, hides in the shower, eventually gets tired of being there, it's cold, so on and so forth, and she comes back downstairs. And as she comes back downstairs, she can see Mr. Torres fiddling to place himself inside the suitcase to try and hide for this game. And the lid is not closed, and it's flapping. And out of jest, out of levity, undisputed according to her testimony, she comes over there and zips it shut. Whether it's 100% or enough for 2 fingers to get out, that is something that you decide as the jury. But there came a point in time where the fun and games was over. And Mr. Torres told her that. Babe, I can't breathe. Sarah, babe, let me out. This is all on video. We don't have to imagine this. This is all on video, 1062. At that point in time, she is using force against him that is not justified. She is the initial provocateur. She is the aggressor under the law. And what level of force is it? I can't breathe. Not let go of my hand, not get your hands off me. I can't breathe. This is no different than two people, maybe they're buddies at the bar, similar to an example that was given by Mr. Owens, who are wrestling, and one has another one in a headlock. And there comes a point in time where the person on the receiving end of the headlock says, that's enough, I'm tapping. George Torres was tapping, and she ignored it. And she was kind enough to tell you why. Out of anger, which translates to hatred, ill will, spite, just like that in jury instruction for second-degree murder. She told you exactly why. She got angry. Him saying, I can't breathe, babe, was what triggered her. Not a fear of imminent harm. Those are her own words. That is the law. These are the two paragraphs that solve this equation without getting up on a big whiteboard in college that's 30 feet long, 15 feet high, and a ladder, and somebody's scribbling Latin words and Greek letters for months and months to solve this huge, complicated equation. The equation is solved in two paragraphs. She is the initial aggressor. He is saying, I can't breathe. It is no different than a naked chokehold that she does not let go of. And she told you it's because I want him to listen to me. This is my bully pulpit. This is how he made me feel in the past. She doesn't describe it as teaching him a lesson, but that's exactly what she says. I want him to feel like I felt in the past. I want to tell him things. Ladies and gentlemen, we can play semantical games, but that is teaching him a lesson. Therefore, we have to look at the other two paragraphs. Because right now, plain as day, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself. And what force are we talking about? Well, the threat of force that she tells you she was facing was him fighting for survival. Him sticking his fingers out of the suitcase. Him sticking his hand out. That is the threat of force, coupled with, I'm going to end you. Well, ladies and gentlemen, she is the initial provocateur. She is the one using deadly force against him. If I have somebody in a rear naked chokehold, they are entitled to use deadly force against me to break that chokehold, at least until we're separated. He had every right to say what he said. He had every right to exist and stick his hand out and try and survive to breathe another day. However, the use of force is not justified if you find that Sarah Boone used the force to initially provoke the threatened use of force against herself, unless she does one of two things. And she did neither. Not even close. The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. All right, let's give her absolutely every benefit of the doubt, which you should. This is a criminal prosecution. The state of Florida has alleged she committed murder. You need to do everything you can to look for reasonable doubt. But a reasonable doubt is not an imaginary doubt, a forced doubt, speculative doubt. So accepting that all of their past history, accepting the doctor's testimony, and the limitations on what they reviewed compared to what we reviewed. We did a much more thorough review of the relationship than any of the doctors did in this case. So let's give her that first clause. Because of their past relationship, with George now fighting for his right to exist and saying that he will end her if he gets out, we'll give her that. But just like Mr. Catatouri mentioned earlier, lawyers' words mean things to us, and they mean things to everybody, but really to us. Or an and. There's an and. Had exhausted every reasonable means to escape the danger other than using deadly force on George Torres. She did not use every reasonable means to escape the danger that now, after provoking him, that he was presenting to her, according to her. She didn't pick up her cell phone and start walking, call 911. She didn't do anything other than, if you believe that is why she called Brian Boone, made a phone call to Brian Boone, and unfortunately, because of past history, he just ignored her drunken phone call. She did not exhaust every reasonable means to escape this danger that she created. She started it. She created this. Other than using the deadly force on George Torres. Now, this is a weird situation. This is not a rear naked chokehold. This is a suitcase, or as Mr. Catatouri said, a box, or actually more aptly described it as a coffin. And when you secure somebody into a box or a coffin, you can still exert that deadly force on them from a distance. I'll give you a quick example from a couple of movies that I love. 1977 in May, a movie came out, it's called Star Wars. They eventually called it Episode 4. In the first scene, there is this large, imposing figure that wears black armor. He is a government agent, and he is looking for some stolen classified documents. He picks a man up who he believes is responsible for this treachery and breaks his neck and chokes him to death when he doesn't tell him where the plans are. We all understand that. That is direct force we all understand.
Vader, come on.
But
He
what
was
we
the
need to
head of the
understand
Imperial
is the
Army.
force she's exerting from the couch. And then when she goes up to bed, she is still exerting that force on him. She set these implementations into motion and did not stop. So later in this movie that came...
And I'm sorry, I don't want to interrupt, so I am going to go back the 15 seconds and let him just get his flow. But the best part about the movie analogy, and sometimes Mr. J's analogies weren't a perfect hit, but this one particularly, because we know in the letters it got to Sarah, like in your stupid sci-fi adventure fantasies, and this one bothered her. So I love it. So we're gonna give it its full due. I'm gonna try not to interrupt Mr. J very often, if at all.
Death when he doesn't tell him where the plans are. We all understand that.
Subros is asking for interruptions. We'll see. I'll feel less inclined not to now that I'm getting some votes for interrupting, but still, it's just too good. I'll try and save what I have to say for the end if I have anything to say. I feel pretty good about Mr. J making his points.
Classified documents. He picks a man up who he believes is responsible for this treachery and breaks his neck and chokes him to death when he doesn't tell him where the plans are. We all understand that. That is direct force we all understand. But what we need to understand is the force she's exerting from the couch. And then when she goes up to bed, she is still exerting that force on him. She set these implementations into motion and did not stop. So later in this movie that came out in 1977, another co-employee of this dark, imposing figure, Vader,
a co-employee, just a colleague,
insults his religion. He does not go to HR. He takes matters.
You and your stupid space magic and lightsabers. I was only kidding. Release him, Vader.
Into his own hands and chokes this person from a distance. Ironically, while we're talking about force, it's the force. And then in the subsequent movie, he's like doing it from his office. He's killing his incompetent employees on different ships. Force, deadly force, can be exerted from a distance in this situation.
Imagine working HR for the Empire. God, what did he do? No, it's just, I've got a sheet up to hear of complaints.
So whether she's on the couch or whether she turns in for bed, she is still using that deadly force on him. She has not exhausted every reasonable means to escape this danger. Do something. You started this. You put him in the position where he cannot breathe. She's required by the law to do something about it. Not something, everything. There was no efforts in this case. None. Or, in good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force. But George Torres continued or resumed the threatened use of force. That did not happen. She never withdrew from physical contact. She is still, like Vader, choking him from the couch, choking him from bed. She never withdrew that force. Physical contact includes any restraint on George Torres' movement. She never indicated that she wanted to withdraw. Sarah, babe, I can't breathe. All right, if I let you out, are you going to come out peacefully? Since I started this, I'm the one that made you not be able to breathe. That didn't happen. So ladies and gentlemen, this entire analysis about deadly force starts and ends there. She was the provocateur. These are her obligations when she starts it. She put him in fear of death. He is literally telling her, I cannot breathe. A couple other things about the law. Second-degree murder does not require a proof of intent to kill. Argument was made repeatedly that she didn't intend to kill him. That has never been the state's suggestion. Because why would we suggest we prove something that we don't have to? It's not her subjective belief. Well, Sarah Boone doesn't believe that this suitcase can kill him, even though he's repeatedly said, I can't breathe. It's a person of ordinary judgment who would know, is reasonably certain to kill or do serious bodily injury to another. A person of ordinary judgment who hears, I can't breathe, babe, Sarah, and his voice gets weaker 9 minutes later, you're on notice. This is statutory notice. Done from ill will, hatred, spite, or evil intent. Her words speak for herself.
Yeah, I will make an interruption here, and I do appreciate all the support. The main reason I'm not interrupting is just the respect for the way this is crafted, and the more interruptions, the less you take that away from it. But even Judge Cranick is paying attention. And not that he didn't pay attention to the defense argument, but, you know, if he had things to do, he's checking his papers. You can see that he's listening to Mr. J just as much as we are. So, yeah, that's the only reason I'm kind of shying away from commentary too much during both Mr. Catatouri's and Mr. J's arguments, because they're really to be appreciated for their preparation, for having a beginning, middle, and end. Mr. Catatouri so strong on, hey, this is what you were instructed. These are the reasons you can ignore that one, that one, that one, and that one. This is why you might want to debate this one. Here's some stuff you can ignore about those. You know, super clinical. And then Owens rambles, tries throwing spaghetti at the wall, and, you know, hits on, almost lecturing them at some points. You don't hit a woman. Oh, okay, Dad. The angry man rages. I think Just a Lazy Gamer did a thumbnail with James Owens, angry man rages at clouds. But then Mr. J wrapping it up. He's got, you know, the emotional. He's speaking for George. He's got the practical. He's explaining the law. He just really pulls it all together really well here at the end. So give him another 20 seconds to get that flow back, and see you in the chat.
A person of ordinary judgment who hears, I can't breathe, babe, Sarah.
One last interruption, just to recognize Kitten Pusher, who's given 5 D&D True Crime gift memberships. If your name is Favorite Noni, Cindy Buchanan, Lomo Hoyo, Jackie C. Renee, and Razzle B140, you've all received memberships to D&D True Crime, courtesy of Kitten Pusher.
Voice gets weaker 9 minutes later. You're on notice.
Siba123,
This is
welcome.
Statutory notice. Done from ill will, hatred, spite, or evil intent. Her words speak for herself. This was not out of fear. This was out of hatred and anger. Born out of all those horrible things that has been done to her and done to him. Understand, we're not going to belabor the past. Is of such nature that the act itself indicates an indifference to human life. I don't care that you're saying you can't breathe. Fuck you. That's my name. Don't wear it out. Fuck you. It's second-degree murder. We do not have to prove the intent to kill. We have to... She intended the act. She intended the act of zipping him shut. She continued to intend that act when he said, I can't breathe. That act resulted in his death. That's a manslaughter, but then when you add in the hatred, ill will, spite, and the depraved mind, that's what makes it second-degree murder. And that 2-minute video is the textbook definition of depraved mind as we define it here in Florida.
Just Florida?
Voluntary intoxication is not a defense. You cannot feel sorry for her because they had 2 1.5-liter bottles of wine and then some from the leftovers from the day before. And quite frankly, she's blackout drunk. She's blackout drunk. She doesn't remember making the videos. She turns her phone over right to the deputy the next day because she doesn't know what's on it. She doesn't remember doing it.
Exactly. Are you concerned that the judge is available?
Another
on the
thing
screen?
that we just haven't talked about much
Go to
is
a smaller view.
her story.
No, there's no.
She can't be up in the shower
Can't see
hiding
the judge.
and taking a picture at 11:03 p.m., 9 minutes before the video. That portion of her story just doesn't add up. And what it shows is it's more like 20 minutes instead of 11 or 12 minutes that we know he's trapped in what turns out to be his coffin. Let's talk about her testimony at trial. And we'll talk about all the problems. A lot of her issues predated her relationship with Mr. Torres. So it's not attributable to the trauma from Mr. Torres with all the luggage she brought into the relationship. And listen to the way she talks. It's not splitting the bills. It's helping without argument. It's not cleaning up and doing Sunday chores. It's cleaning up so we can relax. It's a reward. She talks about him like he's a child. I need to lead him to the next activity from one to the other. And then you saw the videos, and I'm not going to belabor it, that we showed in Rebuttal, but the relationship and the power dynamics speak for itself.
Detective, I don't know if you're live with us or not, but if you can see the Court TV logo, that's over the far right-hand corner of the screen. So if you can see any part of that, no more screen for me to show. I am trying to keep the judge in frame when he is on the main screen, though.
He was treated like the third dog. And it might very well have been a dog that bit and was violent.
Oh, that's...
But he was treated like a dog. That we showed in Rebuttal, but the relationship and the power dynamics speak for itself. He was treated like the third dog. And it might very well have been a dog that bit and was violent. But he was treated like a dog. Why are you leaning against my door? Get out of here. Go downstairs. You're worthless. You're garbage. They showed the part of the video where he slaps the phone, but that's after 5 or 6 minutes of being berated and dehumanized in a way that nobody should be treated. He just wanted to get in bed and lay down next to his fiancée. Instead, get away from the side of my door, you useless dog. I thought it might be a good point in time to listen to the music. You know, when does Mr. Torres get to decide what to do? I mean, she paints this picture that he goes off and does all these things on his own, goes and buys wine when he's not supposed to, does all these things when he's not supposed to, but when does he get to do what he wants? Suitcase downstairs for a week so they can donate it. What was in their lives that was preventing them from getting that suitcase to the Goodwill or whatever? Neither one of them worked. What's going on? Lucas is over there on Mondays and Tuesdays. The story about the suitcase having already been down there is quite suspect, and we will get into that more. But again, it's Not we went on a trip together, we had a great time. It's, I quote unquote, I recently took him on a trip. Then it comes down to the moment of truth, which we've already gone over. And it's just quite frankly inconsistent because she doesn't, there's no explanation for the picture. Her explanation at trial when I brought it up to her was, I just don't remember. I don't remember this period in time from the picture at 11:03 to when I was supposed to be coming down the stairs.
And this is a real key point too. I don't think it gets quite enough attention. As far as the timeline goes, we have the testimony from the boys, the neighbors, who testify near 11 p.m., 10:55 to 11:05, somewhere in there. They each separately testify within 10 minutes of each other as to the approximate time, but that they hear the noise coming down the stairs so loud and away, says one. I guess the other's in a different location, so it's just loud but doesn't hear the direction of travel. But that's on the records. We've got that. Then we have the photograph that Sarah takes. Maybe it's because she's trying to take a video and she's too drunk. She's got the photo app and took a picture. But whatever it is, that is that's the trophy moment. That's her, I've got you in the suitcase and now you're under my control. And she's claiming she doesn't even remember that, which is fine. Okay, you don't remember that. But then you remember, oh yeah, well, right after that second video, 10 minutes later, that's when he started getting angry. That's when I heard the tone change and super vicious and violent. So there's no way all these things can be true. There's no way that she doesn't remember taking the picture at 11:03 and doesn't remember taking the video, but remembers clearly the threats in between the video. He said he'd fucking end me. He said he'd fucking end me. Say it again. Fucking end me. For that to be so clear in between all of these foggy memories, and then it's like, oh, the boys are probably thinking about the night before when I got dragged down by my hair. Nope.
Inconsistent because she doesn't, there's no explanation for the picture. Her explanation at trial when I brought it up to her was, I just don't remember. I don't remember this period in time from the picture at 11:03 to when I was supposed to be coming down the stairs. There's a major glitch in her matrix. She shakes the suitcase. Please stop doing this to me. Please. And then his hand gets out. Now she's the point in time where she gets angry.
Angry again?
And doesn't do what the law requires after basically choking him with his coffin. Beats him into submission with the bat and turns it back over. For the first time ever at trial, she says, I'm going to fucking end you, is what he said. She never told that to even her doctors. We've heard the arguments why she didn't tell the truth to the police and all that. And there's a lot of truth into the argument that was made. There's a lot of truth. When the argument is made that she didn't understand self-defense, what that means, what it comes across as, she makes this story change as she learns about it. When we apply the jury instructions to her statement, all 6 of them apply against her.
All 6? That seems like a lot.
I'll belabor this since it was discussed earlier. But did the witness have an opportunity to see and know the things about which the witness testified? Even at trial, she admitted that she was intoxicated for the first time. She went back and forth with the police about whether or not she was intoxicated and her standard of drunkenness and whatnot, but she was so intoxicated that she still felt the effects of it at 1 p.m. the following day. The medical examiner told you that alcohol dissipates in the average person. Everybody's different. Tolerance, all sorts of things come into play. But on average, 0.015 grams per deciliter will dissipate every hour. So you can do the math. 0.015 times 14 puts her at 2.5 times the legal limit. For those reasons alone, you should not believe anything she told you. You should not believe anything she told the police. You should not believe anything she told the doctors. She was at 2.5 times the legal limit. She has a gap in her memory that's unexplained when I brought up the photograph at 11:03. You can't have it both ways. I don't remember 11:03 to 11:12, but I was upstairs in the shower hiding. Does the witness seem to have an accurate memory? Well, this ties into what we're talking about. But again, there's a glitch in the matrix, 11:03 to 11:12. Her memory is not accurate. By her own admission, I don't remember. She tells the police when they show her the video, I don't remember that happening. Was the witness honest and straightforward in answering the attorney's questions? I submit when we got off script, and by we I mean both, with both attorneys, she wasn't as honest and straightforward as when it was a very directed and smooth examination. I came out of the gate with something that was off script. Tell me about Pamela Erickson. Tell me about Christine. Tell me about Crystal. Because she's the one that said cheating to her meant pornography. Well, ladies and gentlemen, you know, she knew exactly who those people were, and that she believed that he was cheating on them with her. And apparently she is too, with some guy named Ben. That when I describe this as a violent, nonsensical relationship, that's exactly what it is. It's not to downplay the violence. She got stabbed. She had minor surgery. It got infected. Those injuries are real. But they just don't apply in this case. They just don't apply when you use that self-defense instruction when she's the aggressor, if it's to be believed.
Judge, I object.
Ooh.
Approach.
Judge, I object. Approach. That means I have work to do. I thought I was done. Okay, no, that's right. I even queued up the transcript. I knew that there was more. Catch up read. Basis of your rejection? They don't apply in this case. We had 2 witnesses that testified that she's a battered spouse, his own ex, but he's arguing the law was just placed up there and specifically. It was before that. He was talking about the injuries. No. The statement right now was as to the self-defense not being applicable due to his argument of her being the initial aggressor. And that's what the jury instruction. He was saying that the injuries did not apply to this case. That is not what he just said. That's what I heard. Judge, he was talking about the interview. He talked about the violence and the prior violence. And it doesn't apply to the self-defense jury instruction. It doesn't apply to the case is what he said. That's correct under the law, said Mr. J. Mr. O. To this case, battered spouse applies to this case. For him to say that, his own expert said that she suffered from battered spouse. I'm going to defer to the jury instruction that Mr. J was just making reference to, which he outlined, and it identified. If you're the aggressor, and this is the analysis you have to go through, unless I've misstated the law, that's what's identified in the jury instruction. So I don't find that I'm taking your argument as improper argument or improper statement of law, and that's just not what I heard, not what I saw. Mr. J says, Mr. Owens, he just got through talking about the violence that he claimed was nonsense. Just got through talking about the stab, that it was a minor surgery. And it got infected, right, all of those things. But all that is not part of the case. That's not what he said. He didn't say it was part of the case. That's not what he said. Can we have it back? He just said it was not part of the case. Mr. J says, Judge. Court says, yes. Mr. J says, could you make a ruling? Court says, the objection is overruled. Mr. J says, thank you. The court says, thank you. Mr. Owens says, Judge, can I ask about time? Because he was trying to restrict my time. He said I've been rambling.
Objection's overruled.
He said I've been rambling for an hour and a half, however long it was. How long have they been? Approximately 15, 16 minutes. Oh, all right. Was there total time? I think so. Mr. Catatouri's was about an hour and 20, and you were... I'm wrapping it up, Mr. J interjects. The court says, a little shy of 2 hours. Objection is overruled. So Owens is complaining about time, and right now he's about 20 minutes over on time compared to Mr. J, who is wrapping it up, as you can see by my countdown timer. Let me say it loud and clear, battered spouse syndrome does not have any effect on this case. It has no relationship because she is the aggressor.
Let me say it loud and clear. Battered spouse syndrome does not have any effect on this case. It has no relationship to this case because she is the aggressor. She zipped him shut in the suitcase. After he said, I couldn't breathe, she wouldn't let him out.
She zipped him in a suitcase.
Therefore, all of the instructions above that paragraph of however do not apply. They do not apply.
And just skip reading it. You don't
Now,
have
turning
to.
back to what I was saying. Did the witness have some interest in how the case would be decided? Well, of course. 3 out of 4 panels that y'all came from indicated to the judge fear of punishment was more important than the fear of public speaking. It speaks for itself. She has an interest in the outcome of the case. Now let's talk about, does her testimony agree with the other evidence in the case? You do not have to accept this story. Let's pretend, as you should, because all 6 of these things, we haven't even gotten to the inconsistent statements. Let's pretend her testimony doesn't exist, and you just have to look at the circumstances. The testimony from the defendant.
Here we go. Here we go.
George Torres' head is here. You can stand if you need. You've been sitting a long time too. His head is here. His butt is kind of down here. His feet are here. And his hands and his knees are up here. He's in the fetal position, if we remember right. The hematoma on his head is on the left side. The bruises, the deep bruises on his back, are on his left side. You hear that? That's solid. You don't have to accept that she put those marks on him when he was in there.
Just a old beat up canvas suitcase.
Is on the left side. The bruises, the deep bruises on his back, are on his left side. You hear that? That's solid. You don't have to accept that she put those marks on him when he was in there. The evidence doesn't support it. You can conclude she used this bat when he was outside the suitcase. You don't have to believe her when she said they were playing hide and seek. You don't have to believe her because she doesn't know the rules. She came downstairs, saw what she had done, and had all the opportunity in the world to clean up whatever mess may have been at the bottom of the stairs. But ladies and gentlemen, physics doesn't lie. She can't expect you to believe her testimony about the loud boom being the day before compared to her 2 neighbors who weren't drinking, who have no interest in the outcome of the case, who suffer from none of the infirmities of her testimony. She suffers from all 6 infirmities. When her neighbors say there was a loud boom that night, there was a loud boom that night. Did it shake the wall they shared in common? It shook the wall that they shared in common. Did she have any injuries consistent with being dragged up and down the stairs the night before? No. You saw the pictures the CSI took. You don't have to accept her story about hide and seek. Something made that loud boom. It takes energy to make a loud boom. Energy that could very well be in the form of somebody going down some of the stairs, all the stairs, in the suitcase, out of the suitcase. But that's what the evidence supports, is there was a loud boom that shook the walls and interrupted a FaceTime conversation that was so loud that the girlfriend on the other end heard it. Something loud happened. And then there was silence, according to the witnesses. And they can argue that Juan Torres' testimony was great for them. it's great for the state. She was screaming at him already at 7:30 p.m. She was already on her bully pulpit. And we know she doesn't need to put him into the coffin to get on her bully pulpit. There's video after video of her on her bully pulpit telling him how it's gonna be, how you're gonna live your life. Go take a walk, do this, do that. You don't have to accept anything she said. It's inconsistent that he received the hematoma to his head, his bloody mouth. How is his mouth getting bloodied inside the suitcase? That's protected from her and her bat. But that suitcase, a 100-pound drunk woman is not beating through the wood of that suitcase or whatever it is that's making that noise when it's thumped. Ladies and gentlemen, those injuries happened outside of the suitcase. Ladies and gentlemen, somebody or something went down those stairs. She has no injuries consistent with going down the stairs. He does. He has blunt force trauma all over him. You don't have to buy her story, and you shouldn't. The inconsistencies, I'm not going to belabor it. Your dinner is waiting him back. Let's just briefly talk about the experts, and we'll move on to the end. Dr. Brandon was absolutely fantastic. He explained everything that you all needed to know about battered spouse syndrome. And this isn't about whether one of them or both of them had battered spouse, because at the end of the day, she's the initial aggressor, and she had the duty to do the things that the law requires. But it does call into question the credibility of the past power dynamics of their relationship. Those videos speak for themselves. The officer in the last video asks him, dude, you're a guy, why don't you do something about this woman, your wifey, who you don't want to rat on for beating you? It's like, man, I'm not a beefcake. I'm not going to rat her out.
Exactly. There we go.
There's countless examples.
That's it. George didn't feel comfortable. It's one thing if you're 6'2" and over 200 pounds and you're telling, a Sarah, hey, I'm leaving, get the fuck off me. You don't need to worry about her coming at you and it being a fight to the death with somebody who's essentially your own size.
Apply Dr. Brandon's testimony to Juan Torres that really shows you the power dynamics of the relationship. He was her violent pet. Dr. Harper, I don't find much quarrel with what she says about battered spouse syndrome, and nobody should.
No, I think her testimony on battered spouse syndrome, as much as she gets, I think rightfully so, negative attention in the Sarah Boone community, it's because of her testimony about Sarah, not her knowledge of the syndrome. She came off as quite knowledgeable, knew the facts well, just not a very, believable witness. Didn't feel unbiased, that's for sure, not objective.
She's the expert, but she's not Miss Boone's treating physician. She's not her treating psychologist. The way it was described in argument, and I believe from Dr. Brandon's testimony, was she's supposed to be a forensic detective. Get to the bottom of this. She's going to come in here at trial and tell you her opinion you should rely upon. With 9 visits, she never asked the defendant what it is the victim said that put you in imminent fear of death or great bodily harm. That's the crux of the matter, Doc. You're never going to ask her what it is he said or did for this grand jury instruction about threat of force or use of force? It's remarkable. And, she didn't review everything that was presented to you. At the end of the day, it's your opinion that matters about this relationship. And again, we agree with Dr. Werner. It doesn't matter. She had the duty to retreat. She had the duty to take the chokehold off. And if it was too dangerous for her to directly take the chokehold off, she had the duty to do something else, everything in her power, to stop him from dying because she started it. She set it in motion. She used the force grip on him from a distance, the couch and from bed. It was her obligation to stop. She didn't. But Dr. Werner, she was called by the state of Florida after having evaluated and listened to the defendant give a similar story and concluded battered spouse doesn't apply. So she was never asked to delve any deeper into it. Given the information that she did have, the limited information, she agrees, yes, Miss Boone has battered spouse syndrome, but it doesn't apply to the case because she was the aggressor and she did not fulfill her obligations. And really just your gut common sense. Go back to jury selection. In jury selection, there was examples about bullies day after day doing something to somebody. And somebody raised their hand and said, don't they have to do something that day? Don't they have to do something that day? And he didn't. After he was put in fear of death and told her he can't breathe, the imminent threat of great bodily harm and death she is describing to you is him fighting for his life to escape. She did not fulfill her obligations. There's details that matter. And again, it's not to belabor it. I mean, the evidence in the body-worn camera and the 911 calls, it's not offered to prove the truth of the matter of as who stated what. Who knows what happened between these two? You see them with the police. Can't believe anything they're saying. It's not offered to prove that she's a bad person. It's not offered to prove that Mr. Torres is a bad person. It's simply offered to call in question the reliability and credibility of what she said about the past. That's all that it's there for. But there are some nuggets and some Easter eggs. There was an argument made during closings that Mr. Torres knows not to do anything when being videotaped. Bizarrely, shortly thereafter, they showed a very edited clip of him attacking her and slapping the phone out of her hand. He knows he was being videotaped, and there was another video like it too. So to make the argument that he doesn't do anything, he's a good boy when he's being videotaped, it's belied by their own argument. They showed one of the videos. Learned helplessness. She seemed to control everything. I mean, his birth certificate, it gets torn up when he doesn't comply with her wishes. You'll see the rest of the text messages if you choose to delve into them. But I would suggest you don't have to, given the jury instruction about aggressor. Ladies and gentlemen, this has been a long 2 weeks, and you are making a very, very important decision for Ms. Boone, and a very, very important decision for Mr. Torres and the state of Florida and his family. He's dead. She killed him. She's admitting she killed him to have this affirmative defense of I was justified. It was not justified under our law. She does not get to decide that she has a license to kill because of her past grievances. The law requires her to stop using the force that she started applying to him. And she didn't. She didn't withdraw. She didn't tell him he was withdrawing. She didn't use every means available to try and stop this from happening. She didn't. And you know what was in her heart. She tells you it's hatred, ill will, spite, and venom. This is not a self-defense case under the law. Go back and follow the law. You cannot feel sorry for her. You cannot feel sorry for him. You cannot feel angry at her. You cannot feel angry at him. It's maddening to see their relationship. It is maddening. Nobody would want this life for yourselves or your children. It is violent nonsense, but it does not affect what she did and what her duties were under the law that night. She wanted to punish him, she did, and then she left him there. And she had an obligation, if you even believe her story about the imminent threat for him fighting for his life, she had an obligation to do something about it and not just go upstairs and let him suffocate. Thank you.
All right.
Thank
That
you
is
both.
that.
Members of the jury have some additional instructions to read to you.
We will
If you would be so
start
kind to
the
turn to
next
page
stream
21 of
with
22.
that. But we will not have that for this stream. We will leave. Well, let me just get
Instruction 3.12.
There we go. Get Mr. Kranick, Judge Kranick looking up. But then we'll throw on a little closing music. We will no. Go with the show that we closed the morning show with. No. Let's party. That was fun. You had fun. I had fun. We had a good time. We might even ramble tonight. Speaking of the ramble, before I start the music, which will probably be loud, K to Z, KTZ, and you spell out Z with a Z-E-D. They're a channel that was friends with Cowboy Criminology, and they're doing a live stream. I think it started about a half hour ago. Check them out. They do some body cam footage, some stuff that you guys might be interested in. It's not Sarah specific, but they're fun people. And if I do the ramble tonight, the reason I bring them up is they did a reaction to Chelsea and Haley. Those were the drunk sisters in the back of the car. Pretty hilarious body cam footage. I wanted an excuse to watch it again. I really didn't have much to add as far as commentary, but I was watching them. Well, I was watching a stream where they reacted to it earlier in the stream. I missed the part where they reacted to them, but I thought it would be fun for me to react to them reacting to the Chelsea video for the first time. So that might be the stream tonight. I think tonight I'm just going to do reacting to random and not so random live streams. The not so random one will be K to Z to get us started. And then another not so random one might be the failed stream that Cowboy Criminology and I did together that just failed. I haven't even watched it. I know that it half-assed broadcast. A lot of you were there. Barry Adams gave out 50 memberships to Dan D True Crime during that stream. But it was a debacle. It was a nightmare. So it'll be kind of fun to revisit from that point of view. So I think those will be the first two. And then I'm just going to surf around, see who's going live. I'll check it out on my phone first. I don't want to accidentally stream anything, too extreme. But we'll spend 5 minutes on people's streams. If they're fun, then we can take note of the channel and you guys can visit there again. You can shout out channels in the chat. If you guys know people who are streaming, we'll just make it a community fun night. And minimum, it'll start about 4 hours from now. So whatever time it is where you are, the earliest I'll get started again is 4 hours from now. Let's get a little music. We'll get set for a goodbye, and I will see you in not too long.
Switch me on and hang on tight. I'm party coded, activated for the night. I'm party coded, wave your hands in flashing lights. I'm party coded, gotta jump if you feel alright. Right now is our only moment. Free ourselves and unplug now. Move your body and shut your mouth. Not so hard if you work it out.
Happy birthday to all the Leos out there. Good to see you, April E. Rose. Hairball yarn.
I'm party coded, liberated, and uncontrolled. I'm party coded, color popped, and ready to go. I'm party coded with that white chicken set too low. I'm party coded, let me hear you scream. No more talking, just these motions. Feel the beat, you got permission. Move your body and shut your mouth. Not so hard if you work it out. Feel it go. Lose control. Simulation override. I will make my own good time. Simulation override. HTML customized. Simulation override. Intercepted, televised. Simulation override. Circumstances modified. Move your body and shut your mouth. Not so hard if you work it out. Feel it go.
Oh, now I'll see if I can find that link.
Lose control. Move your body and shut your mouth. Not so hard if you work it out. Feel it go. Lose control. Lose control.
No, I don't have it. All right, it's time to go. Enjoy your evenings. I hope you all have a fine and dandy Friday.